Good afternoon, everyone. Today is February 18, 2022. Welcome to the House Judiciary bill hearings. I have a very corny joke that I have to make, and that is, we welcome the judiciary to the Judiciary Committee.
That was actually funny.
Oh, good, thanks. So our first bill is, we're going to hear 4 bills that are brought to us by the judiciary. We're going to start with House Bill 428, please. And we have our Chief Justice Bader, and you are on your own on this one. Whenever you're ready, thank you very much, Your Honor.
Thank you very much. It's a pleasure to be here. The Judiciary is happy to be welcomed to Judiciary Committee. Madam Chair, members of the committee, House Bill 428 would allow judges to sit in senior status if they had won at least one election in the past. This really relates to circuit court judges, which, as you know, is the only level of the judiciary that participates in contested judicial elections. Currently, the law prohibits judges from sitting in senior status for any of several different reasons. One of those is that the most recent term of service ended as a result of a loss of an election. As you're aware, only one level of the Maryland judiciary is subject to contested judicial elections, and that is circuit courts. An appointed circuit court judge must run in the general election that is at least 1 year following the vacancy that judge filled. So at the time of an election, a circuit court judge will have served no more than 3 years in office, and usually 2 in their first election. The winner of that election receives a 15-year term in office. So at the end of that 15-year term, judges will have on average served about 16 years in office, 15 of which followed an election win. It has come to my attention in recent years that several circuit court judges have decided not to run for re-election at the end of that 15-year term out of a concern that if they lost, they would be ineligible to sit in senior status. The ability to sit in senior status is very important to the judiciary and to the individual judges. To the judiciary, senior judges are critical. They're a critical resource that we rely on to keep our courts functioning. Our senior judges are among the most experienced judges who sit, with experience built up over years that is very valuable to us. To the judges, sitting in senior status gives them an ongoing opportunity to contribute as a dedicated public servant, which they all are. It also gives them the opportunity to earn money to fill the gap between what their pension provides and what a sitting circuit court judge makes. But I will note that there are a number of senior judges who continue to sit and sit for free after they have reached that threshold. So the ability to sit in senior status is important to the judiciary and the individual judges, and the prospect of losing that ability for the rest of their lives has become a consideration dissuading good circuit court judges from running for re-election. That gives rise to a couple of concerns. The first is that when they step back rather than running for re-election, the judiciary loses the benefit of their active service, which again is the service of, on average, the most experienced judges across the judiciary. They can sit in senior status, of course, but on average that means they sit for about 1/3 of the time of an active judge, and they lose access to the dedicated staff that helps them be most productive in their position. The second concern is that I am not aware of a contested judicial election in which the sitting judge lost since I joined the bench, where an issue in the election has been the competence, ethics, or temperament of the sitting judge. In other words, the reasons judges sometimes lose are not reasons that should inhibit their ability to serve in senior status. From that perspective, I'm not sure what positive purpose a prohibition on sitting in senior status accomplishes. What it does is incentivize people who have a lot left to offer to step back early from active service. If this change is made, it would still prohibit a judge who loses in their first attempt at an election from sitting in senior service. The same considerations I've been discussing do not apply to a judge in that position. So I appreciate your consideration of House Bill 428, and I'm happy to answer any questions.
Thank you. Are there any questions, members? I see one, Delegate Phillips.
Judge, thank you for coming, and thank you for all that you all do for our state. How often has that happened, though, that someone actually lost their election and was not able to sit as a sitting judge?
So I think actually most people in that position, if there is going to be a contested election, don't run. That's what I'm talking about. It dissuades them from running. So it happens that sitting judges lose in their first attempt, but it has been quite some time since one has lost. for reelection, when they come up for reelection, but I tell you that I think the reason is when that's going to happen, they step back. And that's what this change would prevent from happening. They'd be able to decide whether to step back or not on the merits of that decision, rather than out of concern that they would lose their eligibility to sit in senior status.
Okay, all right, thank you.
Thank you. Delegate Valentine.
Thank you, Madam Chair, and thank you, Your Honor, for being here today. Will this only impact moving forward, or are you seeking to assist anyone who this may have impacted previously?
No, I'm not aware of anybody who would be in that position because they have stepped back.
Of the reasons you've just outlined.
Yes.
My second question is, when you're referring to senior status, I just want to make sure, this is how we would term like retired judges, is that correct?
Yes, when you're
referring to them as senior status, judges who have retired and come back to sit on the bench.
Exactly.
Thank you.
So those are all judges. Once they retire, there's a certification process. They're eligible to come back and sit in what we call senior status if they have been approved by the administrative judge of the court in which they would sit, if my court votes to certify them, and then if I designates them. So there's actually 3 hoops they need to jump through, if you will, before being eligible.
Thank you for clarifying that. Thank you, Madam Chair.
Thank you. The Vice Chair.
Thank you. How long can a judge sit in senior status?
There is no specific limit. They still have to be approved by the administrative judge. They come up for recertification every 3 years for my court. So my court will review their application, get input from the administrative judges where they've been sitting, and then decide whether to recertify them every 3 years.
Thank you.
Thank you. Members, do we have Delegate Woods?
Thank you, Madam Chair. Thank you so much, Judge Fader. My question is just clarification. Can you specify more what that temporary assignment looks like?
So they can be assigned to do any work that an active judge can do. So they often come in and fill dockets when active judges are out on vacation. If a court is particularly busy, they can call senior judges in and they can preside over trials. They can preside over judicial review actions. Really, they can be assigned to do anything that the administrative judge could assign to an active judge.
Madam Chairman, thank you. Thank you so much. And is there any expiration time frame for that temporary assignment?
The expiration is only the need to get recertified every 3 years by my court. So they are certified to sit for a 3-year period of time. And then when that is coming up to be due, they have to reapply. But other than that, there's no deadline.
Thank you so much. Thank you, Madam Chair.
Thank you. Members, any further questions? Delegate Boucher.
Thank you, Madam Chair. And thank you, Chief Justice, for being here. Can you explain the importance of these senior judges for us as public officials needing someone who's outside of our jurisdiction if we're in legal issues?
The importance of the senior judges?
Yes.
So we rely on senior judges to operate our dockets efficiently. The courthouses all across the state bring in senior judges to fill the gaps in what they're able to fill in order to make sure that courts run on time, that decisions are timely, that we can hear cases on a timely basis to the extent we can. And senior judges, importantly, are able to sit in multiple jurisdictions. So when they take senior status, they can't, it's not that they're limited only to coming back in the court in which they originally sat. So we have, for example, a need for extra services on the Eastern Shore, and we have a number of judges who served in Central Maryland who routinely will go out on to the Eastern Shore when there's a need, especially in some of those courthouses that have only one judge, and be able to be there to provide backup. So those judges need to go on leave or handle other cases. If a judge in a one-judge jurisdiction, for example, has a 5-week trial, then they need somebody to call on in order to do other work in that court during that time, and the senior judges are available for that.
If I may, how about the fact that we as public officials cannot have a judge within our jurisdiction preside over us?
So senior judges can also help come into that jurisdiction when there's a recusal issue problem, and so the senior judges are very valuable for that as well. Thank you.
Thank you very much.
Delegate McComas.
Thank you, Madam Chair. Judge, just a real quick question. Isn't the retirement age 70?
Yes.
Okay. So basically, these senior judges would be working beyond 70. Is that correct?
Yes.
Okay. And so every 3 years, you would then say, okay, you're 72 or 3, okay, you can be re-upped because we think you're okay. But do you get a medical diagnosis, well, like a medical test or something so that they're sharp?
We don't get a medical test, but what we get, we solicit feedback from the administrative judges of the courts in which they've operated, and we rely on them to provide an assessment of what the capabilities of the judge are.
Okay. What happens, I know that the law keeps moving on, and it's constantly changing. And I guess my concern is that if you have a judge that let's say they don't particularly like domestic cases and they're put on a domestic case and they kind of remember the old law and they don't understand the nuances of the new law and all the changes that have been made in domestic cases, would they be assigned to a domestic case, or would they be assigned for maybe some, like conferences, settlement conferences, that kind of thing, as opposed to a full domestic case?
So a couple of different points on that. One is that the administrative judges make the assignments specifically, so they wouldn't assign somebody who wouldn't be capable of doing that. That's the primary check there. But we also have continuing judicial education requirements that apply to all of our judges, including our senior judges. So our senior judges do have to take continuing education credits, most of which are provided by our judicial college, and that's an important way that they keep up with the law.
Thank you, Madam Chair. Your Honor, how often are judges not certified, not recertified?
We have put in a process now where all of the judges, whenever they first get certified, can be any time during the year, but we have an annual certification where everybody else, we do it all at the same time every year. And each time we do that, there are judges who are not recertified.
So there are instances where judges aren't recertified?
Yes.
And lastly, you mentioned that your court has a procedure for the every 3 years certification. What about the other courts?
My court is the one that does all the certifications.
Is it the same in the circuit court and the district court?
Yes, in that my court is the one that certifies senior judges at every level. No other court certifies them. So we certify them, and that allows them to sit in those other courts.
Let me rephrase my question. So currently in your court, a judge can sit for 3 years, right? And then they get recertified.
Yes.
Is that the same in district court? Is that the same in circuit court?
Yes, it is the identical process at each level.
Okay.
But what I was trying to clarify is that if you're a district court judge and you're trying to seek certification, you apply to my court for that certification, and then we would certify to be able to sit in the district court.
All right, thank you.
Yes.
Thank you. Members, any further questions? Seeing none, that concludes our testimony and bill hearing for House Bill 428. We're going to move on to House Bill 492, and the Chief Justice will preside over that one as well. Thank you so much for your testimony. We'll also have Chief Judge Morrissey, Judge Wilson, and Melinda Gallier. Okay, Mr. Chief Justice, whenever you're ready.
Okay, thank you, Madam Chair, Madam Vice Chair, members of the committee. Thank you for allowing me to be here to testify on House Bill 492. I want to open by expressing my sincere appreciation for your support 2 years ago for the Judge Andrew F. Wilkinson Judicial Security Act. That act made a big difference here in Maryland and beyond, actually. Those protections have been and remain of great importance. One component of the Wilkinson bill brings us back here today. The law created a task force to study the safety of judicial facilities. The task force's challenge was to address 3 different areas to identify minimum acceptable security standards in those areas. As relevant to the bill that we're here for today, one of those areas was security personnel in courtrooms. This is an issue of critical safety, not just for judges, but for every person who enters a judicial facility. Shortly after Judge Wilkinson's assassination, I was looking for information to provide my judges around the state about their personal safety. one of the first things I was given was a pamphlet from the National Center for State Courts on safety of judicial officers. The first page of real substance is page 2 of the pamphlet, titled "In the Courtroom." And the first bullet point on that page is, do not conduct court sessions or hearings in the courtroom in absence of court security officers. That is information provided nationally to judges by the National Center for State Courts. That is, in fact, the correct standard. But if we were to follow that in Maryland right now, we would have a lot of dark courtrooms that could not proceed. Across the circuit courts, especially in several of our largest jurisdictions, there are many courtrooms in family and other civil cases without security personnel present when those proceedings are going on. And that's really important because family law cases, in particular, are among the highest conflict cases that we see and among the cases that give rise to the most threats and misconduct. In fact, it was a family law case that led to Judge Wilkinson's assassination. The task force identified a minimum acceptable standard for security personnel in the courtroom of having at least one qualified courtroom security officer in every courtroom and a second officer in every proceeding involving an incarcerated individual or one who may be incarcerated as a result of the proceeding. There should also be an additional person for every 4 or fewer courtrooms on a floor of a courthouse in case extra help is needed. We came to you last year with a bill that would have put that standard into law. What was ultimately passed was a very sensible reporting requirement for entities providing security in courthouses across the state to identify whether they were meeting the standard, how far they were from meeting the standard, what they would need to get there, and what obstacles were in their way. The results showed that several jurisdictions were far from meeting that standard and that there are several obstacles in the way. One, of course, is funding, which comes from local jurisdictions for all of the circuit courts across the state. A second problem is the difficulty in recruiting law enforcement, which is a nationwide problem right now. Many of the sheriff's offices that provide security have open pins right now, pins that they can't fill for these positions. 3 have more than a dozen open pins for providing courthouse security. We're working on multiple paths to address that, one of which is funding for a grant program that is included in our budget this year to help make money available to local jurisdictions to help them make progress in meeting this standard and providing courthouse security. To fully implement the standard would require additional officers, even beyond those that are currently unfilled vacant positions. This bill would identify the minimum security standard in law so that everyone knows what that minimum target is. Unlike last year, this bill would not establish that as a mandate. This would require jurisdictions to make reasonable best efforts to meet that standard. So it is not an unfunded mandate, but is still an important target that everyone should be striving to meet. I want to end my remarks by expressing deep appreciation for the sheriffs and sheriff's deputies who provide security in circuit courthouses across the state, as well as to the bailiffs who provide security in the district court courthouses and the special police officers who provide security in our appellate courts and administrative buildings and keep everybody who enters those buildings safe. They do great work, often with strained resources, and we appreciate the critical efforts that they make to keep everyone safe. I'm also grateful to the work of all members of the task force in trying to improve security. And I look forward to your questions and thank you for your consideration. And I will turn it over now to Judge Wilson.
All right. Thank you.
Thank you, Chief Justice. Thank you, Madam Chair, Madam Vice Chair, honored members. After Judge Wilkinson's murder, I was honored by the Chief Justice to chair the Judicial Security Task Force that he mentioned. Two of our primary goals, of course, one were to assess the security and the facilities across the state. The second was to establish a best practices from doing a national search to determine what, if any, security improvements could be made, or at least to, as this bill shows, make aspirational. We searched, of course, the National Center for State Courts, LEOSA, the National Sheriff's Association, and focused largely on the state of Georgia. We did so because after the 2005 tragedy at a circuit court in Atlanta, where an inmate who was preparing for trial had one deputy guarding him as he was changing into his courtroom clothes. He overwhelmed that guard. He stole her gun. He pistol whipped her into a coma. He then entered the back of the courtroom through the back hallway unsecured door, proceeded to shoot and kill the transcriptionist, the judge, and a sergeant on his way to exiting the courthouse, further killing a federal agent before he was finally apprehended. As a result of that tragedy and in a show of true proaction, Georgia modernized courtroom security by entering or creating an entire code that specifically set out all of the security aspirations that should be met, from building design to personnel to courtroom processes, to ensure that in Georgia they would have as good a chance as any to prevent anything like that from ever happening again. In Maryland, more recently, just over the last year, we have seen also the need for courtroom security, unfortunately, too often. In Baltimore City last summer, there was a melee in a circuit court when a victim's family decided or became enraged and attacked the defendant who was on trial. Security forces were able to bring that bring it to a safe resolution, but only because of the fast actions of the sheriffs that were there. Baltimore County has also seen a similar altercation more recently, and of course in Baltimore County District Court, the tragic suicide that happened at the entranceway, and again, court security there helped prevent a greater tragedy. In Washington County, we have also seen the need for security in two recent bomb threats in September of last year and February earlier this month. This month in particular, we had 157 jurors that were there to begin a murder trial that was set for the entire week. The bomb threat was serious. It specifically targeted a judge, and because of that, we had to evacuate on both occasions. Without adequate court personnel, the people that are in the courthouse, in the individual courtrooms, could not have been evacuated safely, would have been prone to potential panic, and could have led to injuries not caused by a bomb, they were only threats, but caused by the panic that ensued trying to leave the courthouse. So we do support this bill. I do ask that you consider it. It is vitally important that we have adequate court personnel for security purposes in every courthouse.
Thank you, Madam Chair, Madam Vice Chair, members of the committee. For the record, my name is John Morrissey, and I'm Chief Judge of the District Court. The District Court's a statewide court system. As you all have heard me say before, it's operating under a single administrative structure. This allows us to implement uniform security standards across all locations. Our bailiffs are contractual employees of the District Court, hired and supervised directly by the Judiciary. This model allows us to maintain higher standards and adapt staffing quickly. However, we also face the same challenges as the circuit court and appellate courts related to recruitment and retention of our security staff. We strive to remain a great place to work by offering competitive salary and benefits, but rising security threats make this work even more difficult. But we continue to be committed to ensuring our courthouses, entrance hallways, and courtrooms remain safe for judges, staff, and the over 2.4 million members of the public that visit the 33 courthouses that comprise the District Court. Last year, the bailiffs of the District Court, as you've heard, to whom I owe much appreciation, confiscated over 60 firearms, over 8,500 knives or razors, over 4,000 chemical sprays, and more than 2,000 tools. Our own District Court security team at headquarters investigated nearly 70 threats. The majority were against judicial officers, some of which began inside courtrooms or as the direct result of judicial decisions. A quick example of some of the actual cases may highlight our concerns. On December 10th at the Wacomico District Court, an individual attempted to bring a Ruger 9mm semi-automatic handgun, which she left in her purse that passed through the X-ray conveyor. She did not have a carry permit. On November 5th at the Catonsville Courthouse, a bailiff noticed a small pistol in the bag that went through the X-ray screening machine. The individual was entering the courthouse to meet with juvenile services. On March 10th at the Baltimore City District Court building, an individual placed her coat on the X-ray belt, and a bailiff discovered a loaded 9mm handgun with a round in the chamber and 2 rounds in the magazine. The individual did not have a carry permit and stated she forgot that she had a loaded handgun in her coat. In addition, in the last year, our judicial threat management for the overall judiciary, not just the District Court, has tracked over 200 threat incidents with threats to judiciary personnel occurring in every one of the districts in the District Court of Maryland. I urge this committee that we cannot leave safety to chance and simply hope that trained armed security will be in the right place at the right time. We need full staffing in all of our courthouses. and courtrooms so that we can secure them, not just for the judges and the clerks and the personnel on the court side, but for all those visitors that come to our courthouse. I urge a favorable report of this committee, and thank you. And Madam Chair, if I may, I have some handouts. As a good former trial attorney, I have some show and tell that I'd like to hand out and publish, if that's okay.
Actually, Your Honor, what we would prefer is if you would leave them, and then we will get them, we will pass them out to the members.
Sounds great. Thank you very
so
much, Madam Chair.
Thank you. Ms. Gallier?
So my name is Marisa Trissetti, and I am the president of the Maryland State Bar Association. I think Ms. Gallier signed me up. Good afternoon, Chair Bartlett, Vice Chair Davis, and members of the committee. I'm here as the president of Maryland State Bar Association, the largest organization of legal professionals, 17,000 strong currently, in the state, representing attorneys from all practice areas. Through our advocacy, we seek to protect the legal profession, preserve the integrity of our judicial system, and ensure access to justice for all Marylanders. Court security and access remains a core priority for my organization. Justice depends on everyone's safety. Judges and attorneys must be able to decide and present cases without concerns for their welfare or for their family. Litigants must be able to come to the court and seek justice without fear. These threats are very real in Maryland and across the country. A 2024 survey of state judges found that over 82% worry about their safety, and over 56% have been personally threatened. We can do better. We must do better. Nationally, the U.S. Marshals Service reported 176 threats the first month of 2026 alone, showing an escalating trend of violence on our judiciary. For our members, the courtroom is their office. They deserve a safe workplace. They should not have to navigate threats and violence in courtrooms or fear walking in and out of parking lots as part of their professional lives. Our members cannot opt out or choose not to appear in court. They have taken an oath and have a duty to represent their clients in high conflict situations oftentimes, making standardized security a necessity. I thank MSBA past President Rafael Santini for all that he did in 2024, representing MSBA on the legislatively creative task force from SB 575. Where he shared his perspectives of our members about security deficiencies and the needs of courthouses across the state. The recommendations from the task force have helped with broader security solutions, including data privacy, physical upgrades to courthouses, and additional security provisions within each courtroom. Last year, we came to you to advocate for minimum courtroom security standards.
Thank you, Ms. Trissetti. I'm sorry, but that sound was actually indication that your time limit had passed.
Okay.
So there probably will be questions. And if you want to just finish that sentence that you were just on, I hate to interrupt you in the middle of it.
Certainly. We urge the committee to continue its commitment to court safety and respectfully request a favorable report on HB 492.
Great. Thank you very much. And you have several members of our committee who are members of MSBA. So I have been given a note to make a special announcement to Chief Judge Morrissey. We have a 3L here from University of Maryland Francis King Carey School, who is a DeMatha alum and a Bowie native, and his name is Blaze. Blaze, would you stand up?
Thank you, Madam Chair. I'm a proud alumnus of DeMatha Catholic High School in Hinesville.
That's right. And we never miss an opportunity to embarrass folks as much as we can. Okay, so members, do we have any questions? Delegate Moreno.
Thank you, Madam Chair. Thank you, your honors and panelists. From any of your perspectives, how far are most Maryland courthouses today from the staffing levels required by this bill? Or are we talking about a modest adjustment to formalize what's already happening, or is it a step up in most jurisdiction, or does it vary across the state?
I think it's fair to say that it varies across the state. There are some that are already meeting it. So we're really talking about the circuit courts here. The district courts, where security is provided and funded at the state level, are meeting this standard. Okay. In the circuit courts, it varies by jurisdiction. Some are already there. Others, and I mentioned that it's a particular problem in some of the largest jurisdictions. I mentioned that there are 3 where even right now there are more than a dozen vacancies from what they have funded in their budgets, and they would need some additional over and above what they have funded. But it varies across the state.
Okay, thank you.
Delegate Boucher?
Thank you, Madam Chair. I think this question might go towards Judge Wilson, since you chaired the commission. On the bill, line 1618, it talks about a court security officer must meet the qualifications for a special police officer as defined in Article 3-301 of the Public Safety Code. Can you explain that for the public and us? Would it be just deputy sheriffs?
Special police officer is a special designation within law enforcement. The qualification level does not rise to a full deputy, sworn deputy. It is still a significant amount of training. The reason being that the special police officer for a court security, the jurisdiction of that officer remains within the curtilage or the footprint of the judiciary building. So they could not then leave the building or the grounds and enforce the laws. But they can carry a weapon. They are trained in weapon. They're trained in how to arrest people. They can then hand the person off to the local law enforcement agency that would then complete the arrest.
If I may, would it actually save the jurisdictions money hiring these specific employees instead of a full-blown deputy sheriff?
It can.
All right, thank you.
Delegate Simmons?
Thank you, Madam Chair, and thank you all for coming out today. As a follow-up to my colleague, excuse me, when you're looking at the role of an SPO, are they currently in place throughout our state currently with some agencies?
Yes.
So I can speak for the district court. All of my bailiffs are special police officers. They have all at one point or another gone through training at the Maryland State Police Academy. They have to be recertified every year in firearms, and we actually have additional training on top of that. I have a director of security. There's over 300 bailiffs in the district court system, so we run them through kind of a mini academy ourselves every year.
Sure.
We have a trainer and things like that.
Absolutely. In addition to the sheriff's department that operate within the court's jurisdiction, do the sheriff's department do more than just protect the judicial inside the courts? Do their job extend outside the building?
So it is jurisdiction dependent. There are some jurisdictions in the state in which the sheriff's office is the primary law enforcement entity for that entire county. And so they do all the law enforcement in the county. There are other jurisdictions where they have law enforcement responsibilities that are shared or with police departments that might be local. And then there are some where really what they do is provide security in the courthouses, security at a local detention center, and provide service of process as well. So it really varies county by county.
Sure, Madam Chair, may I have the last? So when we talk about the safety of our judges and we talk about the safety of our courthouses, can you talk a little bit about that threat that's internal when it comes to people that are entering the courts, and what are we doing to safeguard our judges beyond the building?
So with respect to in the building, we do a lot to make sure that our courthouses are safe for everybody who is there. And the task force didn't only look at security personnel in the courtrooms. It looked broadly at security with respect to the facilities themselves, with respect to the policies and protocols. And right before the task force started meeting, we had a broad review of security at every single courthouse in the state. There were 282 points of contact that we looked at in order to identify that security. And so we do a lot and are continuing to review and reassess those findings to make sure that they are as safe as they can be for everybody who enters them. We have taken steps outside of the courthouses. One thing that we did in the wake of the murder of Judge Wilkinson is create a program to provide subsidies to encourage judges to have home security systems. That was something that Judge Wilkinson's widow was particularly interested in making sure happened. So we have a reimbursement program for those security services for judges, and we make sure that judges register with their local law enforcement agencies. So if there's a call from that judge's phone or cell phone, it's flagged as being a call from a judge, and they know that when they're approaching the situation, because that prevents a different kind of risk than other law enforcement activities. So those are some of the things we do.
Thank you.
Thank you. Members, do we have any other questions? I have just one quick question for Judge Wilson, and it goes in line with what Delegate Simmons was saying. So are we to anticipate perhaps another bill maybe next year with the recommendations that you mentioned with respect to court personnel throughout the courthouse? Or is this as far as we're going with respect to the recommendation?
I think part of that I'll certainly leave to the Chief Justice. One thing that dovetails with that, and also Delegate Simmons' question, is to remember that the circuit courts are county-owned and county paid for. They also date back anywhere from 200 years to 5 years. As you can imagine, the more historic buildings they were built without any security in mind. They were built in public squares. They were built in places where the public could access them, could see them. They were built for beauty instead of function, oftentimes, and they require more. My courthouse, Washington County Courthouse, the judges walk freely amongst the hallways with the public, the litigants, and everyone else on a regular basis, because that's the only way we can get from a chambers to a courtroom. So part of it would be design. The layout of the courthouse may require additional security. The layout may reduce the amount of security if it's built in a certain way. As to future bills, and again, this is where the Chief Justice would weigh in, but the goal here is to help our sheriffs in the circuit courts to develop what tools and what assets they need in order to fully secure their particular building and its needs.
I see.
And if I can address that further, there is no current plan to come back with a different bill next year. But this is a really important issue that we think we really need to come up with a solution where we have this security standard met. So we have, as I mentioned in the budget, we have $5.6 million that was put in our budget this year to be a grant program that local governments or sheriff's offices could come and say, we want to access some of that money as a grant program so that we can get ourselves in a position of being able to comply with this standard, whether that's updating recruitment and retention policies or practices, or a stipend in order to bring people on, or whatever it is. They can come, we thought it would be productive for them to be able to try to figure out what they would need in order to meet this standard. If these things don't work, then we would need to think about ways where we could get up to meeting that standard. And so I'm not going to say we won't come back with something else if this doesn't produce meaningful steps toward meeting that standard, but there is no current plan to do that.
I understand. Members, any further questions? Okay. Let me just personally, on behalf of all the committee members, just thank you all, and we always hope for your security. We hope for the best, and we still remain sorry for your loss with respect to your colleague, Judge Wilkinson.
Thank you. Thank you.
I'm going to call up our next panel. Favorable with amendment, Sheriff Coggin. And Sheriff, you will have 2 minutes, and whenever you're ready, you may begin.
Great, thank you. And thank you for letting me testify here today. I'm Sheriff Sam Cogan. I'm the Sheriff of Baltimore City, one of the larger jurisdictions. And I just want to agree with everything that was just said up here. I was also part of the task force and helped set the security standards that we're talking about. Our court security officers are special police and are meeting the standards in here. My only concern, and it's a major concern, is I would be doing already what they want me to do, the judges, right, if I had funding to do it. That's the only thing that's stopping me from doing this. And so I'm very concerned that this bill sets me up in conflict with my mayor, right? I've testified 3 times, that I need additional security to meet these standards in front of the city council and the mayor, and I just haven't gotten that, right? And so if you would pass a bill like this that doesn't require any kind of funding mechanism, that really puts it up between now it's the sheriff, right, who isn't providing the judges what they need, right, even though the sheriff isn't being funded by the local government to do the tasks that they need to do. So, I guess the amendment would be either a funding mechanism, or if we're not funded to do it, then we don't, you can't hold me responsible for setting a standard that I can't possibly meet, right, because I'm not funded to provide those positions. I have very transparently in my courthouse, down to the manpower hour, know exactly to the hour what it costs to run my court security program. And in Baltimore City, I'm just going to use the city's fiscal note. It's $4 million underfunded to do what I would need to do to run the court security the way it is. And I just want everyone to understand that sheriffs also have to do domestic violence. They have to do warrants. They have to serve the process. They have to do a host of other things related to the judiciary and enforcement of judiciary beyond court security. And I'm very concerned that this standard would mean that I would have to move the entire sheriff's office into a court security role, which then would be highly problematic to do other things. So again, I agree with everything that's being said here. We need to do everything that they're asking, and court security is incredibly important. I'm just very, very concerned that this bill sets me up in conflict with my mayor.
Understood. Thank you. Members, any questions? Delegate Simmons.
Thank you, Madam Chair, and thank you, Sheriff, for coming out. Can you tell me how many of your sheriff deputies actually currently work inside the court system or are placed inside of a courtroom?
Sure. So we have a court security line item that specifies how many positions we have for court security. And in there, I believe we have 30-some deputies that are, or court security officers that are assigned to the judiciary.
Okay, how many is needed?
40, right?
40 is needed?
Right, and like I just give you an example, right? Our court security line item is about $5 million, and just one door to run it 24/7 to keep the courthouse open, because we need to, is almost $900,000, right? So we're talking about everything we need. So I have deputies that are supposed to be in line items to be on domestic violence, warrant service, eviction service. They are now in the courtroom because I have to do that because there's more judges. And so when judicial positions were created in Baltimore City, and I suggest this probably happened everywhere in the state, the local government was just expected to fund the deputy sheriff position to go with that judicial position. And that just hasn't happened, and that's why we're in the position we're in now. And that's why I think we remain in this position.
Sure, thank you. You spoke about conflict with the judiciary in the mayor's office.
Correct.
Can you tell me a little bit about that? What's the conflict?
So the conflict is, I believe, right, and I think any reasonable person believes that when a judge takes a bench, there should be a personnel in there, right? And so I've testified that I need this amount of personnel for this amount of judges, and I'm not funded to do that, right? My budget line item does not fund the staff to do what I should be doing, which is to put them in courtrooms. And so I have to pull from deputy sheriff line items that are supposed to do other things and put them in court, right? And I still don't have enough to do that. And remember, they're two separate things. Like we have a court security officer, who someone alluded to, that's paid much less and is a special police officer within a court facility. And then a deputy sheriff, which has citywide law enforcement jurisdiction. It's a much different aspect. And so to pull a deputy sheriff and put him on a metal detector at the front door is really not an effective use of resources. And so it hurts. And then also I have to go on overtime to pay for what that deputy sheriff wasn't doing during the day.
Sure.
And so it creates a huge problem for me. And this is a problem that all the sheriffs have. I don't think there's one sheriff in Maryland that I feel comfortable speaking for them to say if local government provided them with the funding to put them deputies in courtroom or special police officers in courtroom, they wouldn't do it to the standard that we're asking for. But that just doesn't happen.
Sounds good. So is your responsibility to address or prevent imminent threats against the courts?
It is.
Court buildings and staff there within?
It is. That is one of many responsibilities.
So do you feel that that is something you can negotiate? That responsibility?
I'm not sure what you mean.
I mean, like you feel like you can juggle whether you will or will not do it. Like we know there's a need, right? So you just heard testimonies speaking to the need of it, and that need and mandate is based on what has already happened, so we know it can happen again.
Right.
So I'm asking you that, do you believe that there's a wiggle room there for you as the sheriff to do it or not do it based on your ability to answer the needs of the court?
So the answer is I do it to the best of my ability and run a $3 million overtime deficit every year that I get called to the carpet for because I'm not funded for that, right? Sure. And that causes a conflict between me and the mayor and the city council and the taxpayers and my constituents. And it's a bad position for sheriffs to be in, right? I'm never going to, so we have, a judge will be threatened and I'll put the judge under 24-hour protection. And I'm not funded to do that, and I'm always going to do that, right? And if someone needs someone in a courtroom because there's an inmate in there and it's a medical malpractice case or something, I'm going to put a deputy in there off the street. But then I have to make up their work on overtime, and it causes a huge problem for me in local government. So again, like I agree with all of this. Like a judge should never take a bench without a deputy being there or a court security officer. I 100% agree, but local government is not funding sheriff's offices to do that, and that's what the problem is. And I think this bill, puts the burden on me now as the sheriff that I have to have the judges upset I'm not meeting their standard, and the county executives or the mayor and the city council being upset that I'm overspending my budget, right? And it's a rock and a hard place.
So it's a county council thing?
I mean, I'm not sure. I mean, I think that this body should maybe look at statewide why all the local governments have deficiencies with the sheriff's offices in court security funding and maybe come up with the funding mechanism. I think that's really what's lacking is what's the funding mechanism here? Do we force local government to do that? Do we have state funding that does it?
Sure.
I don't want to. I just can tell you that without that solution, it's really problematic.
Sure. Have you come to this body for funding or any of those recommendations that you're speaking of now?
I have, right? Okay. I testified about how important these standards are. I sat on the task force, right? Every year, this is my third year in a row, I'll go in front of the city council and the mayor and say, these are my transparent line items of what my court security will cost, and you're not funding me at that level in order to make these goals, right? And I'm just not getting what I need with that.
Sure. Thank you. Thank you, Madam Chair.
Thank you. Delegate Phillips.
Thank you, Madam Chair, and thank you, Sheriff Kogan. Always good to speak with you. This seems to me to be one of these real challenges between state, local, judiciary, specifically as it relates to funding. I have a judiciary which is really a separate arm of government, but is a state function operating in locality. The facilities are municipal facilities, and then you come to us.
Correct.
So this is a conundrum.
It is.
In your best of all worlds, understanding that, and you're in the precipice of all of this, do you have a recommendation for us?
I do, right? Like I can tell you that this is how many judges sit, and this is how many manpower hours I work on the door, and this is how much it costs, right? And I would say either that has to be a mandate on local government to pay it, or there needs to be some kind of state funding or grant that we can use to meet that goal so we can meet these court security standards. I think everyone thinks is common sense in the best interest of government. And the problem with this is why I'm favorable with amendments, is that this bill lacks that, and it just creates a standard without any way for me to meet that standard, and sets me up for a conflict.
Now, the Chief Judge talked about a grant program. If there were a grant program, would that address, and that grant program was permanent, not just temporary, would that address the issue? But how would one go about saying that the municipality would stop funding if you got this additional, right? How do you ensure that the municipalities continue to fund this work?
So if you take this analysis that they have, which I think is the right analysis, that every court, has to have a court security officer. And if there's an incarcerated person, it has to have 2 court security officers, and there has to be someone else walking around on the floor, and then you have to run a metal detector at every door. That's formulaic for me, right, and equals PIN numbers. And is very transparent, right? You can tell how many hours each door is open, right, when the courts are closed and when they're open. And if you would give me that amount of money, right, I would take a mandate that I have to staff it, right, based on this formula in a second, because I want to do that. This is the correct thing to do. So, but I don't see how you can say that there's a standard and then there's no way for me to meet the standard without setting the sheriff's office is up in the state for real problems and conflicts, both with the judiciary for not meeting the standard, right, and also local government for not funding the standard. So
where else do we have in public safety where we would put that type of a mandate on a local jurisdiction? Is there anything else that we can refer to? Because that's pretty significant if we say you must staff at these levels.
Right, or, I don't know. I know that we have a Governor's Office of Crime Control Prevention that does grants. I don't know if there's a grant funding for this. I know the Judiciary, right, is talking about grant funding. Like, I could say I'm willing to do this right now. I want to do this. Like, I've testified to do this, right? But I can't do it unless there's funding, right? And I don't create my own funding, and the judiciary doesn't fund me. I get funded by local government. And in local government, I'm in competition with everything, right? I'm in competition with rec centers and schools and libraries and the police departments and, what it's going to be. And so, local government around the state has not funded sheriff's offices. That's why there's a deficiency in all sheriff's offices. It's within the sheriff's offices because they're funded by the local government, right? And the priority in the local government hasn't been to give the sheriff's office a court security for each one of the judges. And, if you want to make it formulaic, if you create a judicial position, then there has to be funding for the sheriff's position to go along with it. I mean, that hasn't happened, and that's why we're in the position that we're in.
Okay, thank you.
Thank you. Delegate Woods.
Thank you, Madam Chair. Thank you so much. I just wanted to clarify that what you're saying is that the $5.6 million that they're saying is available for 2027, that assists local governments is still not enough to come near meeting your fiduciary needs?
So I believe that the city of Baltimore just put a $4 million fiscal note on that, and that would be for us to put a deputy sheriff or court security officer in every courtroom and meet these mandates. That would eat up, if they were talking about for the state, that would eat up to $4.2 million right in there.
Just for Baltimore?
Just for Baltimore City alone.
All right. Thank you. Thank you, Madam Chair.
Delegate Taylor.
Thank you, Madam Chair. Thank you, Sheriff, for being here.
Sure.
And, I'm reading this bill. We had a task force because we have issues.
Correct.
And they've come out with these guidelines. This is our wish list. This is where we think our standards should be. And it also says that any entity responsible for providing courthouse security shall use best efforts to present a minimum of these. So I'm not seeing where it's mandating that you do anything. It's just an attempt to reach these guidelines when funding is available, or to consider to pursue funding and to ensure that we meet these guidelines. So I'm just trying to rein this in a bit and make sure that we're on the same page, and that I don't see this as a mandate unless you're saying that if you don't meet these guidelines, that your department is going to be dinged in some way, or you'll be judged, pun intended.
Right, I understand. Well, so let me say this, and it goes to your point, right? These guidelines they're not guidelines. It's what should happen, right? They're coming across as guidelines, but I think if you pulled up anybody on the street and said, should a judge take the bench without a bailiff or a court security officer or a deputy be there, they'll tell you no, right? And from being in this business for 30 years, it's a safety risk for them to take the bench, and it's very problematic. And once you define, well, here's what the standard is, right? And Sheriff, why didn't you make this standard? And now there was an incident, right? It's not the judiciary that's going to have a problem, and it's not the mayor of Baltimore City that's going to have a problem. It's the sheriffs that are going to have a problem. And it's not a problem of our making, and that's what I'm trying to explain. Like, we will do this and want to do this if you fund us to. If you give us the ability through funding to do these things, we will do them, right? It's not a. We want to do them, but this is like, so where are we going here with this bill? Like, why are we setting a standard in a bar without providing me the opportunity to do that? And I just think that's important to say. I think it's as somebody who is going to take the hit, as you're saying, when something happens and doesn't have an ability to fix the issue, right, without causing all kinds of host of other issues. I just want to bring it to this body's attention. And I'm also asking for your relief and your assistance because I want to help the judges. Like, I'm here also, and I really want to express this, because I want to do what they want, right? I want to keep them safe. All sheriffs want to do that. Sure. That's what we want to be. We want to be in a position to do that because this is an incredibly important issue.
Thank you for your answer.
Yes, Delegate Wood.
Thank you again. Sheriff Cogan. So you said you already have that breakdown of what those specific areas of need would be besides making sure that the courtroom is covered. Sure. I'm sorry. Go ahead. So the question I was going to ask, and this may be not a question you can answer, is do we know that all of our jurisdictions have the same?
So that was part of the, I believe, the task force. What we did last year is identify where there's gaps, right, in court security. And it's the sheriff's offices where there are gaps.
Right.
Because of funding was the number one you heard testimony to. And the second one was also because of funding, because you need a salary that's compensable to get people to want to do the job. And that's also a funding issue.
But specifically, did we identify for each different region that scope of what those specific needs would look like? In other words, you're Baltimore, so you have a larger capacity, right, a larger need. Did we break it down for all of our counties?
Yes, we did. Yes, we did.
So we have that in a report?
I believe you do, yes.
Okay. You do. Thank you. Thank you, Madam Chair.
Delegate McComas?
I've got another question, and it's kind of off, but it is a concern for safety and security. Is there witness intimidation in the courts in Baltimore City?
Yes, and there's also judicial threats.
Right.
So yes, all those things
I know
occur.
we're dealing with the judges, but I'm concerned about if someone is threatened and they were going to expose people, and the people that they were going to expose are sitting in the courtroom, and then all of a sudden they can't remember anything. And there is actually a situation like that, and they told the investigating officer, they said, if I testified, they'd shoot me the minute I got out of the courthouse. So is there any protocol within Baltimore City courts that would protect people that, might testify against the bad guys, and they would be protected to get in and out of the courthouse safely?
Yeah, there's a lot of things in reference to that we do. So if it's a federal person and the U.S. Marshals have them and they're WITSEC, we work with them. We work with Baltimore Police that has a witness protection unit that they do. We work with the state's attorney's office that has a victim witness section that identifies that. And it's not uncommon, and again, we're talking about these standards. It's not uncommon for us to well exceed these standards in certain cases, to put not 2 deputies in, but 4 or 5 deputies in, right? And to raise the whole courthouse and elevate the status of that. And, sometimes we have deputies who are in plain clothes as not to interfere with the jury who's sitting in there. So we do a lot of that. We escort them in and out in different ways. I don't want to get too deep into what it is.
No.
Yeah.
It's just the story that I heard was that the person just drew a blank and that he didn't have any assistance, what you're talking about. And I just wondered if there was any type of protocol that it just, there wasn't a prosecution, is all I can say.
Understood.
Okay, thank you.
No, that's fine. I have one quick question, and that is whether or not there is any partnership. Because I've seen several officers in one courtroom before. But is there any partnership with other local law enforcement or MSP or anybody else if needed?
Yeah, so the Department of Public Safety and Correctional Services in Baltimore, right, transports the prisoners into the courtrooms. That's done by them. And so we work well with them. They act sometimes as an additional court security officer that's in there. They don't work for me, but they're there to safeguard the prisoner and people with the prisoner. So we work very closely with them. Every once in a while, the investigating officer will be in the courtroom and the police officers will be in the courtroom. So we'll work with them. But there is no like court security task force where like another law enforcement organization would come in and offer assistance. This is sort of, you know, fully on the sheriff's office in the circuit court to provide these security mechanisms. There really is no help from other law enforcement entities.
Thank you, Sheriff. Are there any other questions, members? Okay, Delegate Simmons?
Yeah, thank you. And I appreciate you coming out and lending your testimony. Can you tell us the difference between a full-time sheriff's department and a part-time sheriff's department and where they're operating when it comes to the state of Maryland?
Sure. So I'm gonna so in Baltimore City, Montgomery County, Howard County, Anne Arundel County, Prince George's County, and I'm forgetting which else. There's a municipal police department or a county police department, Baltimore County, that does the police services that you would consider the duties. They call them the duties of the county, which would be, you know, the call 911 and they show up. They do investigate crimes and detective work. In the other jurisdictions, it's a cross between two of them. Like, so in Baltimore City, for example, I'm charged with basically as the enforcement arm of the court, right? So I serve, and these are duties of the state. So I serve warrants, protect the courts, transport prisoners, serve protective orders. And in doing that, I'm also a peace officer and can do everything that the police department can. So I can work events at festivals and assist in that. But the court security part of that and the courthouse is the main driver of what we're doing and the work that's coming from the courthouse in those counties that have municipal police departments. In places that don't have a municipal police department, like Harford County or Charles County, the sheriff is acting as both the state actor protecting the courthouse and an officer of the court, and also acting as a conservator of the peace and doing the police department function as well. Right, but it really has to do a lot of it with funding.
So is your agency a full-time or part-time?
So I would say we're full-time, right? But I would not say we're full service, right? We're not doing the policing function. Baltimore Police Department is being paid for doing the policing functions.
Right. You operate 24 hours a day in the sense of your shifts or department?
No, but we're 7 days a week now, right?
What's your hours of operation?
So usually 7 to 7, but we have people on site, like the court is guarded 24 hours a day by the sheriff's office, and we have dispatch control 24 hours a day, and our warrant squad is often out at 3 o'clock in the morning. So it's really a 3 o'clock in the morning to about 6 o'clock in the morning. We're not staffed because no one's calling 911 and getting the Baltimore Sheriff's Office.
Correct.
Yeah.
Okay. Thank you, sir.
Sure.
Yep.
Okay, Sheriff, I think we have peppered you with questions.
It's been wonderful.
Thank you, and thank you for being here.
Thank you.
Okay, that concludes the panel. We're going to move to our unfavorable panel. Sarah Sample.
Just me? All right. Oh, I know it. I know it. I'm ready. So thank you, Chair. Thank you, members of the committee, for having me. My name is Sarah Sample, here with the Maryland Association of Counties, and we are very unfortunately here in opposition to House Bill 492. I want to be very clear that this opposition is not based on the purpose of the bill. It is just based on the process to how we got here. Last year, this bill came in. It came in as a mandate. It was an unfunded mandate financially. We had no idea what it would cost, but we were like, this is a really important thing to do. This is something that is going to make sure that we can protect our justice system and the people that are taking the risk every day to be in those positions. And so we supported with amendment last year. All we basically said was, this is a good idea. We just need to know how much it costs, and we would like for the state to help us out. during the interim, I got marching orders to basically go and talk to some of the associations and the agencies that are working on this, figure out how much this is going to cost us so that we can actually be a partner. We can see if maybe the numbers aren't that bad. Maybe we can fit them in if we get the information before our budget process. And in doing that outreach, I did not get the information that I was asking for. I was told that they wouldn't give it to us, that they couldn't give it to us, and that was very frustrating when we were trying to be a partner. And now, this year, when the bill came in, we looked at it, and it was sort of unclear on whether or not it was a mandate. And, you know, it led us to an oppose because we felt like we were trying, and we just needed them to give us the information. I can share that I got a fairly rushed call this morning from an individual that was basically saying, I'll give you the vacancies, and actually it's not a mandate, and we've got a grant fund and it's discretionary. The actual bill is discretionary. And so I think we're absolutely open to some of those clarifications, 100%. Our thing is just, we need to be able to know what this is going to cost us, and when we feel like we're trying to be a good faith partner and we're not getting that, it can be very frustrating. And unfortunately, a position of oppose did get the phone call that we were waiting for, and now I guess we're going to get the vacancies as of today. So fortunately, that's why we're in the position of oppose. Thank you.
Understood. Thank you. Members, do we have any questions? Delegate Moreno.
Thank you, Madam Chair. If you were to get the numbers and you look at the numbers and you disagree with them, would it be a situation where you unfavor the bill completely then?
Well, it's based on jurisdiction. We don't know what the numbers look in every jurisdiction, and I think the best process would be if we had each individual sheriff's office potentially go to the council. Actually, the process that the sheriff before me outlined is exactly what we would want all of the jurisdictions to do. Have the sheriff go explain in like January or February, while we're in the process of getting our budgets together, what we think the cost is going to be. And maybe it's not everything right at once because we can't find the funds right away, but maybe it's something where we can phase it in over time. That's what I think would be ideal.
Okay, thank you.
Yeah.
Thank you. Delegate Valentine.
Thank you for coming in today. I do have a question, having been on the task force myself, as well as it was a wide variety of entities from the judiciary, several sheriffs, several Board of County Commissioner members, state's attorneys, council members. My point is that this was not a surprise. And what I mean by that is I'm trying to figure out how much time would be enough, because we started this in 2024. We've been discussing this when the task force was first originated. And so I think the date in this is in 2027 with another date in 2029. So how much time would be enough for the counties to get that good idea of what they need when they've known this has really been coming for a couple of years now?
So respectfully, we won't know until we know what the vacancies are. Even if they don't have an estimate on what each individual costs, we can do that estimate as long as we know what the vacancies are, and that will tell us how long the timeline has to be.
And when you say vacancies like,
explain
what that is.
To get to the minimum adequate standard that's defined in the bill and that was given by the task force, which we didn't find any issue with.
Okay.
Yeah.
So you're saying
we just need information.
You just need information.
It was on our initiative. I mean, I'm not going to share much about the initiative, but it was on the initiatives list to potentially be something we were working on.
Okay. I thought these would have been known a few years ago, because I know these numbers, and these numbers look very familiar to what we were discussing back in last year and the year before. So I would have thought a lot of the counties, respectfully, a lot of these counties would have known, at least had a preliminary figure of what they were going to need.
From my understanding, when we discussed the bill last year, there were no figures that were given statewide yet at that point, and that during the interim, everyone was going to have to report those, but I think it was September 30th, I want to say it was, and that's when I was reaching out to be like, yes, let's get the numbers.
Okay. Thank you, Madam Chair.
Thank you. Members, any other questions? Seeing none, that concludes our bill hearing for House Bill 492. We're going to move on to House Bill 493. And Chief Justice Fader. Okay, Chief Judge Morrissey. Judge Stanilis. Thank you, Stanilis. And Lance Richardson? Is there a Lance Richardson? Yes. From the State's Attorney's Office of Queen Anne's County? Okay, so did you want, your sign up is favorable, but are you favorable with amendments, Mr. Bariani? Okay, so why don't you Why don't you go in the next panel, if you don't mind? I'm sorry. Thank you very much. And so we'll start with you, Mr. Chief Justice.
Thank you, Madam Chair, Madam Vice Chair, members of the committee. I'm pleased to be here to support House Bill 493. The judiciary this year is asking to add 2 judgeships. The circumstances of one of those requests is a bit unusual as compared to requests made in the past, so I wanted to be here to help explain that. But first, we are requesting a new judgeship in the District Court of Maryland in Washington County. Our judicial needs analysis has shown a need for a new district court judge in Washington County for several years now. We have not come asking you for a new judgeship there previously because there wasn't any room in the building. Now, however, we finally have a project to add more space in that courthouse underway. That will allow the court to be fully staffed for the first time in several years and alleviate the strain on the current bench. Chief Judge Morrissey will speak more to that request. The second new judgeship that we're requesting is in the Circuit Court for St. Mary's County. That is the spot that takes some more explanation, although you may recall the same explanation we provided last year when we were seeking that judgeship as well. The judiciary traditionally has asked the General Assembly to authorize new judgeships only when the methodology that we have used for decades to analyze that shows a certified need for that judgeship. That methodology is based on an assessment of how long it takes to handle different types of cases on average across the state, and the number of those cases that have been filed in each jurisdiction across the state over the course of the prior 3 years. That methodology has been provided by the National Center for State Courts, and we've, as I said, applied that over the last, over multiple decades. We apply a 3-year average in coming up with that needs analysis. We're currently using a model that was completed in 2017 with a partial update in 2022 for that purpose. This year, the assessment certified a need for 5 new judgeships. For a variety of reasons, including space limitations, we're requesting only one of those, which is the District Court judgeship in Washington County. 4 circuit court jurisdictions requested additional judgeships, even though the model did not produce a certified need. That includes Queen Anne's County, Harford County, Charles County, and St. Mary's County. We are not requesting judgeships in 3 of those jurisdictions. To be clear, each of those jurisdictions makes a good case for needing additional judicial resources. However, the bar for the judiciary to make such a request when the model has not identified a certified need is very high, in order that we maintain credibility with you by adhering to that rigorous methodology and only coming when we do have the case to make based on data for a new judgeship. Given the cases that those jurisdictions have made concerning the need for additional resources, we are accelerating the process of updating our model to ensure that it does accurately reflect need. We are updating that model right now, and the results of that will be available next year when it comes time to make requests for judgeships. We expect to have data then for you that takes into account the many changes that have occurred over the last 9 years, including the rollout of our electronic case management system over that time statewide. The Circuit Court for St. Mary's County, their request for a new judgeship cleared the very high bar we have for coming to you seeking a new judgeship, even though the methodology did not produce that certified need. That is because there have been demonstrable changes in that court's workload that we know are not reflected in the model. Perhaps most significantly, owing to policies in the Office of the State's Attorney in St. Mary's County, criminal jury trials increased by 261% from calendar year 2019 to calendar year 2024. That's particularly significant because the model we employ to analyze the need for judgeships is based on initial filings of each type in the court, not what happens to those filings after they're made. It does not take into account jurisdiction-specific changes that may cause a need for more resources in one jurisdiction than in others, even based on the same filing data. A case that goes to trial obviously takes a lot more time and resources of the court than the same case that might be resolved by plea agreement short of trial. So that 261% increase is not accounted for in the model, but is very significant when it comes to the resources needed for that jurisdiction. St. Mary's County also saw a 62% increase over the same period in family law merits hearings, which similarly is not accounted for in the model, which again only looks at filings, not on what happens after the cases are filed. In spite of efforts to address the backlog, those and other changes have not allowed the Circuit Court for St. Mary's County to do so. And in that regard, I will turn it over to Judge Stanalonis, the administrative judge for the Circuit Court for St. Mary's County, who can provide more information. I look forward after the panel to your questions, and I thank you for your consideration.
Madam Chair, Vice Chair, members of the committee, thank you very much for allowing me this opportunity to address you. As Chief Judge Fader indicated, we have seen a tremendous increase in the number of jury trials in our jurisdiction since the last election for state's attorney. The first year, we did not make a request for an additional judgeship because with a new state's attorney, we wanted to see if things would calm down, if things would change, if we would get back to normal. To give you an example, in the prior administration, we would typically have 2 weeks per month scheduled for criminal jury trials, and in a typical year, we might have 10 to 12 actual jury trials in criminal cases. Since the election of the current state's attorney, that number has drastically increased. We now have 3 to 4 weeks per month scheduled for criminal jury trials, and in a typical week, we have 2 to 3 trials that actually go. Over the course of the year, you can do the multiplication. Some weeks we have as many as 4 to 6 trials that actually go. And to give you an example, usually in those weeks, when we have 4 go, there were probably 4 others or 5 others that also wanted to go that had to be continued to a future trial week, and that is compounding. Each time a judge is sitting in court doing those trials, it's having a significant impact on family court and civil court. And as the Chief Justice indicated, the number of contested family cases has increased, and we are squeezing those in. But to give you an example, if you were to come into St. Mary's County today and say, I need a day with a judge to battle over custody of our child, it will take us a minimum of 12 months to get you into court for a day with a judge, meaning that during that 12 months, if you're the one without the child, you might have to sit and wait, or if you're the one that needs child support, you might have to sit and wait. So we are struggling to get those cases done at the same time as dealing with the requirements of a constitutional speedy trial in the criminal cases. We also, not in this data here, but we have also seen in the last 3 or 4 months an uptick in the number of civil jury trials that are now going. Our jury has been giving some generous awards, and now we're starting to see an uptick in the number of trials in that area as well. As judges, we are doing everything we can to try and keep the dockets moving, not granting continuances so that we lose court time. As those of you who are attorneys in this committee know, most courts in the state of Maryland start at 9 o'clock. They usually take a lunch hour and usually finish court around 4, 4:30, maybe 5 o'clock. In St. Mary's, we typically start at 8:30. We usually go through lunch, and we typically stop late, and we do all of our chambers work and other research and opinions and things. We're doing them late into the night and on the weekends. So I would ask for your consideration, and I'm happy to answer any questions for you.
Good afternoon again, Madam Chair, Madam Vice Chair, members of the committee. Washington County District Court has had a certified need for another district court judge for well over a decade, but a request for additional judgeships can't really be made until there's chamber space available and a courtroom for the judge, right? My administrative judge for that district, which is District 11, which includes Frederick and Washington counties, kind of needles me that the town of Hagerstown had built a baseball stadium across the street from the courthouse in less time it's taken me to get a third courtroom on that courthouse. But I'm delighted to say that we will have a groundbreaking for the beginning of the construction of the third courtroom in early March of this year. It's a 2-year design build contract that we just completed the 80% design documents this week. First, there'll be a rehab of the mechanical system, then a build of courtroom 3, followed by the rehabs of courtroom 2 and 1, and then the clerk's office, first floor lighting and HVAC ductwork. We're basically getting a new courthouse for a fraction of the price of what it would cost us for a new courthouse. But to give you a scope of what the 2 judges that are out there, it's Mark Thomas, who was one of my baby judge school classmates that just retired recently, and Victoria Lobley are the 2 judges out in Washington County. In terms of the caseload that they handle, they hear over 13,000 traffic cases, including almost 4,000 jailable traffic cases, more than 5,000 landlord-tenant cases, disturbingly more than 1,100 domestic violence protective orders, and another 624 peace orders. They disposed of over 3,800 criminal cases, over 900 DWIs or DUIs, and over 5,400 civil cases. In addition to these main case types, these judges will issue over 1,000 writs, renew 1,400 summonses, and will hear natural resource cases, municipal infractions, civil citations, extreme risk protective orders, emergency evaluations, fugitive warrants, and more than 1,400 bail reviews. They'll hear rent escrow cases, forfeiture of counterband, petitions to strike bond forfeitures, extraditions, violations of probations, witness warrants, body attachments, preliminary inquiries, and probable cause hearings. And that was all on last week's docket. That was actually for fiscal 25. Those two judges did all that work in fiscal 25. They operate well over 100% of capacity, and that model that we look at to certify the need shows that they're in excess of 110% of what an average judge should do in a year, well over that. And they've done so for many years without complaining, and I'd like to express my gratitude for these dedicated public servants. We've been waiting for many years to make this request, and I'd urge this committee to give a favorable report, and I'd be happy to answer any questions.
Great. Thank you very much. Members, do we have any questions? Well, seeing no questions, thank you very much for this panel. And we have...
Thank you.
Thank you.
Thank you.
Now we have Mr. Richardson. If you would come up, and Bruce Bariano.
Good afternoon, Madam Chair and
Good afternoon.
members of the House Judiciary Committee. For the record, Bruce Periano. I'm here on behalf of the County Commissioners, Queen Anne's County, in favor of this bill with amendments. The amendment would be to add another circuit court judge in Queen Anne's County. We have no opposition or objection to the testimony you heard by the witnesses. As you'll hear from the Sheriff's Office and particularly the State's Attorney's Office, the situation in Queen Anne's County is exactly, if even more so, the same and the need for a judge. Delegate Ahrens has put in a bill separately, which has not been heard yet but by the committee for what we're saying, but we wanted to take this opportunity to address the committee in this regard. I've sent you information. One thing is very salient. You'll hear from the sheriff and the state's attorney, but please read the materials that I sent you, and particularly read a letter from the clerk of the court of Queen Anne's County, where she attaches a letter from Pamela Harris, who was then the state court administrator for the Maryland Judicial Conference back in 2016, acknowledging the need in Queen Anne's County for another circuit court judge. But the problem was there was only one courthouse. The oldest courthouse in the nation probably only had one courtroom. So the letter, and please, you have it here, it says, build a courthouse and we will come. Well, the county commissioners built a courthouse. If you go to Centerville, it's magnificent. And it's got 2 courtrooms with all, so we did what the administrative office asked us to do. And we have an empty courtroom. We have visiting judges that come in, but they have limitations on the number of times that they can sit. And there's a real backup serious problem, analogous exactly to St. Mary's County. We really urge a favorable report on this. The need is enormous. You'll hear about it. Thank you very much.
Thank you, Madam Chair and members of the committee. My name is Lance Richardson. I'm the state's attorney for Queen Anne's County. I've been the state's attorney since 2009, so I'm pretty familiar with our criminal dockets. Queen Anne's County has over 53,000 residents. I think we are the most populated one-judge county in the state. Our judge, circuit court judge, is amazing, but I believe she's very overworked, and I can tell you why. We have an excellent district court judge in Queen Anne's County. He's my former boss, Judge Frank Cradaville, but I would say he's the toughest sentencing judge in the state. And anyone who has a criminal matter that carries more than 90 days incarceration has the right to a jury trial. So in Queen Anne's County, 90% of our criminal cases go from district court to circuit court via request for jury trial. We had more than 500 of these cases removed from district court to circuit court last year. You can imagine the load that's putting on our circuit court. Judge Cradaville and I are the same age. He turns 58 in May, so he can sit for another 12 years if he wishes. I'm hoping he doesn't. I want him to go enjoy retirement. But, you know, the uptick in crime is also serious as well. We had 3 murders last year in Queen Anne's County. In the 10 years before that, I had none. Each of those murders requires a week-long jury trial. We have 180 days to take those matters to trial and speedy trial parameters. It's very difficult. We are utilizing retired visiting judges daily. There's 2 civil divorce trials going today. They're both 2-day trials. We have a visiting judge handling that. So in addition to our criminal docket, we have a robust civil docket. Also, Queen Anne's County, if you know, the Bay Bridge lands on us. Most of our criminals aren't even local. They're coming through from other states and other jurisdictions. So for all those reasons, we could use that Second Circuit Court judgeship, and I would ask you to consider my letter that I've submitted as well. Thank you.
Good afternoon, Madam Chair, Madam Vice Chair, members of the committee. Thank you for having us. I'm Sergeant Andrew Neal with the Queen Anne's County Office of the Sheriff, and my current role is a Circuit Court Security Team Supervisor. I'm speaking on behalf of Sheriff Gary Hoffman and my court security staff to express our strong support for an additional Circuit Court judge in Queen Anne's County. Each year, nearly 500,000 visitors travel to or through our jurisdiction. Over the past 5 years, travel and commerce in our county have increased by more than 33%. With that growth comes increased responsibility. The Sheriff's Office responds to nearly 42,000 calls for service each year. At the same time, our judicial system is experiencing unprecedented demand. Currently, our courts consist of 1 district court judge, 1 circuit court judge, and 1 judicial magistrate. In recent years, we've seen a 129% increase in the filing and issuance of civil documents and domestic claims. Criminal filings have also risen. Each of these cases require time, attention, and careful judicial review. These increases place significant strain on our court staff, our judicial resources, and timely administration of justice. In June of 2019, Queen Anne's County completed construction of a new circuit court facility. That courthouse was intentionally designed for the foresight to allow for expansion, including the addition of a 2nd circuit court judge to complement the dedicated service currently provided by Honorable Judge Lynn Knight. At that time, we were preparing for growth. Today, growth is here. Queen Anne's County has taken a realistic and responsible look at our needs. We are not asking for expansion without cause. We are responding to measurable increases in population, travel, commerce, and judicial filings. Justice delayed is justice diminished. Our residents, our businesses, and our law enforcement partners depend upon a court system that can respond efficiently and effectively. The addition of a 2nd Circuit Court judge would align our judicial resources with the realities we face today. It will reduce case backlogs, improve scheduling efficiency, and ensure that our citizens receive timely access to justice. We are proud of our county. We are proud of our partnerships, and we are committed to ensuring that our growth is met with the appropriate infrastructure to maintain public safety and judicial integrity. Now is the time to align our responsibilities with the resources necessary to meet them. Thank you for your consideration and your continued support of Queen Anne's County.
Thank you. Members, do we have any questions? Delegate Phillips.
Thank you, Madam Chair. One burning question for me, Mr. Bariano. The judges talk about formulas that they use in order to bring another circuit court judge in. Can you comment on why you feel like we need one if they have not made that recommendation?
Delegate, thank you very much for the question. Very respectfully, and I really mean it. These formulas are developed by a think tank group in North Carolina. They use large standards. To my knowledge, there is really no looking at the unique local characteristics or situations that might be in a particular county in the state of Maryland. And I really don't, I'm not trying to be disrespectful to anything. It's more of a larger cookie cutter approach as opposed to an individual approach. You all know as legislators, yeah, we have 24 counties, but they're entirely different from each other, as you heard from the sheriff and the state's attorney. What I guess frustrates me, and the commissioners, I'm speaking for the commissioners, is 10 years ago, we were told you have a need for a judge, but you got to build a courthouse. I mean, the letter's there, and they were right, absolutely right, for a variety of reasons. We built another courthouse. with doing exactly what we were told. But, you know, and the end of the letter of back then of the administrator is the people of Queen Anne's County deserve better. After so many years of study and the recent commitment to construction, you now have a unique opportunity to move forward and to build what is sorely needed for the benefit of the current and future generations rather than delay the inevitable cost. But so here we are, and very respectfully, I don't understand the switch and the change when we did it at the county's expense. And the county realizes that with another circuit judge, there will be additional expenses that the county absorbs. They will do it. They're willing to do it. The need it's real. And I'm not being critical of the judiciary, absolutely not. But I have a duty on behalf of Queen Anne's County to so strenuously argue because there's a need, and the need's not going to go away. It's just going to get worse and worse. Thank you very much for the question.
Thank you. Delegate Stinnett.
Thank you, Madam Chair. I was going to ask, and just sort of what my colleague was asking, but I guess, are you saying that as far as where it currently looks now, is that cases or whatever gets backed up because of not having that other judge?
Well, we have a situation, I'm going to try to be as polite as I can be. We have a situation that is absolutely analogous to St. Mary's County. In St. Mary's County and in Queen Anne's County, there are officials that by their judicial opinion and their style and their philosophy are exercising their position and their authority in a particular way. In St. Mary's County, it is the state's attorney. Queen Anne's County, as you heard from the state's attorney, it is the judge. I'm not critical of that. It's just the reality. That is causing enormous pressures in St. Mary's as well as Queen Anne's on caseload. It just is. And so a very strong case has been made by the judiciary, and I agree with it, for another judge, a circuit court judge in St. Mary's County. The exact same situation exists, notwithstanding 10 years ago we were said you can get one if you build it. I'm perplexed, but that is the reality of it, and it's to my mind, and I'm not just saying this because I'm a lobbyist representing Queen Anne's County, the situation locally, it's not in a model from North Carolina, is exactly the same as Queen Anne's, as St. Mary's County. Different office holders, but the impact on the circuit court is exactly the same. Thank you.
Thank you.
Delegate Valentine.
Thank you, Madam Chair. And I believe Mr. Bariano just answered my question, but I'm going to ask, so based on St. Mary's and Queen Anne's and positions in both of those counties, because of some of the intricacies of those two office holders and the volume that those office holders, how they choose to run their offices, may put the numbers in a position where they wouldn't quite then apply in the way the judiciary guidelines are created. Is that correct? Does that skew those numbers so that they may not? Do you see where I'm kind of going with?
I do.
Is that kind of what's happening?
We do have a unique situation in our county, and the reality is, like 2 weeks ago, I was in a jury trial in circuit court, and our sitting circuit court judge was in the other courtroom handling 12 separate cases. So we rely heavily on visiting retired judges, which lacks consistency because everyone's got a different style. But yeah, our problem is somewhat unique, but it's a unique problem that's not going to go away anytime soon. If our district court judge was on the verge of retirement, then it might resolve itself, but he is not.
But that also leads me into my second question, Matt. So you have two courtrooms. One, you have a full-time circuit court position. You have a second courtroom that is filled by either retired and or visiting judges. Since you're in the courtrooms every day, about how often or what's the percentage on a given month or a year that second courtroom is filled by one of those positions?
We have a second visiting judge weekly.
Weekly.
Sometimes several times a week.
Mr. Valentine, if I may, when I left to come here today, we had a visiting judge doing an all-day civil trial today, as well as they were here yesterday. while Honorable Judge Knight was conducting normal trials throughout the day, and then she had a civil trial today as well. So we've had visiting judges weekly.
Is it safe to say that it's occupied more than it's not occupied?
I would say so, yes.
Thank you, Madam Chair.
Sure. Delegate Simmons?
Thank you, Madam Chair, and thank you all for coming. Can you tell me a little bit about, we're talking about a lot of mechanisms involving the court. Who sets the docket?
Which docket?
The court's docket on a daily basis.
The circuit court docket?
Yeah.
That would be our assignment clerk and the judge who would decide what cases are set when, what days we have jury trial prayers. Typically, every Monday in our circuit court, we'll have a dozen or more cases that have been removed from the district court to the circuit court. And those are typically misdemeanor jury trial prayers, but those are in addition to all of the felony cases which need their own separate court date. So the judge and assignment clerk set it, but they also have to coordinate all the visiting retired judges, visiting/retired judges to fill all the gaps that they cannot cover.
Okay, outstanding. So with that being said, when you look at, excuse me, the dockets on a daily basis, do you find that when y'all are interacting with the courts that subjects are due or being given a speedy trial in a consensus to when they're detained, for example, to when they're coming before a judge or when they're able to see a courtroom setting for a trial? What does that timeline look like?
As far as, are we meeting our speedy trial requirements?
Sure.
We are. I mean, the previous circuit court judge, Judge Ross, in his 16 years, never went beyond a Hicks date. He would not let anyone waive Hicks. Unfortunately, we have had some cases recently where we had to go beyond speedy trial because our defendant can waive that right, but we don't like to do it. It's rife with issues when you go beyond speedy trial, but it is happening more often and more common these days with our current issues. We've had several cases, murder cases, that we have to go beyond the speedy trial date.
Thank you. Appreciate it.
Yes, sir.
Delegate Boucher?
Thank you, Madam Chair. You had mentioned the propensity of defendants to want to move to the circuit court because of fear of the district court judge, so to speak. Would it be possible as an alternative to have an additional district court judge? Would that help you in any way?
We'll take it.
Is there a courtroom for them?
We do have 2 fully functioning district courtrooms as well. And we did, I mean, believe me, he's my former boss. I love the guy. Before he came, we had 2 district court judges on a regular basis. Now we don't need 2 district court judges anymore because no one's staying in district court. They're all going to circuit court.
That's what I was wondering, if potentially if you had the district court judge before potentially getting a circuit, if that would be relief for you in some way.
That would probably work as well. But
you'll take whatever you can get.
That's right.
All right, thank you.
Okay, Delegate Woods?
My question is this, and I forgot who said it, but it really stuck out with me. Justice delayed is justice diminished. My question is this: what is the difference in cost when you bring in the temporary or retired judge? And does that also require that you bring in additional administrative support? And when I'm talking about in comparison to hiring another judge.
Well, our clerk's office is staffed fully, and I think we would need additional staff for a second circuit court judge, but our county has already pledged that financial commitment.
Okay.
So we're willing to do it. Queen Anne's County is fortunate that we're one of the more affluent counties, and we don't have the budget woes of some of the other jurisdictions. So our county's willing to fund all the additional security and courtroom clerks. Fortunately, we're not in the position of the poor sheriff from Baltimore City.
And I'll just add to that as well, Ms. Woods, the sheriff that spoke earlier, there's the staffing that we have for security personnel meets those standards right now. We're able to take that judge, and if we have prisoners in there, we're able to accommodate those things. I have, it doesn't sound like a lot, but I have 8 people, including myself, assigned there, and I also have civil process staff, and we also have 3 security screeners who are not sworn personnel that help us with getting people in the building. Now, they have a sworn deputy with them But if we have to take in another courtroom, we have the staff to be able to accommodate that judge.
Okay. And
Judge
always,
Woods, just one last thing. As you may know, retired judges, that become visiting judges, and I forget the number, but they only can sit for a certain number of days a year. So you do run out of times with judges. And then if you bring in another judge from the other side of the state, you're pulling away activities there as well.
I didn't realize that the retired judge can literally, Madam Chair. Okay. I didn't realize that the retired judge can only sit for so many days a year.
I believe it's 50. I may misspeak, and I know.
Is that across the board, or is that in your?
Yes, I know several retired judges, and I apologize, I forget the number. I will get that to you.
Please.
But like on the Eastern Shore, some of you may know Judge Danny Long, retired judge, former chair of this committee, Madam Chair. He sits a great deal, but he's only limited to how many times a year he can do that. So you run out of additional judges, retired judges to use, and if you pull an active judge, you're then going to impact from where you're pulling that person. Thank you.
Okay, thank you. Thank you, Madam Chair.
Members, any further questions? Seeing none, that concludes.
Thank you very much, Madam Chair.
Thank
for
you.
your time.
That concludes our bill hearing for House Bill 493. We're going to move on now to House Bill 821. And for this bill, I have Judge Albright. I only have Judge Albright. Is there anybody else?
I will explain.
Okay. Thank you.
Good afternoon, everyone. Thank you for welcoming me. Chair Bartlett, Vice Chair Davis. With me today, I'm honored to be joined by Tanya Bernstein, who is the Director of the Commission on Judicial Disabilities, as well as our investigative counsel. Thank you for coming with me today.
My pleasure to be here. Thank you.
Thank you, everyone, for your time today to testify in favor of House Bill 821 on behalf of the Maryland Judiciary. And personally, I want to thank everyone who has sponsored this legislation. My name is Ann Albright. In addition to serving as one of the judges of the Appellate Court of Maryland, I am also the chair of Maryland's Commission on Judicial Disabilities. The commission is an independent body that investigates complaints of sanctionable conduct, disability, and impairment among Maryland's judges and justices. And when warranted, we conduct formal public hearings on those complaints. Where clear and convincing evidence of such conduct is found, we have the ability to take or recommend actions against a judge or justice of the Maryland Judiciary. Removal from office and compelled retirement are the most serious sanctions that we can recommend, and they require findings by the Commission and the Supreme Court of Maryland, those decisions. In order to recommend removal, the conduct must be so serious that the alternatives, which would be conditional diversion agreements, reprimands, letters of cautionary advice, are all insufficient. The kinds of conduct that would warrant this include allegations and findings of racism, sexism on the bench, sexual harassment, accepting bribes, criminal conduct, or intoxication during hearings. Levying sanctions, especially removal, is not a responsibility that we take lightly. We investigate complaints thoroughly, defend the due process rights of the subjects of the complaints and the judges, collect evidence in a fair and neutral procedure. Recommending removal is rare. Through the exercise of its powers, the Commission promotes public confidence in our bench, preserves the integrity and independence of Maryland's judiciary. But there is a gap. And the gap remains in our ability to fully carry out our mission. Right now, a judge or justice of the Maryland Judiciary who is removed or retired remains eligible for future appointment or election to judicial office, regardless of the gravity of their conduct or their ability to perform their duties. So we ask, how can Marylanders trust their rights are being upheld by the courts if their hearings are presided over by a judge whose impartiality and performance warranted their prior removal? That's why I'm here to testify in favor of this legislation. Put simply, House Bill 821 prevents judges and justices who have been found unable to perform the judicial duties from serving in a judicial capacity or judicial office in the future. 25 other states already prevent removed judges and justices from returning to the bench either for a fixed time or permanently. States vary on whether the disqualification is automatic upon removal or elective, but the measure before you today toward would be automatic. I would be happy to provide any information in addition. Preventing judges and justices who engage in the gravest sanctionable conduct who are unable to perform their duties from returning to office is critical to defending the integrity and the reputation of the bench in Maryland. So on behalf of the Maryland Judiciary, I urge a favorable report, and I'm happy to answer any questions you may have.
Yes, Madam Chair, I'm here to answer any questions that the committee may have. Thank you.
Do we have any questions? Well, you explained it so well that we don't have any questions, Judge Albright. Well, thank you very much for being here. And that concludes our testimony for House Bill 821.
Thank you for welcoming us. We appreciate it.
Thank you
very much.
All right, have fun in JPR. All right, is Delegate Charcutian here? I don't see her yet. Okay, I'll go ahead and start with House Bill 822. And we're going to treat this as a departmental bill. Just give me 1 second to get over there. I saw Scott Poirier. He's not testifying?
He is. He just stepped out in the hallway to get the register.
Oh, get everyone else. Okay. I probably should have moved slower then. Oh, there he is. Okay, great. Since I'm treating this as a departmental bill, I really don't have an introduction. In fact, all I was going to say was the clerks are here to make the introduction. So if you all would start. I see Scott Poirier, you know, my clerk from Anne Arundel Circuit Court, and I appreciate you. Kevin Tucker, yep, and Dawn Lindsay, and Register McFarland. Okay, so Clerk Poirier, whenever you're ready.
Thank you, Chair Bartlett, Vice Chair Davis, and members of the committee for this opportunity to testify in support of House Bill 822. For the record, my name is Scott Poirier, Clerk of the Circuit Court for Anne Arundel County. I'm also representing the 24 elected clerks of the Circuit Court in Maryland. The Circuit Court clerks are the administrative arm of the court and often the first point of contact for the public. While we cannot give legal advice, we can direct people to resources and help them navigate a complicated and often intimidating process. Collectively, clerks oversee more than 1,500 employees statewide, and we handle about 200,000 new case filings every year. The job we do, largely behind the scenes, impacts people's lives. Among our many responsibilities, we make sure that millions of pages of document related to these cases are processed in a timely and efficient manner. When a matter is before a judge, the clerks are the ones to make sure the case is in the right place at the right time. When a judge sentences a defendant to incarceration, it is we that ensure the sentence is properly recorded so that there are no mistakes, releasing someone too soon or keeping them longer than they should. We also ensure guardians are assigned to care for vulnerable individuals and process audits to make sure that property is not stolen. Beyond the courtroom, we serve as the recorder of deeds, maintaining land records that drive Maryland's economy. We record transactions worth billions of dollars every year and collect over $400 million in land records revenues annually for the state of Maryland. Without the circuit court clerks, the real estate market would stall. We also preserve history. People come to us to look up their marriage records and land titles. We process expungements that give individuals a second chance. In addition, we act as the justice of the peace, issuing approximately 40,000 marriage licenses annually and performing about 16,000 wedding ceremonies, moments that matter deeply to Maryland families. I asked for a favorable report on HB 822, and I would like to thank Chair Bartlett for sponsoring this bill. Thank you for the opportunity to comment, and I am available if you have any questions.
Thank you. Whoever wants to go next. Clerk Lindsay, are you clerk?
Thank you, Chair Bartlett and Vice Chair Davis, and members of the committee, for this opportunity to testify in support of House Bill 822. For the record, my name is Dawn Lindsay, Clerk of the Circuit Court for Allegheny County. I am representing the 24 elected clerks of the Circuit Court in Maryland. We support House Bill 822 because of the advantages of streamlining the process for setting the salary cap for the clerks. I have been involved in the salary legislation for the clerks since 2002, and for all of those 20-plus years, we have received requests from legislatures to find a better way to set the cap. We think tying the clerk's salary to that of the state employee schedule would accomplish that objective. As is currently the case, the legislature sets the maximum cap for the clerk's salary, but then the actual salary for each clerk is set by the Board of Public Works. Under this proposed bill, the Board of Public Works is still responsible for setting the clerk's salary, but since the cap is tied to the standard salary schedule for the Maryland state employees, the legislature would not need to separately set the cap for the clerks every 4 years. The state employee salary schedule is already subject to analysis and evaluation to ensure it stays in line with the cost of living and general market conditions. This way, the salary cap will stay in line with state employee salaries and not become too excessive or too deficient. The legislature has already adopted the option of tying salaries to an existing standard for several other offices whose salary is set in statute. This includes nearly all the state's attorneys and the sheriffs in the state of Maryland. This option has worked well for those other offices, and there's no reason to believe it would not work equally well for what applied to the clerks. And at some point in the future, the legislature decided for any reason that tying the clerk's salary cap to the state employee schedule was not working, the legislature could undo it and set a new standard. I asked for a favorable report on House Bill 822 and would like to thank Chair Bartlett for sponsoring this bill. Thank you for the opportunity to comment, and I'm available if you have any questions.
Thank you. Thank you, Chair Bartlett, Vice Chair Davis, and members of the committee for this opportunity to support to testify in support of House Bill 822. For the record, my name is Kevin Tucker. I am the elected clerk of court for Washington County and past president of the Maryland Circuit Court Clerks Association. I support House Bill 822 because of the small fiscal impact of the requested salary cap. Since the legislature sets the maximum cap on the clerk's salary and the Board of Public Works actually sets the salary for each clerk, there is no fiscal impact if the Board of Public Works does not increase our salaries. However, if the Board of Public Works sets our salaries at the maximum under the cap, as established by House Bill 822, it will still have a very small impact on the overall budget for the judiciary. Even a maximum increase would only equate to approximately $500,000 out of the judiciary's approximately $800 million annual budget. The judiciary, which supports our salary increase, has included this funding into their budgetary requests this year. It should also be noted that as elected officials, Article 3, Section 35 of the Maryland Constitution only allows our salaries to be adjusted once every 4 years. So while other state employees, including our staff, have received cost of living and merit increases over the past 4 years, the clerks have not. House Bill 822 ties the clerk's salary cap to grade 26, step 20 of the Maryland State Employee Salary Schedule, which would give the clerks only the same increase that all other judiciary employees have received over the past 4 years. It would not vault our salaries over those of other employees, but would bring us into alignment with other salary adjustments that other state employees have enjoyed. This increase would be consistent with the salary level comparable of senior leaders in similar positions in the judiciary, which is consistent with the clerks of both the Supreme Court of Maryland and the Appellate Court of Maryland. We, as clerks, manage about 1,500 employees, about a third of the judiciary, and I ask that you please have a favorable report on our request, and I'm available for questions should you have any. Thank you.
Great. Thank you, Clerk Tucker. Registrar McFarland.
Good afternoon, Chair Bartlett. It's good to see you in person.
And Vice Chair Davis, members of the committee, for the record, my name is Byron McFarland. I'm the Register of Wills for Howard County and chair the Legislative Committee of the Maryland Register of Wills Association. I want to also thank the chair of the committee for sponsoring this bill and my courthouse colleagues for their thorough explanation of what the bill does for the clerks and for the registers. I'd like to use my time just to share with you briefly who we are and what we do. Each of Maryland's 24 jurisdictions elects a Register of Wills, a state constitutional office in which we devote our full working time to serving the public. These are multifaceted roles, but our primary responsibility is overseeing estate administration, also known as probate. I always think of this office as part judicial or legal services and part human services, because when a Marylander loses a loved one and needs help, they call us. They're going through one of the hardest times of their lives, and they're faced with navigating a legal process they've probably never dealt with before. Knowing that, we walk families through the process step by step, doing our best to make a seemingly overwhelming ordeal feel manageable with the reassurance that we're just a phone call away. We work to defy the sometimes mixed expectations people have of government and provide families with dedicated subject matter experts who genuinely care about what they're going through. We do a lot more, including confidentially storing wills for safekeeping, issuing certificates of domestic partnership, providing copies of records, engaging in community outreach, and working with stakeholders to make reforms to the system. We're also net revenue generators for the state. Last year, we collected roughly $120 million in fees and taxes, $90 million of which went to the general fund. As of halfway through this fiscal year, our revenue was up nearly 18%, which will fund this bill and much more. These offices are a vital role in our state government. We take great pride in the work we do and believe this bill will appropriately resolve how we are compensated for this work going forward. Thank you for your time.
Thank you. Members, do you have any questions for this panel? All right, seeing none. Thank you very much for being here and testifying on House Bill 822. And if you noticed, Clerk Poyer, I did not say what I said last time, but you are great. I'll say that.
That's high praise coming from the best chairperson in the entire state of Maryland.
Thank you.
But I may be biased. Thank you, Chair.
Thank you. Good to see you all. Take care.
Since it was her bill, we knew better than they
We're going to move now to House Bill 332, Delegate Charkoudian.
Thank you, Madam Chair. And two people in person.
Yep, we have David Weinberg and Peter Mena.
And then I have two virtual.
Yep.
As well. Yes. Great.
Whenever you're ready.
Thank you, Madam Chair, Madam Vice.
Sorry to interrupt you, but so just to let you know, you have 3 minutes.
Okay.
And then everyone else will have 2 minutes. And welcome to Judiciary. Have you been here this year?
I have not.
Oh, very good to see you.
Lovely to see you too. Madam Chair, Madam Vice Chair, colleagues, thank you. For the record, Delegate Lorig Charkoudian here asking for a favorable report on House Bill 332. House Bill 332, also known as the No Kings Act, responds to the crisis that we are currently facing in our country. Specifically, what we're seeing across the country and here in Maryland is federal agents actively violating the constitutional rights of our community members, our neighbors, our families. We see this in terms of immigration enforcement. We see this in terms of responding to protests. We see this in terms of potential data privacy violations and many more violations. And so it is our responsibility as legislators in Maryland to do everything that we can to protect Maryland residents. What this bill does is it takes a look at the systems that we have in place, and it creates a new pathway for Maryland residents to file a civil suit against federal agents when their U.S. constitutional rights are violated. Right now, there is a pathway to do that, but unless we put this law into place in Maryland, our residents won't be able to I'm going to leave a lot of the technical conversations to my panel as well as to the virtual panel that we have coming up. I have certainly heard questions about the particular pathway that we have, questions about the technicalities of it. I want you to know that we're in conversation with all of the folks who have filed favorable amendments. We're also in conversation, of course, with all of the experts, several on my panel and others, and with the Senate, where they're also working on this issue. There will be a number of amendments that are going to come that'll address some of the concerns that have been raised. But I think there are also questions about, whether this would be challenged. And I just want to close by saying that we are responsible at this moment in history as Maryland legislators to do everything that we possibly can to protect Marylanders in this current situation. And so even if this law is challenged, it's incumbent on us to have put it into the mix, to have taken the steps that we can. And so I think what you'll hear from my panel is all of the reasons that we believe that this is a very clear path forward. We'll be working on amendments going forward, and I urge a favorable report because I think it's incumbent of us to do everything we possibly can at this time.
Thank you. Whoever's ready to go next.
Go ahead.
Okay, all right. Good afternoon, Madam Chair, members of the committee. It is my pleasure to appear before you today to discuss the No Kings Act. My name is Peter Mina. I am a civil rights lawyer and federal employment law attorney in Washington, D.C. I'm also a resident of Crofton. Prior to my tenure in private practice, I spent 14 years at the Department of Homeland Security, where I served both at ICE as the chief of their labor and employment law division, as well as a deputy officer for civil rights and civil liberties at the department. And so I probably have a unique position in terms of my perspective on the need for accountability. I wholeheartedly respect the very difficult job law enforcement officers have in engaging with individuals in the course of enforcement activities. I think that the Homeland Security mission is critically important. However, that mission should not be separated from the protection of civil rights and civil liberties. In fact, those missions are intertwined. We have to make sure that our Homeland Security mission is executed in a way consistent with our values. A lot of the attention is focused on immigration enforcement. However, this is much broader, as Delegate Jarkoudian mentioned. I would strongly argue that we should, and the House of Delegates should consider, and others, as other states have, as broad a perspective as possible, given some of the legal challenges, and looking at not just the law enforcement officers acting under the color of law, but also potentially either contractors or other entities that may be involved in the arrest, seizure, detention of citizens and other Maryland residents. And so, particularly because currently in the current administration, there really is no measure of accountability. Oversight has essentially been wiped out. And there really aren't any sort of credible investigations happening in the department. And so with that, thank you for your consideration.
Chair Bartlett, Vice Chair Davis, Delegate Jarkoudian, and distinguished members of this committee, thank you for the opportunity to testify today. My name is David Weinberg. I'm a proud Maryland resident and a policy strategist for Protect Democracy United, a nonpartisan 501c4 dedicated to upholding the rule of law. We encourage you to issue a favorable report on HB 332, which stands for a simple proposition. If any official violates your constitutional rights, you deserve a remedy. The recent killings of Renee Good and Alex Preddy demonstrate in chilling detail why this is so urgent. Whether their families have legal recourse should turn on whether rights were violated, not what badge the officers were carrying. State and local officials can already be sued under 42 U.S.C. 1983 if they violate constitutional rights. But because of the context in which Section 1983 was passed shortly after the Civil War, it only applies to state and local officials. HB 332 would fill this loophole by holding federal, state, and local officials equally accountable. Although the Constitution's Supremacy Clause elevates federal law as a general matter, it does so with an important caveat. The supreme law of the land shall be, quote, this Constitution and the laws of the United States which shall be made in pursuance thereof, end quote. Those three words, in pursuance thereof, mean that federal actions can only be supreme when they comply with the Constitution. The Supremacy Clause cannot grant impunity to federal officers for actions that are egregious violations of the Constitution. In recent decades, Congress and the courts have hollowed out remedies that once existed to hold federal officers accountable. Thus, most Marylanders cannot sue federal officers currently, such as ICE agents, to remedy even the most severe harms. HB 332 would fix that by creating a private right of action against any officer who violates your fundamental rights. Thank you for your consideration of this act.
Thank you. Delegate Cardin.
Madam Chair, I'm happy to wait till after the one line out.
Okay. Delegate Erica.
Did you want to do the online, folks? Yeah, go ahead. Yeah, do what you got to do.
Okay, so we're going to bring in Travis Brunner and Professor Field Amar. Pardon?
Madam Chair, I'm happy to wait.
You have 2 minutes for your testimony. Mr. Brunner, can you hear me? I'm sorry, Mr. Brunner, can you hear me?
Yes, now I can.
Okay, great. I'm sorry, I didn't have my mic on. Can you can begin, and you have 2 minutes for with your testimony, please.
Great, thank you. Chair Bartlett, Vice Chair Davis, Delegate Charkoudian, and distinguished members of this committee, thank you for the opportunity to testify for you today. My name is Travis Bruner. I'm a policy strategist and...
Yes, now I can. Okay, great. I'm sorry, I didn't have my mic on. Okay, you're going to have, whoever has their YouTube on, has to be turned off, or otherwise we'll have feedback. Thank you. Okay, Mr. Bruner, you may begin again.
Oh, okay. Chair Bartlett, Vice Chair Davis, Delegate Charkoudian, and distinguished members of this committee, thank you for the opportunity to testify for you today. My name is Travis Bruner. I am a policy strategist and licensed attorney at Protect Democracy United. There are 3 key legal issues I'd like to ask you to consider as you look at this bill, for which we encourage you to issue a favorable report. First, it is important that the act regulate federal, state, and local officers equally because the Intergovernmental Immunity Doctrine prohibits state laws that either regulate the United States directly or discriminate against the federal government or those with whom it deals. For example, last week, a federal court invalidated a California anti-masking bill that applied to federal officers and local officers, but not California state officers. By treating all officers acting under color of law equally, HB 332 should be legally resilient in this way. Second, the Westfall Act shields federal employees from common law tort suits while engaged in their official duties. However, it contains an explicit exception for violations of the United States Constitution. Because HB 332 codifies liability for only those actions that violate the U.S. Constitution, any lawsuit brought under the No Kings Act would, by its nature, be exempted from the Westfall Act. There is one small wrinkle here in the bill as drafted that I'd like to draw your attention to. We would suggest deleting the phrase "or allows" on line 7 in subsection A1 to avoid any question as to whether the bill is introducing a new theory of vicarious constitutional liability beyond the current rule that government officials may not be held liable for the unconstitutional conduct of their subordinates. Lastly, the federal government is likely to argue that a lawsuit brought under this act is subject to object preemption because the officer's conduct constitutes a unique federal concern. And while we do recognize that qualified immunity for federal agents is likely a challenging issue, allowing such a defense in the bill would likely shut the door on any such challenges because there is no federal interest in violations of clearly established constitutional law. If it would help you to thread the needle by not leaning too far into QI, we could point you to some language we crafted in California last month. Thanks for the opportunity, and hope you pass the bill.
Thank you. Professor Amar?
Yes, can you hear me?
We can hear you. Thank you for being here.
Thank you so much for inviting me. I am a citizen of Connecticut. I'm a professor at Yale Law School. And today I come to you from via Zoom from Chicago. This bill has some origins in a piece that I wrote for the Yale Law Journal 40 years ago. It's being picked up, this idea, by many other states, some have adopted it, like Illinois, versions of it, like Illinois. Many others are considering it. There are many technical complexities here, and I just basically want to say that I'm at your disposal if I can be helpful to you and your staff going forward as you work through some of the many complexities. I especially commend to your attention a version of the bill that has recently been introduced in Utah, which is a proverbially red state. Many of the other states that have passed this, versions of this or are considering it, are proverbially blue states. Connecticut, my own home state, California, as I mentioned, Illinois, New York, New Jersey. There are others. With that, I just want to yield back the rest of my time and tell you that I'm absolutely available if I can be of help going forward. Thank you.
Thank you. I just wanted to take a moment of personal privilege and thank you, Professor Amar, for being here. I know that you must find it somewhat amazing that a law review article that you wrote 40 years ago is now the impetus of so many state laws. Is that true?
Well, these state bills, and life is funny that way. If you live long enough, maybe you'll see everything.
That's right. Yes, it is. Well, thank you so much for making yourself available. Members, do we have any questions? Delegate Cardin.
Thank you, Madam Chair. Thank you very much for the bill, your compelling testimony. Mr. Bruner, you actually, I think, answered one of my questions, so I'm glad I waited, regarding, is there any change in liability for state officials in this legislation? It sounds like we already had the ability through 1983 to sue state officials for a violation of constitutional rights. Does this in any way change liability for state officials? The other question I had is there any case law at all that we can look to that may help us predict how this may be handled across the country? Number three is, would this impact elected federal officials? In other words, I know that there's a clause in here that says may not be construed to waive or abrogate any defense of sovereign immunity otherwise available. We already know that the Supreme Court has determined that there's certain immunities that the president has. Is the Supreme Court likely to decide that other folks might also have some sort of immunity based on those same ideas? And maybe the professors or the experts might
defer to the experts, and then I'll check more.
So who would you like to, who would like to answer that question, please?
Just one person, but if there is...
Professor Amar or...
Yeah. I mean, I'm happy to take a stab at it and then defer to Professor Amar.
Okay.
Let me take the last one first. I think really the seminal case is Bivens before the Supreme Court, and unfortunately that case has been eroded pretty substantially in terms of a plaintiff's ability to pursue liability against or personal liability against a federal law enforcement officer. Could the Supreme Court, ultimately reverse Bivens? That's entirely possible. However, that, it is still technically the law of the land, even though it has been very largely circumscribed. The other thing I would flag in terms of liability issues, and you mentioned state and local law enforcement officers, to the extent that there are any remaining 287G agreements with state and local jurisdictions, there very well may be an immunity argument that the government makes as it relates to state and local law enforcement officers acting, to enforce federal law enforcement statute or federal statutes like the INA.
So if we eliminated 287Gs here, that would help. Sure.
Yeah, absolutely.
That's a good.
That's a whole other side conversation.
We did that yesterday.
Yeah, excellent.
But is a federal, let's just say, for example, an ICE agent maybe did something that we believe was unconstitutional in how they tried to perform their duties, and somebody wanted to sue them. Let's just say that happened, for example, here in Maryland. Would they then use the sovereign immunity argument, and would it be able to be successful even if we pass this?
Yeah, I see Professor Amar shaking his head. I'll defer to him.
So in general, sovereign immunity is only for the government itself. It would be for the United States government or perhaps some high government department, but not against an individual officer. Now, an individual officer held liable might have an indemnification understanding with the government if the officer is carrying out government policy. But sovereign immunity shouldn't in general be a problem, nor I think should you worry too much about suits brought against lawmakers, federal lawmakers as such. Usually suits are brought against people who do things rather than people who merely say things. So I don't think that should be a particular problem as well. There is a long history of even state law remedies against federal officials when they violate federal constitutional rights. Now, these are often not targeted at federal officials as such. This long line is just using state property law, state tort law. When someone comes onto my property and into my house with, I can sue that person in trespass or tort. If that person claims to be a federal official, I can counter, oh, you're doing something that not even federal officials can do because you've acted unconstitutionally. You heard an earlier witness emphasize the words in pursuance of the Constitution, and acts of the federal government that are unconstitutional aren't in pursuance of it. With your indulgence, I'd just like to read you a very influential pamphlet that was produced by someone calling himself a Maryland farmer. This isn't during the ratification of the Constitution. It's featured very prominently in another article I wrote in the Harvard Law Review called Fourth Amendment First Principles. That article has been cited 7 or 8 times by the Supreme Court, along with the Of Sovereignty and Federalism article that was already alluded to. But since you all are in Maryland, I thought you might want to hear what someone said about federal officials violating the rights of Maryland citizens. This was during the ratification debates on the Constitution. To repeat this from a Maryland farmer, here's the quote. Suppose, for instance, that an officer of the United States should force the house, the asylum of a citizen, by virtue of a general warrant. I would ask, are general warrants illegal by the Constitution of the United States? No remedy has yet been found equal to the task of deterring and curbing the insolence of office, but a jury. It's become an invariable maxim of English juries to give ruinous damages whenever an officer had deviated from the rigid letter of the law, or been guilty of any unnecessary act of insolence or oppression. Here's an earlier quote. If a federal constable searching for stolen goods pulled down the clothes, by which was meant the sheets, of a bed in which there was a woman, and searched under her shift, that is her nightgown, a trial by jury would be our safest resource. Heavy damages would at once punish the offender and deter others from committing the same. But what satisfaction? So anyway, I won't go on, but this idea that states exist to protect their citizens against all sorts of abuses, including unconstitutional abuses by the federal government, is very deeply rooted in our history. And Maryland played a particularly important role in these early conversations.
Thank you very much. Thank you.
Okay, Delegate Erica.
Thank you, Madam Chair. Thank you guys for being here. I don't know who can best answer this question. I actually have 2 questions. Whoever mentioned why we can't already do this, can you explain that again to me? Why do our current laws not permit us to sue anybody that comes into our state and does anything?
So I think right now there's a gap. You know, the primary statute that we've been talking about is 42 U.S.C. 1983, which, you know, was enacted, you know, post-Civil War and really focused on state and local law enforcement officers. The Supreme Court nor the Congress, I mean, outside of Bivens, has really recognized a similar cause of action against federal law enforcement officers. And then you have the other statutes that have been mentioned by other members of the panel, like the Westfall Act, as well as the Federal Tort Claims Act, that protect federal law enforcement officers, with the very important exception that folks have mentioned, which is when one of those law enforcement officers engages in unconstitutional behavior.
Okay, that's helpful. And then for the.
Delegate Erica?
Oh, sorry, did you want to add to that?
Yeah,
Oh, go ahead.
I just wanted to share. Professor Amar engaged in a conversation about this exact matter during the Senate hearing last week, and I think he might be able to provide another.
Okay, awesome. And I actually have a second question for him as well about, he had mentioned other states that have already passed this. Has there yet been cases that we've seen that we can look to outcomes, facts, anything additional? Professor, if you want to.
And if I might try to take a stab at those questions and also correct the record just a bit. I gave you two quotes. One was from the Maryland Farmer, another one was from another pamphlet from Pennsylvania. We haven't had yet court cases on some of the other Converse 1983 or No Kings Act statutes. These are very recent enactments. Some of them have problematic provisions. They haven't yet come to court. If you want the best academic commentary on them, I commend to you a piece written by Professor, former Dean Vikram Amar. He happens to be my brother. He clerked for the Supreme Court. He was the Dean of the University of Illinois College of Law, and he has an analysis of the Illinois bill. To remind you, he was the Dean of the Illinois College of Law, and he tries to go through which aspects are particularly problematic and which ones are likely to survive court scrutiny. You asked also why we might need such a law. Let me just give you one example. Back in the founding, common law of tort and trespass and property was roughly coextensive with federal constitutional protections. When a government official, for example, searched or seized you, typically that was going to involve an intrusion on your property interests or your personal tort interests. Today, just for example, you can have high-tech surveillance that does not technically cross a property line. It's a wiretap upstream of the property line. And in a famous Supreme Court case from the 1960s called Katz, the Supreme Court said there can be a Fourth Amendment violation even if there's no physical trespass. So now we know that the Fourth Amendment can be violated even though there's no physical trespass, but you might not have a remedy for that violation because trespass isn't as broad as the Fourth Amendment itself. If the government discriminates against me, the federal government, federal officials, because I'm a person of color, because of my religion, that might not violate. It withholds money from me that I'm otherwise entitled to, and it gives it to people of different religions or races, but not to me. That might very clearly violate federal constitutional rights, but it might not violate any common law trespass or tort right that an ordinary individual might have. Stuff like that.
Okay, and so is there not a federal path to remedy? Like there's no chance for somebody to find their way into a federal court?
Well, historically, there have been a couple of ways. One is, you've heard it alluded to before, Bivens, which was handed down by the United States Supreme Court shortly after Katz. Katz is, I think, 68, Bivens is 73 or something. And so as it really became clear to people that there could be a Fourth Amendment violation without a state law remedy, the Supreme Court said, we're going to infer a direct federal remedy directly under the Constitution for damages. But as you've also heard, Bivens has been hollowed out in the years since then. You've also heard reference to a statute called 1983. It dates back to the Reconstruction era after the Civil War, and it is a federal statute that gives people a remedy for federal constitutional violations, but only federal constitutional violations typically by state and local officials. And you say, well, why didn't Congress create a remedy against federal officials? And a cynic might say, well, if you create a remedy, if the Congress creates a remedy against federal officials, those federal officials when they violate the Constitution, are going to pay out. They're going to want indemnification from the federal government, and that's going to raise costs for the federal fisc. And Congress might not want, they're perfectly happy to give remedies against, folks in Maryland officers who misbehave, but they, in their infinite wisdom, and I have many students in Congress. 4 of my students are senators of the United States. I don't mean to be disrespectful, but Congress has been less vigilant about protecting against federal wrongdoing. It's been more vigilant against protecting against state wrongdoing. Now, if you read the Federalist Papers, I especially commend to you Federalist 35. The Federalist Papers say states should protect us against the federal government in the same way that the federal government can protect us against states. Each government should be able to give us remedies against the other. Excuse me, I think that's Federalist 38. I may have misspoken. Sorry about that.
Okay, no, I have a final question. We have now heard a couple of times that Bivens was hollowed out. Can you explain what you mean by hollowed out? Like how does a ruling become hollowed out over time?
What the court giveth with one hand, in Bivens, it hath taken away in subsequent cases. Bivens was about the Fourth Amendment, but the court has said, oh, we don't want to recognize similar causes of action for damages in situations where the Eighth Amendment is violated or equality concerns are violated, maybe First Amendment rights are violated. Where there's special reasons for sensitivity involving national security, the military, we're cutting back. So partly Bivens just hasn't been extended an inch beyond what it gave on the facts of that case. In addition, there are immunities that the court has recognized for Bivens actions against federal officials that were not historically recognized when state law trespass, for example, was used to sue a federal officer, like the quote that I gave you about a woman being searched under her nightgown or something like that. So both because of various immunity doctrines that have been read into Bivens, because Bivens hasn't been extended beyond a certain kind of Fourth Amendment violation, because Bivens is only a remedy against individual officers, whereas it's possible you might be able to provide broader entity liability for departments, because Bivens has no punitive damages component. There's an issue about whether a state could actually go even further. 1983 sometimes allows punitive damages against state officials. So there are all sorts of ways in which Bivens has been hollowed out. And finally, it's been hollowed out because some judges have thought that they were making things up, that they were uneasy about federal judges fashioning very robust remedies on their own, but they might be, because these are justices who very much, many of them, and many are my friends and affiliates, they do believe in states' rights in all sorts of ways. And if a state like Maryland or Utah or Connecticut or California, Illinois, et cetera, New Jersey, New York, were to pass such a law, they might very well say, gee, we can't create this on our own, but states can. Just to remind you, when the shoe was on the other foot, when it came to abortion rights, many conservatives on the court said, gee, federal courts shouldn't create abortion rights on their own, but states are allowed to, a state like Maryland. So the reasons for certain caution that has motivated some anti-Bivens justices might not apply here. I can't guarantee you that the Supreme Court would uphold this law. I need to be honest with the committee, and there are lots of complexities here.
Yeah, when you were talking, I was literally thinking, what are the chances this gets upheld? So I really appreciate your insights. We haven't heard a bill like this really in detail. So thank you very much, Professor. Thank you.
Thank you. Delegate Moreno?
Madam Chair. Professor, can you describe a circumstance where a plaintiff will be able to defend that their case remain in a state court versus being removed to a federal court majority of the times?
I think they would be able to remove to a federal court almost invariably under federal officer removal statutes that date back to the 18-teens and the 1830s. So what this law is not about is state trial courts or state appellate courts or even state Supreme Courts, being the early decision makers. In any event, things would be reviewable by the United States Supreme Court. So, but a suit could be brought in state trial court, but it will immediately be removed to federal court. But the federal court actually under Erie and other, federalism doctrines will have to apply state law where it applies. And without this statute, there's basically no cause of action. So this is not about state courts, state trial courts versus federal trial courts. It's about state law providing a remedy. Let me give you another example just so you see it in a slightly different context. Suppose the federal government just grabs my home because it's, for the federal government's point of view, very conveniently located, and they'd like to run a road through it, build a fort, a federal dam, maybe for all good purposes, but the Fifth Amendment says they can't take my private property for public use without just compensation. But suppose they just do that. They just take it. What law from time immemorial got me into a court of some sort? And the answer was state property law got me into court, even if very quickly that a lawsuit was going to be, at least since 1815, removed to a federal district court. And from there, a federal court of appeals and the United States Supreme Court.
Okay, so in the end, this law is not meaningless. It does have some meaning to being enacted, correct?
If I could be really blunt, it got me tenure at Yale Law School at a ridiculously young age because, and if it were just, a nothing burger.
I would like to give you tenure all over again because you're doing a great job fighting your thesis right now. So thank you.
Thank you.
Okay, that was pretty funny. Delegate Embry.
Thank you, and thank you, Delegate, for bringing this. And I feel like I'm back in law school. It's amazing hearing. I know you're working on all the favorable amendments, but there was one that I wanted to make sure I understood the thinking in the original bill, that judicial officers were called out specifically, and whether that's based on other. I'm so sorry.
I don't know if it's because people are talking.
I'm sorry.
Yeah.
I know you're working on the favorable amendments, all the suggestions, but the one I wanted to understand the rationale for was the specificity of judicial officers in the bill as introduced, and whether that is from other bills, other statutes, or what was the thinking behind specifically naming judicial officers? And I assume that means judges. It's not defined, but presumably it's judges.
Did you? Yeah, I think so. I took I sort of worked with a couple folks to draft something and was up on drafting deadlines. So I have to be honest, that's why there were a lot of legitimate issues, including that one, that have been brought to my attention. And I just didn't have time to fix things with the filing deadlines. And so I understand the concerns that are associated with that. And that's one of many things that we're sort of working through to try to address. So I think we're going to be able to address that.
Terrific. Thank you.
Great, thank you.
If I could just jump in on that one just very quickly.
Sure.
My own view would be it's a mistake to try to hold judges in general liable. When judges make a mistake, the proper remedy is not civil damages against them, but appeals. Other officers might be different issue, court marshals or bailiffs or the rest. When I testified in person on this issue in the other chamber about a week ago, when it was the first time I'd been in your beautiful city, and what a beautiful complex you have, I did advise against applying this to judges, and the sponsor of the bill, I think, suggested that was a set of amendments that were going to be considered.
Thank you. Delegate McComas.
Thank you, Madam Chair. Professor, is there any way you could send us a good synopsis of where we are, or maybe that treatise that you had that got you your early position in school?
I would be happy to share with the committee and anyone else a couple of articles that I've written, and also I think a very good analysis of the Illinois bill recently done by Professor former Dean Vic Amar, formerly of the University of Illinois College of Law, now at the University of California, Davis School of Law.
Yeah,
Happy to share those with
anything that could
staffers.
clarify it, because it's been a long time since I've been in law school and my brain's kind of fried at this point, so thank you.
Can I just mention on that my testimony references, I think we either linked it, Delegate McComas, I just wanted to let you know that my testimony That's okay. My testimony links to one of the thorough analyses that are out. It's lengthy, but that's in my testimony. And then we'll work with the professor to take anything else that he shares with us, and we'll make sure that it gets to the committee.
I just kind of want to understand it so that I know which way I want to vote.
Right. So I just wanted to point you to the fact that some of the analysis he's referencing is linked to my testimony.
In case it's a useful resource in response to your question as well, one of the other states that has a legislature that's moving on legislation that's very similar to this one, the Massachusetts Senate just introduced a bill on this, and the Senate President pro tempore there, who's the sponsor of the bill, posted a blog actually where he talks through the reasoning for the bill structure in a lot of these different regards. And I think it's very concise and very on point in case it's useful. Sure.
Thank you all. This has been absolutely a treat. I will tell you honestly. It's been a treat. And, you know, we in this committee, we have a bunch of lawyers, and we are all super excited to analyze. We have a bunch of non-lawyers who are still very analytical, and it's just a very interesting topic. And I appreciate you all for being here. And Professor Amar, thank you so much for taking us back to law school and just giving us an opportunity to truly think through everything. We will be, I'm sure, going through some of the material that you provide us. If you could provide that to us, it would be great. And if you provide it through the delegate, however you want to, however we can accommodate, that would be wonderful. Everyone, thank you for being here and providing your testimony. We have more testimony to come, so we have another panel, but members, I don't see any more questions, so we're going to excuse this panel and we'll move to our next panel. Again, thank you. So favorable with amendment, we have Carrie Hansel. Favorable with amendment, Mark Pennack. Sarah Sample, and Kristen Mack, all favorable with amendment.
What do you want to say to Sarah Sample? Okay, cancel.
Siri is such, oh, why do I say her name? Okay, we're done. We're done with her. I don't know if Sarah Sample left, but maybe if she comes in, she can testify. So Carrie, want to start with you, or does anyone else prefer to start?
Thank you, Madam Chair. I'm happy to start, and thank you to the Vice Chair and the sponsors as well.
I'm sorry, I just want to clarify. Is Ms. Hansel here?
I'm Carrie Hansel.
Oh, sorry, sir.
That's okay.
Okay, okay.
Listen, growing up with that name, if you ever heard the country song, A Boy Named Sue, that would tell you what it was like, and I happen to be the third. So my father went through that, my grandfather went through that, and I think they wished it on me on purpose. So.
It's a rite of passage, okay.
It was indeed. It was indeed.
Thank you so much. And my apologies, but you may begin.
Thank you, Madam Chair, Madam Vice Chair. I want to commend the speakers that have already spoken. What a great group of folks from the national level, right? But I am here to represent a coalition of Maryland civil rights lawyers. 13 civil rights lawyers here in the state of Maryland from 10 different law firms with a collective 150 plus years of experience. I'm here to support the tenor and intent of this bill, which is tremendous and will give us a critical tool to protect Marylanders here. However, there's not a single practicing civil rights lawyer in the state of Maryland who supports this bill as written. As written, it will do more harm than good. And it breaks my heart to say that because I understand the intent of it, and I understand and admire the brilliant work that has gone into it so far. Here's the issue. This bill, for the first time in Maryland history, enshrines qualified immunity into Maryland law. That creates an almost insurmountable hurdle in the law for us in bringing these cases. Why is that such a problem? Because there are efforts judicially and legislatively at the national level to get rid of qualified immunity. If they're successful, but we've married it into Maryland law here, we will not enjoy the benefit of all of those efforts. And I'm involved in some of them, and some of them are on the precipice of success. So please, I urge you, do not pass a bill with the words qualified immunity in it. There is a simple fix that protects all current immunities that everyone has. You take out the specific reference to any sort of immunity, whether it's qualified, absolute, or otherwise, and replace it with simple language that says, officers or defendants will enjoy whatever immunity is otherwise applicable. And if I just may finish my sentence, what that means is we would preserve qualified immunity now while it applies at the federal level, but when we are successful, and I promise you, Madam Chair, we will be, when we are successful in getting qualified immunity struck down, which is an odious, racist doctrine that was designed to hurt the Freedom Riders in 1967 in a case called Pearson. When we get that struck down, if qualified immunity is not in this bill, instead, if it says whatever immunities are otherwise applicable, then we will be safe here in Maryland, and our law will keep up with the rest of the country. If we enshrine it in the meantime, this racist doctrine, we might be stuck with it forever. Thank you, Madam Chair.
Thank you very much. Mr. Pinnock.
Thank you, Madam Chair. Mark Pinnock, I'm president of Maryland Shall Issue. I'm not here to defend the actions of federal agents, but I am here to bring to the committee's attention the benefit I had is representing the federal agents, federal officers in the United States Supreme Court and all the federal courts of appeals in the country for 3.5 decades at the U.S. Department of Justice. So you have my written testimony that shows all the defenses that may be mounted and that this committee may not abrogate under the Supremacy Clause, chief of which is the Westfall Act. Now, there's an open question under the Westfall Act whether the exception under the Westfall Act for suits brought for violations of the Constitution, whether or not that would include a statutory cause of action, which is what this bill does. That bill, as I recall from the legislative history, and believe me, I've litigated the Westfall Act endlessly, including in Osborne versus Haley in the U.S. Supreme Court case that governs this area. That was intended to protect Bivens' cause of action for the statutory. There is no statutory cause of action at all. It's implied under the Constitution itself. It's a very narrow exception, and there's only 3 categories that Bivens' actions, type of actions are allowed. And they're set forth, and the citations are in my written testimony. So if you, that will be an issue for the courts. Now, there's no decision on that one way or the other. But if there is, I'm willing to bet that the U.S. Department of Justice will make this argument that it was intended only to protect those kinds of actions. Now, as to other matters, this bill, along with HB 351, confuses 1983 actions as somehow applicable to federal officers. It is not. It's only for causes of action brought under color of state law, for actions by law enforcement officers under state law. You cannot bring a 1983 action against a federal official, period, full stop. So please, that bill has to be amended. Thank you.
And last but not least,
Kristen Mack.
Thank you. If you're on the other page. Thank you, Kristen Mack. Thank you.
Thank you. Madam Chair, Vice Chair, and members of the committee, thank you for allowing me to be here today. My name is Kristen Mack, and I'm a very proud and devout civil rights attorney. I have the pleasure of working with Mr. Hansel, and this is all we do. So we come with a lot of experience here to tell you why the purpose of this bill is wonderful. As it's currently written, it absolutely cannot pass. It would do more harm than good. HB 332 is designed to give people in Maryland a state law remedy when officials acting under the color of law would violate their constitutional rights, particularly as federal courts have sharply limited remedies for abuses by federal actors. Marylanders should not lose their rights at the courthouse door simply because it was a federal agent and not a local or state agent. However, how it's currently drafted, it would for the first time enshrine qualified immunity into state law. We cannot let that happen. Qualified immunity is a judge-made doctrine that essentially blocks relief, even for the most egregious conduct, unless a plaintiff can point to a prior case with nearly identical facts. It just doesn't happen very often. New scholarship shows that we have a pathway to get rid of it for good. And right now is the time to act on that. So this bill would give us the tools necessary to fight that. And the fix is really simple. Instead of saying absolute or qualified immunity, we should just use neutral language, just like Mr. Hansel said. I'm not going to harp on that anymore because he covered that pretty well. But I also respectfully urge 3 technical changes reflected in the proposed language that I submitted. First, exempt these claims from the non-economic damages cap under Courts and Judicial Proceeding 11-108, so that the remedy has the same deterrent as the 1983 statute. Second, we need to clarify that this bill does not alter existing state or local tort claims acts. So all the immunities that apply now would still apply. And third, we need to include a severability clause so that if one portion of this bill is not held up, the rest of it will be. So I urge a favorable report with amendments. Thank you.
Thank you. Members, do we have any questions? Delegate Ericon.
Thank you, Madam Chair. Thank you, guys. Okay, so now I'm even more confused, so thank you so much. Okay, so you guys had, I got your amendments that you wanted about qualified immunity. I understand that concept. But it seems like maybe there's a disagreement between the first panel and the second panel on what Westfall is, and I'm trying to, and the impact it'll have. So, and I guess maybe what I really just want to ask you guys is, what do you think the chances are that, even if we amend this bill to satisfy your concerns, does it stand once it's challenged?
Sure. The short answer is yes. Once it is properly amended to reflect the concerns that we've raised and we've provided those amendments, I think it does survive. I'm here on behalf of the 13 lawyers who will be defending it in court when it is challenged, because it is our clients who will bring these claims, and when the federal government steps in and says you have no case, we'll be at the tip of that spear. And it's a lift, okay? So it's not a slam dunk, it's a lift. But as civil rights lawyers, that's what we do. And the people on the letterhead that we've provided, you'll recognize those names. They include former judges, they include former members of this body. These are people that can handle the lift. So I think if you give us this tool, we will protect it in the courts.
Okay.
Yeah. So if I could respond to that, the Westfall Act immunizes federal employees for the conduct taken in the scope of their employment. It's full stop. Whenever there's a certification issued by the Attorney General or his designee, usually the U.S. Attorney's Office, the case is immediately removed to federal court, and the United States is substituted for the employee, and the employee is out altogether. That means the plaintiff in such action is remitted to whatever remedies he may or may not have under the Federal Tort Claims Act. That's you see it in my written testimony and citations. There is a remedy under the Federal Tort Claims Act for actions which were a violation of the Fourth Amendment. You see that in 2780H. It's the citations again are in the written testimony. But if it's not a remedy provided by the Federal Tort Claims Act, the case is dismissed. I mean, there's legions of cases on this. That means the plaintiff loses, period, full stop. So the question is whether or not you can issue a Westfall Act certification for a Bivens claim. The answer is no. Okay. It's very clear on that. But this statute is not a cause of action that lies under the Constitution itself. It lies as a statutory cause of action created by the state. Mm-hmm. So that's a different cause of action than a Bivens claim. The question will be whether that sort of cause of action, it falls within the exception for actions brought under the Constitution. And I will tell you for a certainty that the U.S. Department of Justice will argue that there is no exception for the statutory cause of action, that they all fall under the Westfall Act, and they will vigorously defend that.
Okay, so that's kind of what we'll end up getting there. Today, for those of you who do represent clients, if somebody comes in with a case like this, how do you handle it today?
So if historically we had Bivens, Bivens was from about the 1970s forward. Prior to that, as Professor Amar said, we had common law that we used to be able to apply against federal officers. Slowly, the courts created immunities for those common law claims. They fell by the wayside. In the 1970s, when the Supreme Court realized there's going to be this gap, right? Because Section 1983 gives us a remedy against state and local officers, but none against federal officers. So will we have that egg on our face as the Supreme Court? They said, no, we'll give you a remedy, it's Bivens. And that was in the 70s. Then what happened? And the most recent case you asked earlier is Egbert versus Boulay from the Supreme Court. That happened to involve, interestingly, since we're here talking about ICE, that was a case that involved a Border Patrol agent. Okay, they're cousins in the Border Patrol. And the thing to understand is that having granted this Bivens relief, which effectively in the 70s replaced these common law claims of trespass and the others that Professor Amar talked about, the Supreme Court then engaged upon a long-standing campaign to slowly carve those rights away. And those of us in this field now believe they're effectively gone. So in answer to your question, if somebody comes in and it's a state officer, we have the State and Local Government Tort Claims Acts. Our amendments to this bill are specifically designed to keep all of that neutral. In other words, to keep state and local officers exactly where they are. If it's a federal officer, I have to ask the question, can I shoehorn it into what is left of Bivens? And that is probably 1 in 100 cases. If you sat and watched what happened in Minneapolis, 99 out of 100 people that brought a tear to your eye, and I mean people who were clearly heinously abused, would have no case against that officer under Bivens. Now, could we struggle to find a workaround, maybe in some peculiarity of the law out there? Maybe, but unlikely. So most of the cases that we would bring would get dismissed, probably 99 out of 100 under Bivens. Now, as civil rights lawyers, do we bring them anyway? Sure, because we're tough-skinned people and we're used to, banging our heads against the wall. That's our job. But 99 out of 100 of them we would lose. And this fills that gap, but only if we don't shackle ourselves to qualified immunity. And I'm sorry to raise it again, but it's why there's not a single Maryland practitioner testifying in favor of this bill without amendments. All of us. And the lawyers on we submitted a sheet with a letterhead we made up. Those are lawyers you couldn't get to agree on any one thing, okay? You're going to see some large personalities on that list, and every single one of them are urging you to please make this amendment, get qualified immunity out of the bill, but protect the concerns that are being raised by the proponents, which is we have to provide the same immunity that they already have. Great, do it. Just put that in the bill. You have whatever immunity you already have. And then when we defeat qualified immunity at the federal level, they won't have it anymore, and it'll be gone. But right now, 99 out of 100 of these cases is not a case. And that's the gap this fills after the Supreme Court has stripped away those most, really, of Bivens. And that's the short answer.
So there is a nuance here, and that's in 2680H under the Federal Tort Claims Act. That allows a suit under the Federal Tort Claims Act for investigative or law enforcement officers for assault, battery, false imprisonment, false arrest, abusive process, or malicious prosecution. That can be brought against the United States by name under the Federal Tort Claims Act, and those suits would remain, regardless of this bill, one way or the other. Now, you can't limit that anyway. That's a matter of federal sovereign immunity, and United States sovereign immunity is strictly construed, like state sovereign immunity is. So you still have the remedy provided by the Federal Tort Claims Act against some of these abuses, but the suits are not against the individual. They are against the United States only.
And that's the key to understanding. Because if you want to stop this, it's the officer in the street pulling the trigger. And the problem with the existing remedies that Mr. Pennick, and I have enormous respect for him and his experience, and he's exactly right. What he said is exactly right. But why that, to me, doesn't provide me the tool I need to put a stop to keep Baltimore, frankly, where I live and work, from becoming another Minneapolis, is because it doesn't have any meaningful teeth against the officer whose finger is on the trigger. And absent that officer knowing that the people of Maryland are going to hold him or her responsible, if he's told, as some officers have been, hey, you're going to be immune, don't worry about it.
So
that's where the risk is.
I would reinforce the point that was made by the first panel that you heard in support of this bill, is you can't single out federal law enforcement. There's intergovernmental immunity here that makes that really clear. The United States versus California, decided on February 9th on the Maskey claim, is actually dead on point. So, and this is something I support. Why just make it limited to the U.S. constitutional violations when we have a Maryland Declaration of Rights and the Maryland Constitution, which is entitled to equal respect? Those individuals, those law enforcement officers who go off the line should equally be held liable. So I would like to see the state waive its sovereign immunity for those kind of actions, as this body can do. So those kind of remedies, and I'm with Mr. Hansel on terms of the need to deter these kind of actions, equally applicable to state officers. They shouldn't be limited just to federal officers. One, you can't, and two, you shouldn't.
So that could be a potential problem if we don't.
Well, it is a potential problem because I know the Attorney General's office doesn't like that at all, and for obvious reasons.
Yeah, okay, thanks.
And Delegate, if I may, for Bivens claims, just to put into perspective how rare these cases move forward. I'm part of a larger group, a national group called the National Police Accountability Project. And it's a phenomenal listserv, and that's really the reason I'm part of it. But when someone wins a Bivens motion, like we all celebrate it for weeks. And this is hundreds of civil rights attorneys from all across the country, from every jurisdiction you can imagine. Like we all just like want to go out and have drinks after, like remotely with each other, because it's just so rare.
Zoom drinks.
Yes.
I have one more qualified immunity and absolute immunity cases on the other side of this question than I can count. In all the federal courts of which I've been into, I don't think I've ever lost a qualified immunity case once.
For the defense.
For the defense.
Right.
So Mr. Hansel is completely correct. I mean, it's a complete barrier. So it's very effective.
Okay. Thank you. Thank you very much.
Madam Chair.
Don't go anywhere. Delegate Moreno.
Thank you, Madam Speaker. Has the bill sponsor been amenable to these amendments, or is there?
Yes, and I want to redouble my support for her, for the bill, for the sponsors also on the other side. We've had wonderful, wonderful conversations. We're going to continue to do that, and so absolutely. And if I wasn't clear about that, I apologize to the sponsor.
I may have not heard some like writing questions probably, but thank you.
And I will say that the bill sponsor had to leave for a subcommittee hearing, and she did text me that she is working with the favorable with amendment panel. Delegate Cardin.
Thank you, Madam Chair. Thank you all for your very compelling testimony. This is from Mr. Hansel. I'm looking at line 15, I guess, and 16 on the bill. A defendant in an action under this section may assert a defense of absolute or qualified immunity to the same extent as a person sued under 14 U.S.C. 1983. So are you saying that you just need to get rid of absolute or qualified? A person may assert a defense of immunity to the same extent they can under 1983, or just?
So the amendments, yes, that would work. So in short, yes. However, I think there's a little more nuance that's important to not make radical changes in connection with state and local officers. Now, I'm with Mr. Pennick. Immunity of any type shouldn't exist. The first and highest duty that is ever owed under law ought to be from the government to the people who give it its power. So I'm against any form of immunity. However, I'm not here to ask that, as Mr. Pennick is, because I know the brick wall that I'd be banging my head up against if I did. Okay, so I'm not. I have a much more modest request, and here would be my proposed edit. If we edit it the way you suggested, Mr. Delegate, the problem would be we might be opening the door for waiving state and local immunities. Instead, I would strike, and if our testimony on behalf of the Maryland Civil Rights Coalition looks like this, and we've attached our proposal, but our proposal would strike that language, and in the next, in line 18 and 19, what is now, I think, paragraph 2. So we'd strike the first part, and the second part would read as follows. Any defense of, strike sovereign, immunity, otherwise applicable at the time the action here under accrues, Why is that important? First of all, we're getting rid of the reference to qualified immunity. Second of all, we are saying to every officer, local, state, federal, whomever, whatever you have, you've got it. You're keeping it. And that's the way to make it clear. Any defense of strike sovereign, any defense of immunity, that's every possible type of immunity, otherwise applicable at the time of the action hereunder, otherwise applicable at the time the action hereunder accrues. Why is that second part important? The most important thing I have to say to you is this. We are working to defeat qualified immunity at the federal level. That's why it should say any defense of immunity applicable at the time the action accrues, because if we are successful and if qualified immunity is defeated, we don't want to have tied our hands here in Maryland. We want to give people whatever they deserve at that moment. So if a year from now qualified immunity is defeated, 6 months after that there are federal agents on the streets of Baltimore, I have a tool to hold them responsible without qualified immunity. However, this language would also ensure that local state officers keep all of their immunity. Because when we were in the other chamber, the Maryland counties came in and said, you know, we want the counties out of this. This language is designed to give them exactly what they have now and forever. Right. So whatever immunity they otherwise have, they would keep forever.
Thank you.
I would like to add one point on that. The reference to Section 1983 should be struck from any piece of legislation applicable to federal officers. It has no bearing, it's apples and oranges. So please, please do not incorporate 1983 into this bill in any shape or form.
Yeah, we had that amendment as well. That's more technical, but we had that.
Yep, we saw that. Thank you.
Okay, thank you very much.
Thank you, Madam Chair.
Appreciate your testimony.
Thank you.
But can we still call it Converse 1983, Mr. Pinnock? That's just a joke. That's a joke. That's a joke. Okay, thank you so much. I appreciate you all being here. And yes, and Mr. Hansel, I've met you before. I apologize.
Not a problem.
Actually, I'm gonna let Kaufman go, and then I'll go to. Okay, Delegate Kaufman, you've been patiently waiting. All right, this is going to be House Bill 526 with Delegate Kaufman. He has provided an amendment. If you all might, you should have it in your inboxes. So we have Patrick Thronson, George Tolley, oh, there we are, and Asar Miller. Mr. Miller, okay.
Okay, hold on. Boy, I miss those Lincoln Douglas debates in the committee.
We miss you.
Well, I wanted to, first of all, I wanted to just talk about the amendments, since the chair talked about it, and I wanted to, there was a lot of opposition, but I only found out about it, late this week because because testimony sign up was at the end of, 5 o'clock on Monday. So the first thing we're doing is we're taking state and local governments out of it. And so we're hoping that that means that MML will be neutral. The second thing we're doing in response to concerns is we are extending the time that it takes to pay, that you can wait to pay. The third thing that we're doing is there was objection to where it said written or oral agreements, and so we're just changing it to written. So good afternoon, Chair Bartlett, Vice Chair Davis, and members of the committee. My name is, for the record, is Delegate Aaron Kaufman, and I'm here to request a favorable report on HB 526, Settlement Agreements, Payments, and Release. HB 526 addresses a practical but deeply consequential gap in Maryland law. When parties resolve a civil lawsuit for money damages through a settlement agreement, Maryland statute does not currently require the settling defendant or insurer to provide a release within a defined period of time, nor to issue payment within a specific time frame after the agreement is finalized. As a result, even after both sides have agreed to resolve the case, plaintiffs can wait weeks, or in some cases months, before receiving the funds that were promised. I understand the insurers are opposed to this, and that makes sense because they are the ones that have to pay out most of these. But for many Maryland families, settlement proceedings are not discretionary. They are intended to cover medical expenses, rehabilitation, rent, or mortgage payments, child care, and lost wages. Once the case is resolved, individuals reasonably expect closure. Instead, delays in payment can trigger collections, financial instability, and additional stress at a time when stability is most needed. The policy rationale for my bill is grounded in economic reality. According to the Federal Reserve, a study of economic well-being of U.S. households, 37% of adults would not be able to cover a $400 emergency expense using cash or its equivalent. That means more than 1 in 3 households lack even minimal financial cushion. When an injured Marylander is waiting on a settlement check that has already been agreed upon, delay is not merely administrative. It can mean missed rent, delayed medical care, or mounting debt. Other states have recognized this issue and acted, so my bill is not radical. Illinois requires payment of a settlement within 30 days after receipt of a signed agreement, and New York State requires payment within 21 days, both with accountability measures for noncompliance. Maryland currently has no comparable safeguards. HB 526 establishes a clear and reasonable framework. It requires a settling defendant to provide a proposed release within a specified period and to pay all the sums with a defined time frame after execution of the release. If they do this, there aren't any penalties. It protects lawful third-party recovery interests and provides for accrual of interest when payment is not timely made. Importantly, the bill expressly provides that the section does not apply to a person paying for a settlement with personal assets. The purpose of this exemption is to ensure that private individuals who are not insurers or institutional defendants are not subject to statutory timing requirements designed to address systemic payment delays. Finally, for these reasons, I respectfully request a favorable report on House Bill 526. Thank you. I'm happy to answer any questions.
Thank you, Delegate. And whoever's ready to go next.
Thank you. Good afternoon, Madam Chair, Madam Vice Chair, and members of the committee, and thank you, Delegate Kaufman. My name is Patrick Thronson. I'm an attorney in private practice in Baltimore County, and I appear today on behalf of the Maryland Association for Justice. We are in strong support of HB 526 as introduced and as amended. When injured Marylanders agree to settle a tort claim, they relinquish their fundamental right to trial in exchange for the certainty and the immediacy of financial compensation. Yet far too often, insurance companies delay paying these agreed-upon funds for months, even a year. They have a powerful financial incentive to do so. Warren Buffett once explained this incentive in a 2009 letter to shareholders. Quote, "Insurers receive premiums up front and pay claims later. This collect now, pay later model leaves us holding large sums, money we call float, that will eventually go to others. Meanwhile, we get to invest this float for Berkshire Hathaway's benefit. This combination allows us to enjoy the use of free money and, better yet, get paid for holding it. While insurers profit from investment float on improperly withheld settlement funds, injured people face mounting financial pressure, including medical bills, lost income, transportation costs, and housing instability. Delayed settlement payments force many into higher interest loans, deeper debt, or even foreclosure or eviction. HB 526 offers a simple, balanced solution. Once a settlement was reached, the defendant must provide a proposed release within 15 days. As amended, after the plaintiff executes that release, the defendant has 30 days to pay the settlement funds. If these deadlines are not met, the settlement amount accrues at the statutory post-judgment rate of interest, just as a judgment would. essentially, the statute treats settlements just like judgments. The bill allows parties to agree to different timelines where appropriate. For these reasons and others, we urge a favorable report. Thank you very much.
Good afternoon, Madam Chair and the members of the committee. My name is Ansar Miller Abdullah. I'm here representing my family and also my daughter, Yara Shahada Miller Abdullah. I think I'm here to give human impact to a judiciary issue. My family has experienced firsthand when there are no firm timelines, the impact and strain that it can have on a family. After we sat down and came to our agreement, we believed we were finally taking the first steps towards closure. But that closure never came, at least not immediately. We sat and we waited, and every time our attorney called and had no updates, it left an emptiness in us. It wasn't just about a delay in payment or paperwork. It was about an extension of emotional suffering for my entire family. Days turned into weeks, weeks turned into months, and in my case, it turned into a whole year. A year of uncertainty, a year of being stuck in limbo, a year where healing felt like it was out of reach. During that time, my family was trying to pick up the pieces of our lives. We were trying to breathe again. But the weight kept reopening wounds that were already so deep. And while all of this was happening, my wife was suffering with her own health conditions. The stress of not knowing, constantly waiting, added weight that her body and her mind simply did not need. When family reach settlements, they are often at one of the most fragile moments of their lives. They are grieving, they are exhausted, they are trying to find a path forward. Unnecessary delays slow that process down immensely and prolong pain. House Bill 526 matters because it brings accountability and compassion in the system that families rely on during the most valuable times. Families deserve closure, families deserve timely resolution, and families deserve a chance to begin the healing process on their terms. I respectfully urge a favorable report on House Bill 526. Thank you.
Good afternoon, Madam Chair, Madam Vice Chair, members of the Judiciary Committee. My name is George Tolley, and I represented the Miller family, Mr. Miller and his wife and his family, in the case he just told you about. If you had told me before that we would enter into an agreement to settle a case for a certain amount of money on a Friday in August, and I wouldn't get a written first draft release until the following May, I would have said, that's crazy. That doesn't happen. What happened in this case is it was a pre-suit negotiation. So there's no scheduling order. There's no judge to go to. Most tort cases settle pre-suit. There's no externally imposed timeline. It's what you can get done, when you can get it done. And that's the problem, right? This is an outlier. It's never happened before. I hope it never happens again. But the problem exists, and for this family is just an example of families who have experienced, if not the same thing, they experience months of delay. And I can report, it takes months to settle cases now. After the mediation, when it used to take weeks, it takes over a month sometimes to get the check after the release is signed, when I used to trade the signed release for the check when I started practicing. So I don't know why, and there's a whole army of people signed up against this bill, and they can maybe explain to you why it's okay for this family to wait a year or other families to wait months for the closure that they negotiated and for the closure they deserve. I just want to repeat what was said before. Justice delayed is justice diminished. And all this bill does is set up guidelines, guardrails that can be negotiated. And it's a good bill, and I ask for a favorable report. Thank you so much.
Thank you. Members, do you have any questions? Delegate Simmons?
Thank you, Madam Chair, and appreciate you bringing this legislation. So you spoke about being able to represent him on the case. So let me ask you an idea of a settlement hearing. So a lot of us are not attorneys and don't participate in that process, right? At any time during the process of settlement, is there any discussion of a timeline around deliverance of the physical check to the client after the settlement has been made?
I can't speak to every negotiation that happens.
Give me any.
In my experience, certainly my more recent experience, it's a conversation we have in every case now. And often before mediation, my firm has taken up the practice of sending out a list of stipulations we would like to have on the table to discuss. But that's because we've had the experience. I don't expect that that's the practice of everyone. It's certainly not the standard of care, I don't believe.
So there is a process.
But there is a way to negotiate these things.
Okay.
Having a law that sets the table for that discussion would help, because it's easy for the other side to say, well, no, we're just not going to agree to any of that. You see that a lot. No, we're just not going to agree to produce the check within 25 days.
So is it not your responsibility as his attorney to kind of cross those T's and dot those I's with that agreement at the end?
I struggled for 9 months trying to figure out what I could do, how I could elevate this issue and get a release. I struggled. And there's no, I mean, we have an agreement. And sure. And overwhelmingly, speaking generally, these agreements are confidential. I can't file a lawsuit because they didn't honor a confidential agreement, right? So my hands are tied. I can't go to the court now because we've got an agreement, but I can't do anything else either. I am waiting for, now I don't know if it was the defendant, I don't know if it was their lawyers, I don't know if it's their insurance company. Sure. I didn't get satisfaction. At one point, the defense lawyer took some of the blame.
Sure.
But 9 months.
Sure.
If there was this stick that this bill provides, along with a carrot to negotiate and talk it through and reach some kind of an agreement beforehand, we could avoid these kinds of, this kind of a problem.
Sure, I appreciate that. I think what I'm trying to ask you is, so you're referencing him in your testimony. For his case, was there any written agreement to a specific timeline of when, based on the case being settled, to the check being delivered to your client as it's passed through your office?
No.
Okay, thank you.
Delegate Phillips.
Thank you, Madam Chair. And I did a little bit of personal injury work back in the day, and you made a comment that I was more familiar with. You settle a case and you exchange the release for the check. What has changed in the industry from what you have seen today? And then help me understand what writing would begin the clock. What would you need? Could it be just an email from, because often that's what I remember, an email that says, yes, we agreed to $10,000.
So I've never practiced as a defense lawyer, and so I'm only familiar with the process that they go through from what they tell me. I understand that from time to time, sometimes they would issue a check, and the plaintiff's lawyer would have delayed settling a lien or getting information from Medicare. And some of that is in the opposition, written opposition that you've seen, the complaints that unexpected delays cause problems. And so that's why I'm told now we're not going to even ask that a check be cut until after we have the release in hand. And your experience and my experience were very similar until it's been years since I've been able to exchange a signed release, even notarized release for the check. Years. If the problem is Medicare or Medicaid or liens, typically there are, again, generally speaking, provisions in every release I'm familiar with that I've ever seen from a defense lawyer worth their salt that indemnify the defendants so that if there is a lien that some Medicare comes after them, my client's the one who's on the hook, more my firm. And that's why we're ever so careful to make sure that doesn't happen. But I think what you may hear from the opponents is they're nervous about the possibility, and they want to be sure every duck is in a row and every I is dotted and every T is crossed before they even try to write the check and have it signed. And that's why they delay. That's my impression anyway, but I urge you to ask the folks coming up.
And this is, so in your mind, the clock would start with the release, not just the agreement, let's say in an email.
So
there's a
I believe that under the statute, it would start with a memorandum of understanding at the end of a mediation. And most of my cases settle with a formal mediation, not a phone call with an adjuster. But if there's a phone call with an adjuster and a confirmatory letter, that would start the time. And it's true, sometimes a settlement agreement involving a minor child needs to be approved by a court, and that can take some time. And of course, the parties, every plaintiff lawyer I know is going to say, yeah, we'll start it 15 days after the court signs the order approving the settlement. Let's get that done as quickly as we can and cooperate to get that done quickly. The bill is written in a very flexible way, I believe, to allow, because every case is different. Every case, every circumstance is going to be different, and you need to be flexible about that. But without some guardrails to streamline or standardize this process, what we've seen over the course of years is justice delayed, and that's a problem for the folks who need the money.
Thank you. And just one more if I could. And this may be to the sponsor of the bill. If you're aware of how this is working in any other state, I know you mentioned that it is the case that it has been passed in other states.
Yes, that's correct. For example, in the state of New York, you have to get the check within 21 days. In Illinois, they get you in Illinois they get you the check within 30 days. But in terms of why the insurers dilly-dally, I don't know because I can't read minds. So.
And this bill is based on similar language to both New York and Illinois?
It is.
Thank you.
If I may add, so the delegate at the beginning mentioned some amendments, some sponsor amendments that have been formulated since Monday. To the extent that hasn't been made clear, the trial lawyers are in full support of those amendments.
Delegate Woods.
I'm wondering if you kind of asked the questions. I guess I don't understand why there isn't any legal jurisprudence that says when this happens behind that. And I want to question because you keep saying this is an outlier, right? But it doesn't sound like it's an actual outlier. It sounds like
it's an outlier. I'm sorry, I didn't mean to interrupt you.
That's okay.
Yeah, it's an outlier in the sense of the scope of the delay. I hope it's not true that there are lots of families that have had to suffer that the way this family did.
I'm sorry.
But there is delay, and delay, a month of delay that's unnecessary is diminishing justice, and that's I think why the bill is needed, because there isn't a rule. Every case is different, and it is hard to fashion a rule that isn't flexible, that applies in every single case and under every single circumstance. And so that's what this is an attempt to do, to follow the experience in other states.
Okay. I guess for me, it would just seem like there has to be some type of theory of law that follows some type of a pathway that says in these different situations, and help me understand, in some situations or circumstances, the impact on the family can cause irreparable damage. Is that not true?
I believe that is absolutely true, certainly in some cases. I think the effect of the bill is more likely than not, in my opinion, just going to lead to more discussion and negotiation about what the timeline, based on the circumstances of that case, what is the timeline that everyone can agree to? so that there's no unfortunate and unhappy surprises down the line. Yeah.
Thank you, Madam Chair.
I just wanted to say something to, about the impact to families. During the course of going through and waiting for the settlement, you were putting, and specifically I'm speaking to my family, is that we were in a balancing act of trying to figure out how to balance my wife's health and our bills. And when I say that, I mean in a matter of life or death. Is that we're waiting so long, and every call we're waiting, we're trying to figure out if we can afford her medicine. We're trying to figure out if we can afford our bills. We're trying to figure out if we can afford trips to clinical trials. And that means we had to go without in other things. I had to shutter my business. I had to stay at home and take care of her when, she couldn't get the medicine that she needed that week, or she couldn't, make the trial that she needed to make, which was all the way up in New York. So these are the real life impacts of something, to the insurance companies or to the defendants seems that is trivial, but these are the real life human impacts that can have effect on families such as mine.
Thank you. Thank you, Madam Chair.
Thank you. Delegate Conaway?
Thank you, Chair. Thank you, Delegate and panel, for coming in to testify. So, Delegate, on page 2, starting at line 10, first you have the plaintiff within 10 days after an oral or written agreement that they're going to do something. Then after that, after the agreement, and you get the signed agreement, within 15 days, the plaintiff is expected to receive all the money that's due to them after the 15 days. That's line 13.
Well,
on page 2.
Well, Delegate Conaway, quite frankly, pun intended, we did extend the timelines to 15 days and 30 days. In response to some of the opposition testimony.
The 30 days is in an amendment?
Yes, sir.
Okay. So
and you should have received that in your inbox. If you didn't, we can resend it to you.
Okay, so I just want to be clear that you have come up with the 30 days as being the standard like some of the other states have.
Yes, just like Illinois.
Yes.
And if I could, when Illinois passed this law, the sky didn't fall. So.
Okay, so in reference to falling skies, can you make any comment about the judgment interest? Someone has spoke about judgment interest. So if you're not paid within the 30 days, the sum will start to accrue interest?
Well, yes, because there has to be some incentive for insurers to pay promptly. And as you saw, from the Berkshire Hathaway quote that my friend quoted here, in many instances, it's beneficial, this isn't me, it's Warren Buffett saying, to hold on to the money as long as possible. So there has to be some sort of stick.
Sure, but how much is this interest amount?
I'm not sure. I'm going to defer to my panel.
I believe it's 10%, except in a few outlier cases.
10% what?
Annually. 10% annually.
Oh, 10% annually?
Yeah.
All right, thank you very much.
Certainly, thank you.
Delegate Taylor?
Thank you, Madam Chair, and thank you guys for being here. And miss your humor, Delegate Kaufman. And
I miss you too, Delegate.
Sorry for your, having to wait and going through what you've had to go through with your wife. I've been a caregiver, so I completely understand that. On page 2, there's reference, B2 actually, that line referenced that this section does not apply to an individual paying for a settlement with personal assets. So does that mean this bill only applies to a civil case that's against the insurance company?
That's correct. We realize that individuals may struggle to make a payment if, I hit you. And so we didn't want to penalize individuals in this way. We wanted to incentivize insurance companies who are doing quite well to pay promptly. So my goal was not to go after an individual person who commits a tort.
So there's really nowhere in statute that gives individuals any kind of parameters at all with regard to how fast they have to pay? Nowhere in our statute?
Let me defer to the lawyer.
If there is, I'm not aware of it. I can say our firm had a case more than 30 years ago against an uninsured individual. And every month we get a check for $250 because that's how the case was settled. And
Yeah.
that was the way that they could do it. And that's going to go on for, a few more years. But every month he makes the payment, which is
Yeah.
great.
It was worked out.
It worked out.
Yeah, yeah, and I'm a business owner too, so I can also understand the complexities actually of, these types of arrangements. And George, you actually mentioned, I'm sorry, attorney talking. You actually mentioned that in this bill, there's written in some flexibility. And I'm looking for it, like I'm looking for where there is flexibility to negotiate if an insurance company or other company felt that there were some extenuating circumstances or some complexities that they had to
And that wouldn't
overcome.
just be at the time of the initial settlement agreement, but at page 2, lines 21 to 23, provide that even during the time period that is initially agreed to, the parties can mutually agree to extend. All right, the point here is not to wield a cudgel and beat the insurance industry senseless, although as attractive as that may be. The point here is to set up a sort of default that can be amended to fit the needs of any individual case, but that will be a safety net for when, unfortunately, for whatever reason, the agreed to deadlines are not satisfied.
Okay, thank you. I actually didn't see that number 2 where it says sometime there's a time period where the parties may mutually agree to an extension of the time period. Okay, thank you for answering.
Thank you.
Appreciate it.
Thank you. Does the bill address alternative dispute resolution matters?
Did you say attorney's fee resolution?
No, ADR, alternative dispute resolution.
I would, not that I'm aware of, Madam Chair, but I would certainly consider that a friendly amendment if you were to add something on.
I was just curious. And the stick that we're talking about, is it anything beyond the interest? Is it something else? Is there another form of punishment or another stick?
No, it's a minor penalty. It's just the interest.
Okay, thank you. Just wanted to make sure. Okay, I see no further questions from, Delegate Conaway?
Chair, thank you very much. Very quickly. That 10% interest, is that written somewhere in?
That's the statutory rate of post-judgment interest in Maryland and has been for decades.
Per year?
Per annual, but it doesn't compound. So, I wouldn't expect it in this context that there'd be more than a year of delay, but, crazy things happen. But in a post-judgment interest context, you get 10% interest each year, but you don't get interest on the interest in year 2.
Yes, I understand. Okay, thank you.
Okay, thank you, members. Thank you, panel.
Thank you, Madam Chair.
Okay, we have another panel, unfavorable. We have Rob Enton, Nancy Egan, Carvel Collins, Grayson Wiggins, Nicole Nesbitt,
Okay, Madam Chair, Robert Enton on behalf of the American Property Casualty Insurers Association.
Can you hold just 1 second? I want to get the whole panel up. Just give me 1
I'm sorry,
second.
I thought he was.
I mean, you could have actually technically go ahead and start. Yeah, sure. Are the people, I just want to make sure the people that I mentioned are here. I see Robert Enton, I see Carvel Collins. Nancy, are you going to come up now? Okay. And then I don't see Grayson. Are you Nicole Nesbitt? I am. Okay. Okay. Mr. Enton, go ahead and start. Okay. Thank you.
Thank you. Madam Chair, once again, Robert Enton on behalf of the American Property Casualty Insurers Association. And we are opposed to this legislation. We have very serious concerns about it. I'm not sure, what happens in New York State or wherever else, if there's 1 or 2 other states that have this. But, you have one example of this problem and a massive statute that will affect every single, all types of litigation, and in particular, what we normally see, which are personal injury cases. It's all about what you've heard today is a he said, she said, but there's really not any concrete evidence whatsoever that this is a problem that needs to be addressed by legislation. And the question that got asked, well, suppose, there's a reason why they can't make the payment within whatever the 10 or 15 days, whatever you have. Well, then they can negotiate an extension. Well, of course, they can negotiate an extension if they can, but suppose they can't negotiate an extension. Suppose the plaintiff doesn't agree to an extension. Now, all of a sudden, you're going to start paying interest. The insurance companies don't have an incentive not to pay. When a case gets settled, they process it, and they pay it over. I just don't see where this is possibly a problem that needs to be addressed by legislation. And if you look at the fiscal note on the bill, the fiscal note mostly talks about what the fiscal impact is going to be on government. So we have amendments to take the government out of the bill. But if it's going to affect, here's what the fiscal note says. The Office of the Attorney General advises that the state will have a difficult to impossible time complying with the requirements of this bill. Well, okay, so to take the state out of the bill, but what about everybody else? All the carriers, private businesses, you name it. How's that not going to apply to them? We just don't see where this is a problem which merits this type of resolution, and we'd urge the committee to give the bill an unfavorable report. Thank you.
Thank you. Is Lauren Pockman in? Do you want to come on up?
There she is.
Okay.
Yes.
Okay. And Ms. Nesbitt, you can proceed.
Thank you. Madam Chair, Vice Chair, members of the committee, I appreciate the opportunity to be here. Each case being different is a reason why it is very difficult to legislate this. Because Mr. Tolley's case being a total outlier, as he said, that was a real extreme variation, but there are other cases that have different levels of variation from the time frame that are being negotiated. That being the practical application of these settlements is why it can't be legislated. Setting up a default doesn't work when there is this much violation or variation, and a statute that requires adverse parties to agree with each other can't be enforced. As it relates to the time frame, I will just make a couple of other practical points that haven't been made yet. For one, if to the extent that the parties want to negotiate a structured settlement, that takes way longer than 30 days. There are outside third parties that have to put money into a fund, and that fund is what funds the rest of the structured settlement. If there is this requirement that really can't be negotiated to the parties' agreement about how much more time is needed, then they just won't do structured settlements at all. And that is a problem for both entities, both parties. The other thing that could happen is, because we don't really know what triggers the clock on this, I could see that in order for a defendant to try to pull the money together in a way that meets the timeframes that are set forth, there's going to be something held open about the settlement so that that trigger doesn't happen yet. That's problematic because you want the parties to agree to all terms of a settlement. And if somebody is going to have to hold it open in order to not start the clock, you don't get that closure, and that's what everybody's going for. I'll also say that the separate section of this bill that relates to the IOLTA funding, to my mind, it's preempted by federal law. Both parties to a settlement have an individual obligation to pay Medicare for the lien. We can't defer that to one side. The defendant has its own obligation to pay the lien. I defer to the others on my panel. Thank you for listening.
Thank you. Mr. Collins?
Madam Chair, Madam Vice Chair, members of the committee, Carville Collins here on behalf of the Maryland Employers for Civil Justice Reform Coalition. We are comprised of many of the largest employers, businesses, and healthcare providers in Maryland. We're opposed to this legislation for what we see as unintended consequences. This bill calls for a new subtitle 11A, Payment of Settlement Agreements. It would be located right next to an existing subtitle that governs settlements, Subtitle 11, that governs structured settlements. That statute was enacted back in 2016. It establishes a set of governing rules for these settlements, structured settlements, to ensure that the transfers are effectuated on fair and reasonable terms and protect against deceptive practices. These rules govern notice, jurisdiction, registration for transferees, bonding, and other safeguards. It's a balanced statute, and as between plaintiffs and defendants, it facilitates settlements. This legislation contains not a single provision that provides the safeguards to parties that are afforded under the structured settlement statute in Subtitle 11. This bill imposes an array of prescriptive measures, such as the stringent timeline on payments, and such as provisions imposing interest on the settlement. This legislation, we believe, is out of line and out of step with Maryland's successful practice in Subtitle 11 of regulating and facilitating settlements in a fair and balanced way, and without the imposition of onerous terms and requirements. The cumulative effect of all of these requirements in this bill, that contains enough unbalanced requirements to discourage settlements, which has never been the public policy of Maryland. For these reasons, we urge an unfavorable report.
Good afternoon, everyone. My name is Nancy Egan. I'm with the American Property Casualty Insurance Association. And as you are aware, we write about 71% of all insurance here in the state of Maryland. We are in opposition to the bill. One thing that has been not pointed out by the rest of the panel is that under Maryland law, we are regulated insurance companies by the Maryland Insurance Administration. And there's a section of the code under the insurance code for Unfair Claim Settlement Practice Act. And it requires insurers to pay claims promptly, and we can be subject to fine and also to bad faith. We're not aware of the company that was involved, and we don't know the specifics of that arrangement that Mr. Tolley had described. And I just hope that they did make a complaint with the Maryland Insurance Administration to make sure that this company was following the prompt claimant sections of the Maryland Insurance Code. And for those reasons, we ask for an unfavorable report. Thank you.
Good afternoon, Chair Bartlett, Vice Chair Davis, and members of the committee. My name is Lauren Packman, and I'm Legislative and Regulatory Senior Counsel for Allstate in Maryland. I first want to refer back to the proponents panel. My comments, first of all, refer to the original bill text. We haven't seen, at least I have not seen any amendments. The bill says it applies in a tort action for damages, which I had read as a filing in a court of law, not simply a dispute between parties where a payment is anticipated. So if it comes after a complaint is filed, then the court is involved, and the court can be encouraged to intervene and threaten sanctions and, impose its will basically on a defendant that isn't paying promptly. There's no definition of a tort claim in the bill text, and I didn't see one in the underlying statute around it where it would fit, but I may have missed something. In any event, in that case, the case described by the proponents would not have been solved by this bill because it was a settlement before a lawsuit was filed. We also have concerns about the numerous unintended consequences. The rigid deadlines, even if they're a little bit longer than they were originally, are just not workable, particularly in cases involving multiple defendants or involving liens, as previous folks pointed out. The other thing I wanted to note is just that HB 526 treats all defendants the same, whether the delay is a result of compliance with other law or the result of bad intent. And operating in good faith would basically have no value in a post-526 world. For that reason, we ask for an unfavorable report. Thank you.
Thank you. Mr. Whitaker, why don't you just come on up so that we can finish out this panel? Thank you. Ms. Nesbitt, you probably have to slide down just a little bit. Well, there you go. Thank you so much.
Great. Thank you, Madam Chair and members of the committee. I'm Jake Whitaker, and on behalf of Maryland's hospitals and health systems, we're respectfully opposed to House Bill 526. So I don't want to get into all the arguments that the defense counsel has made here already. I just want to say that we echo those same concerns. I would just want to take this opportunity to kind of talk about how this uniquely impacts the hospital field. So as you may know, Maryland's hospitals operate under a unique global budget system where they have a fixed budget every year and they have fixed revenue. So that means they can't raise new revenue or new taxes, for example, like local governments. So for the same cost restraints that local governments have, we have the same. So what that means is if we're spending more money on interest or on settlements, that's money that we can't spend for care, for hiring nurses, or reducing ED wait times. And another second major issue is kind of what the panel's brought up, and that's relation to the Medicare liens. So in many lawsuits, Medicare covers the patient's medical treatment when the case is still ongoing. But when the case settles, federal law requires that the hospital pay back Medicare. And so where this is troubling is the bill basically says, and even the amended version would require us to basically pay the money before we even know when Medicare's asking us to pay. And so what's challenging is we'd have to pay Medicare and also the plaintiffs, that's double. But what's even worse for us is there's a rule that allows Medicare to reclaim double the damages. So that means we'd ultimately have to pay 3 times. So for those reasons, we respectfully request an unfavorable report. Thank you.
Thank you. Does anyone have any questions? Oh, yes, we do have questions. Ms. Egan, I was looking up what is it called? The unfair claim settlement practices. So that was my hesitation there. And I think you're referring to the section that says under A4, refuses to satisfy a claim for an arbitrary or capricious reason based on all available information, maybe that section?
And then there's a section about prompt payment.
Oh, wait, I'm sorry, and then there's number 6, fails to settle a claim promptly whenever, okay, thank you. Delegate Boucher.
Thank you, Madam Chair. Since this is civil tort, isn't it the responsibility and obligation of the 2 counselors involved in a non-disclosure statement or agreement to come to the terms and put that language into the agreement, even with the penalties? Doesn't it fall on their responsibility, not the law? That's their obligation, is it not?
I think so. I mean, look, I've been practicing law for a hell of a long time and handled a variety of different kinds of cases during my career before I started doing this. And I've never heard of this issue. I mean, I think 99% of the time, whatever it is, you know, it gets paid, and you have lawyers that are going to, you know, bug the hell out of the other lawyer if they don't get their money.
But the point is, if you're going to come to a contractual non-disclosure agreement and you want to be paid, that you would incorporate into that agreement the timeline to be settled and any potential penalties and ramifications if it's not paid.
Right. If you think it's a problem, that's something you can negotiate, absolutely.
Thank you.
Members, are there any other questions? Seeing none, that concludes this panel. And it concludes our bill hearing for House Bill 526.
Thank you.
Thank you. We're going to move on now to Delegate Cardin. House Bill 638.
Anybody else here?
Delegate Cardin, I just have you and Mr. Santini.
Great.
Great.
Thank you, Madam Chair, members of the committee. John Cardin here asking for a favorable report on House Bill 638. This will be probably a lot shorter of a bill, and thank you, Mr. Santini, for having your patience and waiting and listening. Although with the law school that we went to this afternoon, I think that Mr. Santini probably enjoyed that. Yeah. For those of you who don't know, Mr. Santini is the former president of the Maryland State Bar Association, who was referenced in an earlier bill when the judges were up, and for his work on the Judicial Security Act that was done a few years ago. This is a bill that those of you, I don't think there's anybody here who's on the committee back in the early teens when I put this bill in a number of times to extend the retirement age for judges. Judges right now are mandatorily required to retire at the age of 70. They can't even serve as a sitting judge for 1 day more. They have to literally retire by their 70th birthday. And there's 3 reasons why I'm going to give, and then I'll let Mr. Santini speak and answer any questions as somebody who's far more experienced in this area than I am. Number 1, as you heard earlier today on like 7 different bills, we need more judges. We need more people officiating on judicial issues, and this bill could help that. Number 2, 73 is the new 50. I am 56 years old, and I can't believe that should I ever be fortunate enough to ever be a judge, I only have 13 and a half more years, 14 more years until I would have to retire, and I feel like I should be able to go a lot longer than that. And number 3, and I think most important for us this year, and this is really the coup d'etat, is if you look at the fiscal note, this will save the state $21 million. And I know that each one of us wants to figure out how we're going to solve our budget crisis. $21 million is a lot of money for doing something that, as far as I'm concerned, is a no-brainer. So I'll leave it at that. Thank you very much, Madam Chair.
Thank you. Good afternoon, Chair Bartlett and Vice Chair Davis and members of the Judiciary Committee. My name is Raphael Santini. I am a proud practicing attorney. I've been involved with the Maryland court system since 1979. That's about 46 years. I've attached my resume. I'm here to support HB 638. I support HB 638 for 7 reasons. 1, life expectancy and workforce longevity have increased since the enactment of Article 4, Section 4 of the Maryland Constitution in 1851. Life expectancy in 1851 is 40 years. Life expectancy today is 80 years. See Exhibit number 1. 2, the judiciary should reflect the public it serves. Quoting from a Baltimore Sun article, December 13th, 2025, quote, within the next 2 decades, more than a quarter of Maryland residents will be 65 years or older. That's Exhibit 2. 3, Maryland is surrounded by states that have a higher judicial retirement age than Maryland. The judicial retirement age in Pennsylvania is 75, in the District of Columbia is 74, and Virginia is 73. Recently, Virginia changed from 70 to 73, and that's what we want in this bill. That's Exhibit number 3. 4, retaining judicial experience enhances legal quality and continuity. We live in challenging times. The current history has demonstrated that the judiciary protects against excessive executive power. Judges with experience, deep legal knowledge, and institutional memory help in their expertise. 5, accessibility of judicial positions to senior attorneys. Most young attorneys in their 30s, 40s, and 50s cannot afford to apply for judgeships. Attorneys in their 50s are better economically suited to apply. Increasing the age by 3 years, you're going to get more knowledgeable attorneys in the judiciary. In closing.
Somebody will ask you the other 3.
Okay.
You can finish where you were going. You were saying in closing.
Oh, I was going to say, in closing, thank you, Madam Chair. In closing, our society is evolving, and the Maryland Constitution should evolve with it, like other legislation we've passed. HB 638 will help the people of Maryland and probably change history. I'm asking for a favorable decision on HB 638, and I thank you for your time, and I'm open for any questions.
Thank you. Members, do we have any questions? Delegate Ericon?
Thank you. I actually was here the last time you brought this bill. And I learned, I think, and you can correct me, and I think we've heard today, that even though y'all do have to retire, you actually do get to come back as temporary judges. We just had another bill on it earlier. So we still do get, is that correct, the benefit of their tenure and their wisdom, but they don't get to serve full time.
So as we learned, I believe it's 90 days a year. They were incorrect in their testimony earlier. I wasn't going to correct the judges, but
smart, never do that. I've learned the same.
They are only permitted to do it 90 days a year, and we are paying they're paying them hourly for that, plus we're paying them their pension. So you're kind of the state has to double dip. And that's one of the reasons why there is a relatively significant cost savings by doing this.
My only, and I know we've probably talked about this years ago, but my only concern is sometimes there's a judge that everyone else would agree it's time for retirement. And this actually has been the only way for us to gently usher them out to pasture. And so do you not have a concern that maybe some jurisdictions who are kind of breaking under the weight of someone whose time has really come, we won't be able to move them on to the next project?
Thank you for that question, and that was my 7th point, the
the
Judicial Disability Committee.
Yeah.
If there's any concerns that increasing the retirement age from 70 to 73 will create a non-compliant judge, these concerns are resolved by our very active Judicial Disabilities Committee. In my Exhibit 5, I give you the report from the Judicial Disabilities Committee and how active they are. Over my career, they have become very active.
Okay.
Originally, when I started in '88, a judge could say anything, and there wasn't a problem. Okay.
Right.
It's very different now.
Okay, when did that change? I remember when I was first elected, it was still a kind of an issue where we could have some pretty outrageous stuff. And
there's no question. I don't know the specific time it changed, but I can tell you in the 90s, I started to see some change.
Okay.
Okay. And I can, you don't know me, but I practice all over the state. Literally, I go to every courthouse. Pretty much know most of the judges. I have seen the temperament change, and it's for many reasons. Judge Morrissey has helped quite a bit with that, to be perfectly honest with you.
Yeah.
You know? No, but he actually has a meeting with the new judge to explain how things have changed since the 80s.
Mm-hmm.
Yeah, and like I said, I go back to 1979, okay? And the district court only started in '71. So I've been around for a long time, and I can tell you without a doubt, the Judicial Disabilities Commission is very effective in resolving these problems.
Okay, thank you.
Thank you. Delegate Conaway?
Thank you, Chair. Thank you, Delegate and panel, for coming in to testify. Can you explain why you chose 73 years of age, let's say, versus 75?
Well, it's interesting. If you look at history here, we originally tried no age, then we went to 75, and now we're looking at 73. And 73 makes sense because if you do the numbers, right now, at 54, you have to be a judge 16 years to collect the full pension. Okay, what does that mean? That means that that's at 70 you have to retire. So now we're using 57. 16 years, it'll take you to 73, okay? Now, why is that important? It's important from the concept that the Maryland judiciary does not resemble the Maryland State Bar. What I was talking about earlier with respect to younger attorneys not applying for judgeships because of their economic situation, that changes after you're in your late 50s. Okay, in your late 50s, you have more opportunity. Okay, because your economic situation is set up so now you can enter the judiciary. Okay, and obviously do something positive for society. Now, in the Maryland State Bar, 60% of private practice is made up of private practitioners. Unfortunately, that is not the judiciary. The judiciary is mostly made up of assistant attorney generals, assistant state's attorneys, and assistant PDs. Let me be clear. I have total respect for the public service and their commitment. But by increasing the judicial retirement age to 70 or 73, that door is open for a senior attorney that will create a more representative judiciary of the bar. Senior attorneys will have a wealth of public and civil, private and civil knowledge that experience can enrich the judiciary. All you have to do, if you go into any courthouse and ask, what background is this judge? I will guarantee you most of those judges are in those three categories.
And so that, when was the age 75? When was
No, what I think he meant is that when we were looking at legislation, we originally looked at the age of 75 and decided to curb it back to 73.
Right,
So.
right, but you had this bill in before?
I had this bill in before. I had it in before for 73. It's been years. This bill has been in many, many times.
But it was always 73?
For me, it was 73.
For you?
But other people have had it in. Mr. Santini's been here
I got you.
long before I was here.
I just got here this year, so I don't know.
Incremental movement up, it might also make sense from a public policy standpoint, which is another reason for 73.
Thank you.
Great, thank you. And Delegate Mangione, I'm gonna come back to you because I said I would go to this side. Delegate Simmons and then Boucher.
Thank you, Madam Chair, and thank you for bringing the bill. I was just trying to get a clear understanding. So in order to become a judge, do you have to be a member of the bar?
Yes, in Maryland, you do. You have to be a member of the bar, and you have to go through a judicial nominating committee.
Right.
And each county has it, and then we have the Maryland State Bar Committee, and then it goes to the governor, and they do their.
Sure, sure. And with that being the case, if you have a timeline, or for example, a certain number of judges are going to be coming up on their 70th birthday, and while they're still on the bench for replacement, do y'all pool the bar or other ways of recruiting or promoting or encouraging lawyers to become judges? What's that mechanism?
So the way it works now is that when a judge announces their retirement, whether it's they choose to retire early, they can, or at 70, there's then an official announcement that's made by the judiciary on the judiciary website, and that announcement stays open for a certain period of time by rule, and then people can apply. So now, there are certainly, I will tell you, there are organizations and bar associations and other groups that seek to recruit people to do it, and they investigate when certain people are turning 70, and they will do it, but there's not some sort of official. The MSBA, I don't think, has some sort of an official kind of promotional program. No.
They still have to, do they have to run for office, or they just appoint it?
So as we've learned in the past, circuit court judges they get appointed, but through the nominating commission, they have to run in the next, whatever the next election is. District court judges are appointed for a 10-year term. They do not run. They have to get reappointed after 10 years. And appeals judges have a retention election, which we can talk about later.
Outstanding. Thank you, Madam.
Delegate Boucher.
Thank you, Madam Chair. Have any judges challenged this as age discrimination and create any case law?
I do, since I've been around a while, I do remember Baltimore City judge arguing that point. I don't know what eventually happened, but that has come up. But I don't know
It'd
what
be
the
nice
result
if there was some case law to reference to this.
Yeah.
Thank you.
Delegate Mangione.
Thank you, Madam Chair, and thank you, Mr. Santini, for being here. I have a pretty reliable source, but I wanted to ask if you don't mind sharing with the audience how old you are.
I don't mind telling you. I am 70.
So you're right on the threshold here. Now, another question would be, and full disclosure, I guess my father would be your wife's cousin, correct?
Yes.
Yes. And I do have a couple actual serious questions, and that is a point I wanted to make because, I mean, I know you're very active. You're active in somewhere around, you were just honored, actually, and you had 11, I think, active boards and whatnot, plus you're a practicing criminal defense attorney. You're traveling all over the state. Probably one of the top in this position around Maryland, I would have to say. And without a bill like this, you're not eligible to be a sitting judge, despite all your experience, despite how active you are currently at 70. But with that being said, I do, my colleague from Harford County makes a great point, and I have no idea how the Judicial Disability Committee works. Number one, can you, well, I guess two questions. One, can you talk about whether a criminal defense attorney has more of a workload, in your opinion, might be biased, than some judges? And two, can you explain the process of how the Judicial Disability Committee would work if somebody, after this bill was passed, was 70, well, or beforehand, doesn't matter, how that process works?
Sure. Well, regarding workload, it depends on the individual. We're in court every day, literally. While I'm sitting here, my daughter's in Catonsville taking care of a case. She was in Baltimore County earlier. So my workload is pretty busy. Okay, and I know you don't know, I speak several languages. We have a multicultural practice. We deal with a lot of people all over the state. So we're very busy. I know judges are busy, but you know, I'm here and was it 5 o'clock and we're still working. And when I go back, I'm gonna go back to the office. I have to answer all these calls. So we tend to be pretty busy. Okay. The way judicial disabilities work, and again, I've given you their annual report, and it contains last year what happens. So somebody appears in front of a judge, for some reason they're disheartened, they can write a letter to Judicial Disabilities. When it goes there, they'll do the Judicial Disability Commission, they do their investigation, and they have them come in and testify, okay, about what happened, and then they make a decision. It's not complicated, it's open. And when was it about? Last year, I'm trying to remember, there was a judge in, I think it was PG County. It was a horrible situation. They had to, Justice Fader actually had to remove her from the bench. It was most of the Daily Record. It was a horrible situation, but that shows you how active they are, okay?
Yeah, well, no, thank you for your testimony, and I really, this bill is very interesting because I absolutely can see what the concerns would be on one side and on the other side, and obviously we would probably disagree a lot politically, let's be honest, but I also would hate to see somebody of your experience and your mental capabilities at this point in your life, obviously, not be allowed to serve and continue on in that role. So I appreciate the bill, and thank you for being here.
And just to be clear, I don't think that Mr. Santini is interested in seeking a judgeship.
I understand, yeah, but I'm saying, you know what I'm saying.
I will tell you that now that my father has retired, if I got into trouble, this would be he would be on the top of the list for me. So just FYI for all of you guys.
All righty, well, thank you for being here, Mr. Santini, and that concludes, well, actually, guess how many unfavorable we have? None. So Delegate Cardin, none who are here, I'm sorry. So Delegate Cardin, thank you very much. That concludes our bill hearing for House Bill 638. Now we're going to move on to Delegate Moon, House Bill 906, and House Bill 351. Delegate Moon, are you ready for favorable with amendment to come up with?
Sure.
Okay. And I see Bruce Plaxton and George Tolley.
Good evening, colleagues. House Bill
906. This is actually the brainchild of Speaker Pro Tem Luke Clippinger, Appropriations Chair Ben Barnes, and Deer Hunter in the back there had a contributing role in this. You might remember this bill from last year when we had a hearing on it. So it's back before you, and I'll just give you a brief refresher on what it does before I turn it over to my panel here. But there's really two aspects to the bill. The first is it attempts to allow punitive damages in cases of clear and convincing evidence of gross negligence as opposed to actual malice. The second change is that, and this is the Hunter portion of the bill, is that it applies a surcharge to those newly found potential revenue streams. And that was, you can understand the format of the bill and the context last year in which we were having that conversation and why some of those provisions are in there. So I just want to give you a brief, my take on policy reason for this. The actual malice standard requires something like evil intent or an intent to harm as opposed to gross negligence, which is wanton and reckless disregard. And it obviously means you're going to miss cases where you might want punitive damages. I went back and looked at some of the reports that this body produced when it actually studied the question of punitive damages, and they put quite clearly in here that, you know, one of the policy reasons for punitive damages is they're intended to punish quasi-criminal behavior, right? So if you have a corporation that can't be jailed under the criminal system, but they're doing something that's quasi-criminal, it might not be enough to say, all right, we're going to make you whole. You'll get your money back, and whatever actual damages you suffered, you're going to get that money back. But what if what they did was so bad and there's going to be no recourse, for quasi-criminal behavior? You might want punitive damages in that situation. One example that I will throw at you in my recent research is the Key Bridge case. Attorney General Brown is actually bringing a gross negligence case against the Dolly ship operators, and he's seeking punitive damages. And he can do this because under maritime law, punitive damages are available for gross negligence. So this case would not be a good case for punitive damages necessarily under Maryland law. And we are in the minority in making that exception. And when you look at the types of things that were alleged in the Dolly case, excuse me, very briefly, electrical fires the day before the accident, not notifying the Coast Guard of what was going on, having staff that were improperly trained to operate the vessel. Not a single one of these things were evil intent or an intent to harm people. But what was so preventable and catastrophic, the recovery, to me, it's not enough to just pay us back for the bridge. It seems to me there ought to be a penalty in that case. So that's my one use case for this bill.
Sure, I'll go first. Thank you, Madam Chair and members of the committee. My name is Bruce Plaxton. This is the first time I'm appearing before you this session. It's a pleasure. I'm a past president of the Maryland Association for Justice, as well as the current president of the American Association for Justice. So I'm very familiar with how this goes. Punitive damages are handled around the country, and I was going to explain it, but Delegate Moon did a fantastic job with not only the public policy, but explaining the need for it. The standard we have in Maryland, which is essentially evil intent, makes it practically impossible to get punitive damages. I started practicing law here in Maryland in 1982, and for 10 years, I was permitted to tell juries about corporate wrongdoing. I was permitted to tell juries of repeated violations. I was permitted to tell juries of trucking companies that deliberately put dangerous vehicles on the road, or untrained dangerous drivers, or deliberately violated laws made to make the public safe, such as not giving drivers proper rest. Under the current system, I'm not allowed to tell a jury any of those violations because an insurance carrier will just simply stipulate liability and the trial will go forward on damages. And since there are no punitive damages, none of those examples I just gave you are evil intent, the jury would never hear about repeated violations. What our opponents say is a low standard is they object to the ability to hold people responsible for the failure to exercise even the slightest care, a pattern of repeated misconduct, and acts or omissions that create a high degree of risk or harm to others. I would think we would all want to be protected from such egregious errors. I went and looked at the opponent's testimony, and it's much of what happens in all of these bills. It's a henny-penny defense that the sky will fall, our economy will falter, rates will go up, and as typical, no data or facts are produced to support this. What MedMutual did was they said that most states have a different standard than Maryland. Most states, Maryland would have a more difficult standard, and then attached a chart that proved the exact opposite, where almost every state does give punitive damages for willful disregard, gross negligence, recklessness. They don't require the evil intent standard that Maryland does. So I'm not surprised to see so many people behind me that are going to come here and look to protect the most egregious tortfeasors in our state instead of your constituents.
Thank you. Mr. Tolley?
Thank you, Madam Chair. Madam Vice Chair, members of the committee, my name is George Tolley. This is the second time I'm appearing before you, but I was equally delighted to be here the first time. I want to commend to you there was a work group that Delegate Moon and Mr. Plaxton have referred to. It was in February of 2017, the House work group on punitive damages convened by then Speaker Bush with then Vice Chair Dumais as the chair of that work group, and a comprehensive look, a deep dive, if you will, was done on punitive damages, and the report commended all of that information to the legislature for its determination on whether to change the standard. The history of it is this, that prior to 1992, the standard was implied malice instead of the actual malice standard we have now. And the implied malice was defined in those cases as wanton and reckless disregard for human life, which is, again, why the Dali case is an example. Corporate conduct that puts Marylanders at risk could be wanton and reckless disregard of human life. And if that happens today, there's no way for Marylanders to hold that wrongdoer accountable for punitive damages. Of course, we also have caps. So why Maryland's tort law exposes Marylanders uniquely to these sorts of dangers? Restoring punitive damages to a standard that is common throughout the country doesn't make Maryland less competitive with those same states that have gross negligence or wanton disregard for human life as the standard. It makes us just as competitive as they are, because we have the same, we would have or adopt the same law that they have, the same standards that they have. The standard for punitive damages has to be proven by clear and convincing evidence. For these folks to come in and say, there's going to be a lot of Maryland businesses going to see lots more punitive damages, means that apparently today they are engaged in a wanton and reckless disregard for human life, because Maryland law doesn't punish that yet, and it should. For these reasons, I ask for a favorable report on House Bill 906, and I'm happy to answer any questions.
Thank you. Members, do we have any questions? Delegate Conaway.
Thank you, for coming in to testify. So in reference to the standard, do other states have 50% standard?
No, and I will say, having had a year to think on the rate that Hunter chose there, that 50% rate.
Well, that's a Hunter rate.
So I want to flag actually a couple variances between Maryland and other states and what's proposed here. You've tabbed on one. There are certainly other states that do cost share on punitive damages, but 50%, I think was a test number. Certainly, if this were to move and people were interested, it revenue as one of the items here, that number could certainly come down from 50%. The other thing I would point out, and this is perhaps without the consultation of the two gentlemen sitting on either side of me, is that in other states, you will see the ratio of punitive damages minimum, or like for maritime law, for example, the Supreme Court has said the punitive damages should be a 1-to-1 ratio for your compensatory damages. In other words, if you had $1 billion in bridge collapse, you could do $1 billion in punishment. And other states set that ratio differently. And I would certainly be open, as we expand the pool of cases that be subject to this, to some limiting factor so that there's not an unbounded, unknowable amount of liability exposure. But again, I haven't talked to these gentlemen about that.
Can you say how much is being asked for in reference to this key bridge collapse? How much?
Well, they did not specify a punitive damages amount. They initially specified $1.7 billion in compensatory damages for the bridge rebuild, which we now know is going to be way more than that. And then they said, and punitive damages. So they did not specify amount. But again, it would be in a 1-to-1 ratio. So if they're saying it's the cost of the bridge, it's the cost of the bridge times 2.
Yeah, but you said 50%. So, but
that's in the bill. That's the Dolly example. The Dolly example is not going to be one that applies in the real world.
What's a typical example? But let's say for 2025 or 2024, something like that. In percentage rate.
You mean in terms of the share of a punitive damages award that would go to the state?
I think that's what he's asking.
Well, I'm talking about where it says the state court administrator shall assess a surcharge on punitive damages in the amount equal to 50%.
There are a very small number of states that impose a surcharge. I think one of them is Georgia, based on, and I'm basing that on the testimony from last year.
But other states award punitive damages.
Yes.
Almost every other state.
In most states, the plaintiff keeps 100% of the punitive damages and does not share it with the state. We've crafted this bill to have a positive fiscal impact, and because punitive damages are meant to punish the wrongdoer and not be a windfall for the plaintiff, the compensatory damages go to the plaintiff, and then the plaintiff would share the punitive damages with the state.
And why would the plaintiff share punitive damages with the state?
Because
well, I understand that's what
that's because
the bill says that.
Because the goal is to punish the wrongdoer.
Okay, thank you.
That's why the goal is to punish the wrongdoer, not to make the plaintiff.
Intellectual answer. Thank you very much.
Yeah, and if just following on Delegate Moon's point about the ratio, the Supreme Court has held in non-maritime cases that the due process clause of the Constitution does require some limits on punitive damages generally, and some states have enacted by statute and other states have by court decision different ratios based on what they perceive to be a fair due process of law relationship. And those can range from 5-to-1 to 7-to-1 to 9-to-1. Something like that. So if you had 100,000,
1/2.
Well, so that's different from the tax or the surcharge. The surcharge is the sharing of the ratio. I think that Delegate Moon was talking about is if there was a case with $100,000 in compensatory damages, you couldn't fairly have punitive damages of $20 billion, right? That's out of proportion to the compensatory damages in the case. And due process says, and in fact, there's a case on this, that no, you can't have that kind of a disparate ratio of 200-to-1. You can do some other number, and the Supreme Court's never said what the number is that they think it is, but different states have stepped into that void, and as I said, 5, 6, 7, 10, 9, whatever those numbers are, depending on the state. That's different from the sharing of the money between the state and the plaintiff. I hope that answers your question.
What we've also, the opposition has talked a lot most of the opposition that there could be unlimited awards of punitive damages, but that's not the case because remittitor applies to punitive damages just as it does to compensatory damage. There are safeguards to protect parties from having runaway verdicts. And if a judge is not convinced that there's evidence, clear and convincing evidence of gross negligence, the punitive damages will not even go to the jury. The judge can dismiss that count preliminarily, which is why you won't see everybody in every auto accident case or slip and fall case pleading punitive damages. It would be a waste of time.
Okay, thank you very much.
Thank you. The Vice Chair?
I know that the punitive damages bar is pretty high. Do either of you know of anyone who's been successful in the punitive damages case in Maryland?
So the standard in a case arising from negligence is actual malice. If there's a personal injury action that can be cast as a strict liability action, our courts, because this is all judge-made law from our Supreme Court. The Supreme Court said in negligence cases, it's actual malice. In a product liability, strict liability context, it's implied malice or gross negligence or whatever the disregard for human life, the wanton and reckless. And there was a verdict last year in a product liability case against Johnson & Johnson, whose talcum powder products have been shown to sometimes contain asbestos because their quality control isn't what it should be. And the jury in Baltimore City returned a verdict that included $1.5 billion in punitive damages against Johnson & Johnson, which isn't a lot of money for a multi-billion-dollar international pharmaceutical company. But it is enough to maybe, and the instructions typically are, you want an amount that would punish and deter. And when you're talking about multi-billion-dollar companies, punishment doesn't happen and deterrence doesn't happen if it's a rounding error on their books. If this law were in place last year instead of next year or whenever, the state would have had an interest in a $750 million surcharge.
What it also illustrates that in Maryland, we already have punitive damages that works in products cases, and you don't see manufacturers not selling their products in Maryland. So the henny penny argument that the sky's going to fall and only in Maryland, not surrounding states or the rest of the country, just doesn't work. We have punitive damages on strict liability cases, products cases. We can handle punitive damages. We did before 1992, and the state didn't go broke. Truckers still traveled through Maryland, and doctors still did surgery in Maryland.
Thank you. Thank you, Delegate Phillips.
Thank you, Madam Chair. I'm trying to get a sense of how wide of a lens we open if we do punitive damage, allow for punitive damages. And my sense is it may not be that large of a, so give me an example, both of you are practicing attorneys, of a case that you've had where you thought, just a fact pattern, where you thought punitive damages would apply, and where you have normal cases where you would say you would never plead for punitive damages.
So if I may, I think you all know I'm a medical malpractice trial lawyer. About 98% of what I do is medical malpractice, representing patients and their families when unreasonably unsafe or negligent healthcare injures or kills the patient. Almost never is there punitive damages in a case like that. The doctors aren't typically willfully and recklessly endangering human life. They're trying to save life. If they fall below the standard of care because they're typically a hospital system's cutting corners on when multiple people have to check, if you have a timeout, make sure it's the right patient, that kind of thing. But it's very, very, it would be, I would expect, very rare. Is it
have you had a
possible?
case?
No. There have been cases, it wasn't my case, but there was a doctor at St. Joe's who was putting stents into perfectly healthy people for profit motive. And hundreds of those cases were filed in the 2012, 2013 timeframe because when it came to light that he was putting stents in patients who were perfectly healthy and the folks in the room who were watching him do it knew what he was doing, punitive damages were not available. Those cases went forward on a purely negligence basis because he didn't hate the patients. He didn't have, maybe, I don't even think he was a criminal. prosecution of him. This is Mark Madej was the name. And so I'm not, that's the sort of outlier. There was a doctor at Hopkins who was filming his female, his OB at Hopkins was filming his female patients with a little camera pen that he had around his neck and was clicking and clicking and clicking as he was doing his exams. That class action didn't have a count for punitive damages in it. Could it have? I think maybe. It's not, disregard for human life, but it's a pretty reprehensible conduct. So they're rare, not unheard of in the medical malpractice context, but rare. I don't do what Mr. Plaxton does, so I'm going to turn it over to him now.
Mr. Plaxton.
I think of cases where a construction company deliberately doesn't follow the law, where they build a building that they know is unsafe. They cut corners, and you have a building collapse, like the awful building collapse that occurred down in Miami. If we were to have that here in Maryland and find that the general contractor didn't follow, use substandard material, they would not be guilty of evil intent under our current law. And if they came to court and said, we're at fault, we're sorry, and they put their people in nice suits, and you would never hear about the misconduct, you would only hear about the damages in Maryland. And there'd be no punishment, there'd be no requirement that they pay anything additional for a building collapse that killed, dozens of people.
But I'll ask the question the same way that Mr. Talley. And once again, don't have to mention a specific case, but do you have fact patterns that you would say, you know what, in the last 2 years, I was dealing with a case where this defendant was truly grossly negligent, disregard. What would that fact pattern look like?
Well, I think of something like, someone who, maybe had multiple DUIs and caused a horrific accident and blew a .3, 4 times the legal limit. And I couldn't, the jury never learns that this was a drunk driver who had, wasn't supposed to be driving, or even maybe had someone blow into an interlock that he didn't blow into it, but had someone else blow into it and got around it, or jerry-rigged it or something. I mean, there's cases like that after the jury gives the verdict, I'm sure they would want to know something like that.
Okay, thank you.
You okay? Thank you. Any further questions? Delegate McComas, thank you.
Thank you, Madam Vice Chair. Just real quick, I was looking at some of the opposition testimony. I know you guys leave and then the other guys come in and then they leave and there's no kind of, so anyway, I'm just gonna try to mix it up a little bit because I'm curious what your response would be. And it's from the American Tort Reform Association, and they say that they're opposed to the bill. And they're opposed to it because it would reduce the standard for imposing punitive damages, exposing those who live, work, and do business in Maryland to significantly higher risk of massive awards, which equals, to me, insurance rates going up. And we all know that everybody's very concerned about finances and the electricity and insurance rates and taxes. And then they said a broad-based coalition of businesses, municipalities, associations, and professional firms that share the goal of having a fair, balanced, and predictable civil justice system. So I'm kind of curious, do you think that this would raise insurance rates and basically be an expense to the general public when it's just a few bad actors that
Can I just briefly say, since you started off with it's just a few bad actors, I think if it is just a few bad actors who are engaging in this egregious conduct, then the unpredictability probably comes from not having a cap on the punitive damages. And again, I haven't spoken to these guys about it, but I'll refer you to page 10 of the fiscal note. where you can see they have a table of, this is from the House Work Group. It's not in the fiscal. I'll email this to you after, but they have a table of all the different states that apply punitive damages and the caps, basically. Alabama, $500,000 cap, or 3 times the amount of the compensatory damages, right? They're all set up in this way. Arkansas, $250,000 or 3 times compensatory damages. So again, we as a group can come up with a formula that creates a limited, predictable compensation or punishment for punitive damages. It doesn't blow the budget out of the water.
That sounds good. Half of the picture though, aren't we? Because we have a major deficit in the state of Maryland, and we're looking in the couches for some coins, and we seem to be spending money. We're not taking care of DDA. So I guess what I'm saying is that, and also we have a high out-migration in Maryland, and some of the places you talked about are probably a lot less tax burden. So I'm just not sure. In other words, you have to kind of look at the whole picture. I mean.
Can I take a shot at that?
Okay.
Please. So there's two things about it. First of all, if a non-state, I have to look at this. I'm not sure if punitive damages are available against the state under the State Tort Claims Act, and if they're not available against the state, well then the state's not going to be liable for punitive damages because the state has a way of immunity.
I'm just concerned about the cost of living in the state.
Of course, and that's a great point.
And also whether businesses want to come here.
Yeah. So insurance rates in Maryland are we have insurance with Allstate or Nationwide or whoever it is, Chubb, depending on who you get your insurance from. They set rates, and the market is a national market. They're spreading the risk nationally, including in Maryland, for the risks that they have. And so when there are, hurricanes in Florida, our homeowners rates go up ever so slightly not because of something that happened in Maryland, but because of something that happened in Florida. Punitive damages are available in 46 states on a standard that's lower than ours. We are paying already, I would submit to you. And if this isn't true, then where's the data from the insurance industry? They didn't include it in their written opposition. They didn't say Maryland pays $5 less than Pennsylvania because we have this great evil motive standard. That's data. There's no industry in the world that's as data-driven as the insurance industry. We're paying, I would submit, for the coverage for the punitive damages protection that everyone else in America almost has, but we don't have because our law says you can't get it here. Our people don't deserve those protections that everyone in Arkansas and Maine and Pennsylvania, they enjoy. That's number one. So in terms of, is it really going to change if Maryland changes our standard to be the same as everyone else? Is it really going to affect affordability in Maryland when nationwide insurance risk is spread over 50 states? I would submit no, not credibly. And if that was true, where's the data in their opposition? Their opposition is henny penny, that it's going to. Well, how much? They would have the data. I don't have that data, but they would. And they don't produce it to us. And why I submit, if they don't produce data that they should have, it's probably because the data doesn't actually help them as much as the gloom and doom does. Second, every time there's a punitive damages award and the state takes 50%, that closes the budget and eases the tax burden that we have to raise to fund state whatever it is you want to use the state money for from other sources like property tax or what have you. If punitive damages is a source of revenue, that's an additional way to close these budgets, and you don't have to look in the couch cushions for the pennies anymore.
One side of it.
You wanted our side. I'm sure they've got one too.
Thank you. I am confused because you've described the surcharge as not a windfall, but I read the bill as saying the surcharge is on top. It's not a split recovery rule, it's a surcharge. So it is, so I want to make sure I'm understanding that correctly because
The extra 50% not going to the plaintiff is not a windfall for the plaintiff.
Right, but the plaintiff still is whole in the sense that they get the full punitive damage.
Yes.
Whereas a split recovery model, which many states have, including 50% or 75%, would, I'm not saying one is better than the other. I just want to make sure I'm understanding the structure proposed.
We are okay if instead of the surcharge,
Yeah.
the award just gets split 50-50.
Yeah,
That's how the bill was drafted originally last year, and your then chair thought the surcharge was...
I'm not looking at Hunter.
Thought the surcharge was a better idea so that the plaintiff could keep 100% of the award.
Okay, no, I thank you.
But we're okay with not affecting the jury award and instead the plaintiff forfeiting 50% to the state.
Can I ask as a follow-up, what are the incentives in terms of settlement of one versus the other? How would that affect?
Well, that's very interesting. You want to talk about Oregon, George?
Yeah. So, so my understanding was we were talking about this over on the Senate side as we were looking at the surcharge and what sort of amendments might be put on the bill. And my understanding, I was informed that in Oregon, as soon as the verdict happens, because last year, I'm sorry, let me put a pin in that and come back. Last year, Mr. Collins' testimony said, well, in Georgia, there's a surcharge, but the state of Georgia almost never gets it because what'll happen is there's a verdict that includes punitive damages. The state says, ooh, I might get a surcharge. But the parties then negotiate and settle the case without the punitive damages, and the state gets nothing. And Mr. Collins says, so this surcharge is really an illusion. It's not real. Well, in Oregon, getting back to Oregon, the law, the statute there, I'm advised, is that as soon as there's a verdict, the state has its interest. And so the state then would be part of any settlement negotiation and could stick up for itself, and somebody from the Attorney General's office presumably would be party to any settlement negotiations, and the likelihood would be that punitive damages, assuming it's supported by the evidence and isn't going to be subject to a remitter and isn't going to be stricken as on a motion for judgment notwithstanding the verdict by the trial judge based on the evidence presented at trial. If there's a legitimate punitive damages award, the state would have a much higher likelihood than apparently what the experience is in Georgia of actually recovering its share of that public fine, if that answers your question.
Very interesting. Madam Chair, may I ask one final follow-up? I'm sorry. That entire process, is that in statute or is that governed by court rules?
I believe it's by statute, but I could get back to you on if I'm wrong about that. I'll let you know.
Thank you.
Of course. Thank you so much for the question.
Okay, members, I see no further questions. We're going to release this panel. They've been here quite a while.
Thank you,
Okay, and we're going to move on to our unfavorable panel with Robert Enton, Nancy Egan, Carrie Silverman, Carvel Collins, Nicole Nesbitt, Steve Wise, Lauren Pockman, and Jake Whitaker. Let's see how many people we can fit. I know we can fit 6 successfully. I called more than 6. No, yep, and then we'll do the next panel. Okay. All right.
Madam Chair, members of the committee, Robert Enton, once again on behalf of the American Property Casualty Insurers Association. And, I look at this and I say to myself, what a tremendous change this will be in Maryland law. The standard in Maryland law is that in order to get punitive damages, which have no cap whatsoever, and which, as you heard, can be billions of dollars, okay? Billions. That we're not going to say that what the standard has always been, which is You're only going to get this in a civil court proceeding. You're basically going to get a fine that can be billions of dollars. That's what, and now, instead of saying that to get this penalty, this fine, far in excess of any criminal fine that a court could impose, you just have to, meet the civil burden of proof, and the jury can come back with whatever it wants for punitive damages, millions, tens of millions, $1 billion, as you heard, and that's it. That's what you're going to get. That's what you're going to get hit with. The actual malice says if we're going to punish you in a civil proceeding, we have to show that you had actual malice. So that's one point. The second point is that your insurance policies, you want to know why insurers care? Go look at your insurance policy. If you engage in an act of malice, that insurance may not cover it if you engage in an act of malice. On the other hand, gross negligence is going to be covered, okay? So is this, what we're saying is you think this is not going to increase rates of insurance when you can come back with what you heard, which was a $1.5 billion verdict? This is well-settled Maryland law, and it shouldn't be changed. Thank you.
Thank you. Whoever's next.
Go ahead, Carol. Let's just go down.
Good evening, Madam Chair and members of the committee. I'm Carrie Silverman, the second Carrie of the day, on behalf of the American Tort Reform Association. Thank you for the opportunity to speak on this bill. ATRA opposes this legislation. Punitive damages, are there to punish and deter truly reprehensible conduct. And it's not there to punish carelessness. It's not there to fund our schools. Maryland law has stayed true to its purposes, and it's reserved punitive damages for malicious, evil, intentional, deliberate misconduct and fraud. Over time, we have seen, as others have spoken previously, over time, states relax their standard from what was the traditional requirement for punitive damages. And what happened? What happened was lowering the standard led to punitive damages or the threat of punitive damages, which could be enough in cases involving no more than mere negligence, or as the Maryland Supreme Court has characterized gross negligence, big negligence. Punitive damages became too frequent, inconsistent, unpredictable, and disproportionate. So what happened next? You had the U.S. Supreme Court come in and declare that punitive damages have run wild and start putting in constitutional requirements. Yet half of the states now enact caps to control them. Maryland has retained the appropriate high standard, and it's not alone. There are other states that have a similar standard. But when awarded, there is no statutory cap, and this has worked. We don't see Maryland as having the types of nuclear verdicts that we see in other states. We don't see those jackpot judgments. I can speak about the 50% surcharge as well. I know I'm out of time, but I can tell you no other state does it this way, and there are significant policy problems with doing it, and we would ask for an unfavorable report. Thank you.
Thank you, Madam Chair, Madam Vice Chair, members of the committee. Carville Collins on behalf of Maryland Employers for Civil Justice Reform Coalition. The current standard of actual malice is appropriate. It is an extraordinary standard because punitive damages, which are unlimited under Maryland law, are an extraordinary remedy. The Supreme Court of Maryland created the gross negligence standard back in 1972. But within 20 years, it changed the standard back to today's standard of actual malice. The court found it was a mistake. It needed to be overruled. The High Court held, and I quote, "The gross negligence test has been overbroad in its application and has resulted in inconsistent jury verdicts involving similar facts. It provides little guidance for individuals and companies to enable them to predict behavior that will either trigger or avoid punitive damage liability, and it undermines the deterrent effect of these awards," end of quote. The return to actual malice in 1992 was also based on the court's further finding of a literal explosion of punitive damage awards in practice under the lesser gross negligence standard. We see that issue in the fiscal note, where state expenditures would increase by $500,000 alone just to hire more lawyers to defend the state in the greater number of actions permitted under this bill. Contrary to what you have heard from the proponents today, that this would return us to the gross negligence standard, this bill does not stop at the previously abandoned standard of gross negligence. It goes even lower. In the plain words of the bill, it allows punitive damages for such minimal and arbitrary infractions as a failure to exercise even slight care and certain other omissions. Such a low standard could include someone's forgetfulness. Such low and arbitrary standards would expose, we think, practically every claim of negligence, including simple negligence claims, to a punitive damage award. We urge an unfavorable.
Good evening, Nicole Nesbitt on behalf of the Maryland Defense Council. The prior panel really combined two forms of damages into one, and I want to separate them out because I think that is critically important to this committee's ability to analyze what the bill does. The purpose of punitive damages, as we've all said, is to punish and deter, but that is separate from a plaintiff's entitlement to compensatory damages for any monetary damages that they've suffered. So in that bridge accident, the plaintiff in that matter is going to get fully compensated for every bit of monetary damage that was sustained, fully compensated. Same is true for personal injury plaintiffs or any other plaintiffs in civil actions here in Maryland. They get fully compensated for all of their monetary damages with no cap. And then in addition to that, they can get a capped amount of non-monetary damages as well. So the plaintiff gets their damages covered outside of the punitive sphere. This is why I was surprised to hear the panel complaining about a defendant being able to admit liability, and then the jury never gets to hear that they were grossly negligent in the course of the accident or whatever the underlying matter was. That is by design. We want for defendants who don't have a defense to admit liability and just have the jury hear about the plaintiff's damages so that the plaintiff can get compensated for their damages. It is not appropriate for that to be confused with what punitive damages are for, which are for punishing that defendant for doing something intentionally wrong. And the issue of having intent versus gross negligence or something lesser than that is because we need a bright line for a jury to make that determination. And intent is something that can be proven. These other things, like the language that my colleague was talking about, is very difficult for anyone to interpret. And for that reason, MDC urges an unfavorable review.
Good evening, Madam Chair, members of the committee. I'm Steve Wise here tonight on behalf of MedCI, the Maryland State Medical Society, in opposition to the bill. Obviously, our concern here would be medical malpractice, and you heard Mr. Tolley indicate, and I would agree, that punitive damages are rarely awarded today in a medical malpractice case because it requires a level of intent, if you will. This bill takes that standard and swings the pendulum far in the other direction to the point where I believe most medical malpractice cases could be squeezed into the language on page 2 of the bill. For example, acts or omissions that create a high degree of risk or harm to others is just one example. You may be aware, we already have a significant physician shortage in this state. What would happen if this bill were enacted? Well, you're going to have significantly higher medical malpractice premiums, and I'll come back to that. But in the Zenobia case that was referred to earlier, the court talked about the faults with this gross negligence standard, and what we have here is even lower than what existed then. Gross negligence, I'm quoting the case, gross negligence simply covers too broad and too vague an area of behavior resulting in an unfair and inefficient use of the doctrine of punitive damages. A similar problem exists with allowing punitive damages based merely upon reckless conduct. To sanction punitive damages solely upon the basis of conduct characterized as heedless disregard of the consequences would be to allow virtually limitless imposition of punitive damages. And that is our concern, is that they would come into play in every medical malpractice case. These judgments that would result in that environment is exactly what caused the legislature to have to convene a special session in 2004 to fix the runaway medical malpractice insurance premiums. For those reasons, we would ask for an unfavorable report.
Thank you. Ms. Bachman?
Good evening, Chair Bartlett, Vice Chair Davis, and members of the committee. Thank you for the opportunity to speak in opposition to HB 906. My name is Lauren Packman on behalf of Allstate. 906 raises serious concerns for us because it would really fundamentally change what punitive damages are for in Maryland. As previous witnesses said, punitive damages are intended to punish bad actors and deter future bad behavior. They're not designed to fund unrelated state programs. Turning them into a revenue mechanism changes them into a funding source. It gives the state a financial interest, weirdly, in the imposition of punitive damage awards, and it could send a message to judges and juries encouraging them to impose punitive damage awards because they want to see this other program funded. It also raises questions about due process and excessive fines. It would likely lead to additional challenges and appeals, and it would delay the final resolution of cases for all parties. Increasing punitive damages exposure would also discourage defendants from pursuing settlement, encourage them to aggressively litigate punitive claims specifically, and encourage appeals specifically of the punitive damage decisions. These would lead to longer cases, higher litigation costs, and delayed compensation. Also, the bill would impose the 50% surcharge on all defendants, regardless of their size or the amount of annual revenue they have or the number of employees they have. Every single defendant, regardless of the nature of that defendant, would receive the same 50% surcharge. In addition to not being calibrated to defendant size, the surcharge isn't calibrated to the degree of malfeasance or harm caused. Ultimately, the 50% amount will end up producing an arbitrary surcharge sum that's completely disconnected from the conduct of the defendant being punished. We ask for an unfavorable report on the bill. Thank you.
Thank you. Members, I'm sorry, Mr. Whitaker, you go ahead and
Thank you, Madam Chair and members
Sure.
of the committee. I'm Jake Whitaker, and on behalf of Maryland's hospitals and health systems, we're here to respectfully oppose House Bill 906. I'd just like to echo what my fellow panelists said about the concerns about this bill just upending the entire liability environment here in Maryland. I'd especially like to echo what my colleague Steve Wise mentioned about how this could potentially upend the whole medical malpractice scheme in Maryland and how that would have an impact on Maryland's hospitals. But again, I just really want to emphasize how this would have an impact on Maryland's unique all-payer hospital model. So as you know, we're going through a transition to the AHEAD model. But what this means is that we have a fixed revenue on any given year. So that means we can't offer new services, we can't raise new prices or generate new revenue streams to address some of these costs that would result from the new punitive damages cases. I think I'd also like to emphasize that as a product of this model, every single hospital in Maryland is a nonprofit hospital, and we accept every single payer, including Medicaid. And I really wanted to emphasize that because this money's not coming out of profits. This is coming directly out of care from your constituents. So I just want to really make that point clear. And finally, I would just like to add that this is really insult to injury. With the federal uncertainty and about $800 billion in Medicaid cuts, to add additional cost to hospitals right now is just not the right time. So we respectfully request an unfavorable report on this bill. Thank you.
Members, do we have any questions? Delegate Phillips?
So I'm going to ask a couple of what ifs. So what if there was a cap, and so you could use actuarial tables to figure out what that cost is? Would the industry be more open if there was a cap? Okay. What to the medical folks? What if we pulled you out?
We think this bill is a bad idea for the medical field, and we wouldn't like to be a part of it, but I think it's bad for Maryland's entire liability environment. And what I would add is even on bills like, for example, the cap that lifts on personal injury and wrongful death cases, that still reverberates back to the medical field. That raises insurance prices across the board. So even if it's a personal injury case, we still have to buy insurance, so that impacts us regardless.
All right. So we have a really high standard when it comes to malice. You got to show intent, you got to show evil motive, you got to show conscious wrongdoing, and a state of mind, which is subjective. What if in these cases we said you got to show 2 out of 4 as a balance? It would make it much harder. I mean, it would make it easier, but at the same time, it would take any. I guess I'm struggling, and I don't want rates to go up, so I want anybody to quote me that. But if I have conscious wrongdoing, and it's repeated, and the fact that we have no punitive damages, it is a little concerning.
Each of the 4 of those things you mentioned is one thing: intent to harm. That is what actual malice is, and that's the standard that we currently have.
Intent to harm is not conscious wrongdoing.
Yes, it is. That is the way it's defined in all of the cases. We don't have a statute right now. We only have case interpretation of what Maryland's.
So what if we did a statute and we said, this is what this is what that is, and this is what this is? Because since you say you got to find all 4, but we can say.
They're not 4 different things, though. They are, the actual malice standard is the actual intent to harm the plaintiff. That is what that is. And the reason that bright line matters is because anything less than it is almost impossible to give application to.
But conscious wrongdoing and intent to harm can be 2 different things. And I'm saying if
right, you want deliberate indifference, right, which is what this statute would propose in part. This statute proposes a lot of different other things other than intent to harm. And what we have right now is intent to harm. And what I'm saying is that the application of anything less than intent to harm gets real fuzzy real quick. And that's why the efforts to describe what they are, things like a pattern of misconduct. Well, what's a pattern? Is it 2? Is it 5? How many things equals a pattern? Or even the slightest care. Sorry?
Isn't that for the judge to decide or the trial fact to decide?
Well, no, it's a statute. I mean, you know.
No, I'm saying, and what's a pattern and how significant is the pattern?
Well, I think it would be incumbent upon this body to determine the right language for a judge to interpret, because if you make it too difficult, then you're going to get inconsistent applications of that. And that's what we're trying to avoid, and that's why the actual malice standard works well. And it, I mean, I know you've heard different statistics about what other states are doing, but at least half the states have some actual malice piece of it. Fewer than half the states have a deliberate disregard. They don't go that low. So, and that's, I think, because of application, practical application of the law.
The Vice Chair.
My question is for Mr. Whitaker, Medcai. So we heard a story about.
I'm sorry, Madam Vice Chair, I'm with the Hospital Association. Did you need to speak to Medcai?
Okay, yeah, you do.
Sure, happy to help, yeah, whatever I can do.
Thank you.
Sure.
We heard a story about a doctor who was intentionally doing something wrong to patients just to make money. Well, all of you could answer this. I mean, shouldn't that doctor be punished?
Yes.
Thank you, Madam Vice Chair, and my co-panelist is familiar with the case, so if I could turn it over to her, if that's okay.
We were involved in the representation of that physician as well as the one who was taking pictures, right? So in the first case, the application of actual harm.
Was it a yes or no? I think it's just a
yes. No, I want to say that the reason that punitives wouldn't be applicable is because the standard of I intended to harm the person was not met, because he didn't intend to harm people. He was providing care that he believed was appropriate, and others were saying, nah, you did that to make money. But he didn't intend to harm the individual.
Suppose he did it to make money.
No, right, okay, so yeah, I understand.
Just to make money, the people didn't need it, and everyone agreed they didn't need the services.
Right, he didn't intend to harm the people, so that's the easy application of the standard that I'm talking about. He didn't intend to harm the individuals.
That's pretty bad.
Sorry?
That's pretty bad. That if you think that's okay, that's pretty bad.
No, I'm saying that it's easy to apply. I'm not necessarily saying that that's okay, but all of those people were able to get fully compensated for the injuries that occurred. He was deterred in other ways by he lost his privileges.
You keep using that term about fully compensated for the injury that occurred. Punitive damages should be a part of that.
I disagree. That's not what they're for. That is not what punitive damages are. They're meant to punish and deter only. Okay. That's why sometimes they don't even go to the plaintiff at all.
Okay.
They're not compensatory.
Okay.
Okay. Sorry.
Thank you, Chair. Thank you, panel, for coming in to testify. So you just said the punitive damages are designed to punish and deter, I guess, the wrongdoer from doing wrong. So in the case of the doctor taking pictures, they were doing wrong, but they had no intent to do harm. Is that what we're saying?
No, not that one. That one definitely intended to do harm, and they definitely would have applied in that case, but he died. That's why they weren't brought.
Oh, that's why it wasn't brought?
Yes.
Okay, but if we enact this bill, you foresee more punitive damages being applied or being requested?
Right. Once the standard is lowered, as other people have said, then you start pulling into the net unintentional matters that are hard to apply.
And so you would estimate the net might get bigger by 10%, 15%, 20%?
I think that's hard to quantify, but it would be exponentially bigger, right? Because you're expanding it to non-intentional conduct.
Okay. Thank you so very much.
Thank you. Members, do we have any other questions? Seeing none, that excuses this panel. Thank you so much. And that concludes our testimony for House Bill 906. We're going to move on to House Bill 351. This is also Delegate Moon. And this is also our last bill of the night. I have you and Carrie Hansel. Is Mr. Hansel still? Oh, there you go. Okay, great. Whenever you're ready.
Good evening, colleagues. House Bill 351. I know I'm now standing before you and dinner, so I hope this goes brief. So this bill is an attempt to ensure some accountability, some preservation of rule of law, and some hope that we may deter excessive behavior by people who wrongly believe that they have been pre-immunized against state action for their misconduct. So what the bill proposes to do is to use very common police technology, many forms of which you are familiar with because they are the police technologies that we have regulated by law. And it would deploy these technologies to help identify federal agents and gather evidence if and only if there's a Maryland law enforcement office that has determined there is a serious, credible complaint of violent or unconstitutional misconduct. So if a prosecutor or state prosecutor finds that this is the case, they would refer the matter for information gathering. And the law specifically puts out that we would use things like license plate scanners, cell phone tower data, stingrays, GPS, facial recognition technology. Again, very commonly used law enforcement technology. We have vendors currently using these services in our state through our local police departments. And it would deploy these again if there's serious, credible allegation of violent or unconstitutional misconduct. I want to be very clear about a couple other things. This is not doxing. This information is not publicly available. It would simply be stored and only released upon court order if there's a criminal case or a civil case in the future. I'm not changing anything with respect to what state prosecutors do. In fact, this information might be held for a future federal prosecutor. If there's an oversight hearing in Congress and they want this information, if there's a new U.S. attorney in town, my friend Eric Barron gets his old job back, say, and decides to take a look at some of these cases, there are many possible uses for it. But again, all this does is reassure the public in Maryland and a reminder to our federal agents that when they are here, they are expected to follow the law, and there is no statute of limitations or federal pardon that can shield you from state action and accountability. So that's what the bill does. Happy to take any questions, and I turn it over to Carrie Hansel.
Whenever you're ready.
Thank you, Madam Chair, and thank you to the sponsor. This is a really common sense measure, because all it is an evidence collection and preservation bill at its heart, right? All this information is out there in the world digitally. This makes sure that if a law enforcement officer, the Attorney General or a state's attorney deems it appropriate, and it's important, I think, that it's a may, so there's still law enforcement discretion that is exercised. If a law enforcement officer deems it appropriate, then this information, which is out there, which exists in a moment in time, can be captured and preserved. And so all it is a very common sense preservation measure. And for people on both sides, I think this makes a lot of sense. If I were an officer falsely accused, I'd want to know that if somebody made this complaint, right, to the Attorney General or the state's attorney, that they collected all of that data. If I wasn't there, I'd want to know that my cell phone data is going to show that I wasn't there. So this is a evidence gathering measure that leads us to the truth, whichever side of the equation the truth is on. And so from my perspective, it's a very common sense measure. I want to add one thing to something that Delegate Moon said, which is that it is kept and preserved until ordered released by a court. And I can tell you, having done similar cases where we are fighting to get materials released from various government agencies, sometimes gathered in the context of a criminal investigation, the judges, when they give those orders, are very careful about parameters around how that information can be used. So if I went to a judge and said, I'm trying to get this information, when they order it released, if they do, first of all, the officer that I'm suing would have his attorney saying to the judge, let's put some guardrails on it. And I would expect a judge on a case-by-case basis to do that. So there's going to be guardrails on this information. There are a few technical issues that I can address. I see my time is almost up, that will improve the bill from the perspective of any challenges, but we're very much strongly in favor of it.
Great, thank you. I almost want a demonstration to see how this works, but that's okay. Delegate Embry and then the Vice Chair.
Thank you. I think it's very interesting, and I certainly appreciate the goal. I am struggling, though, to understand how the Attorney General would have authority if there was not an actual crime committed, and how it would not run afoul of the Fourth Amendment, because a lot of that information we have regulated, even sometimes beyond what the Fourth Amendment requires, for all the reasons that you know you've been involved in that. So right. So question one is, does a crime, I would think a crime would have to be committed for the Attorney General, and they would have to have authority to prosecute that crime in order to obtain some of that information. The second thing, which ties into the very interesting Delegate Charkoudian bill, is right now there's not a civil cause of action. So again, I would think we would have to have some theory in order to authorize the Attorney General. So again,
These are very good questions, and I will just tell you that because this is a novel bill, I had to put some placeholders in here. And so, for example, this talks about 1983 suits. We heard a lot about this today. One of the changes that I would make to this is just to strike that and just say a civil case. You know, I don't think we need to have that sort of limiting factor in here. Now, you raise an interesting question, however, about what can prompt an investigation. I'm trying to put two categories of cases in here. One is a set of physical altercations, kidnapping, assault, excessive force, right? This sort of thing. Those are clearly criminal. They touch on criminal laws, and so I think there's likely a nexus that if a state law enforcement agency decided to begin an investigation, they'd be in clear ground. Now, You also heard other bills that are attempting to open civil liability. So in reality, this would pair with one of those other bills. The question, however, is an interesting one about whether you could initiate an investigation and the information later only be used for a civil claim. Now, I would think that as long as there's the shade of a criminal offenses there, even if you never actually went and did the prosecution, my hope is that that information, again, would be stored for discovery. It could be for a future criminal case, but the branch could take us so that that criminal case never does materialize. But later, somebody files a civil claim based on the very same facts and is able to get discovery, to get access to that information. So that's cases where the initial facts seem to indicate the possibility of a criminal claim. Now, if it's something entirely constitutional, a Second Amendment violation, as we're seeing, or a First Amendment violation, I am trying to bring those cases into this bill. Again, just at the investigatory stage. There are implementation questions, as you suggest. We could leave in place the existing warrant requirement for some of these technologies that are in there. I would actually hope to relax them. And so I have some language I would propose, again, that if there are certain parameters met, that there is a serious claim of a constitutional violation, that you would be able to get a court order issued to say, look at cell phone data, license plate data, or the like. That's a novel aspect of the bill that I will put a pin in. So some parts of the bill are probably going to raise fewer questions than others, but I think there are some very straightforward parts of this bill.
There's also, if I can follow up on it, just from a Fourth Amendment perspective. The Fourth Amendment right turns on expectation of privacy. So when a police officer is in the conduct of their duties, be it state, local, or federal, that expectation begins to drop. Remember, these are people whose cars are tracked already by GPS, by their employer. These are people who walk around already with cameras often on their bodies or in their vehicles. So a lot of this information is not information that would trigger the Fourth Amendment because there's no expectation of privacy in the conduct of one's duties as a police officer. In some instances, there's no expectation of privacy at all, right? So for instance, in license plate data, my car is parked outside. Anybody here who wants to go take a photo of my license plate is welcome to do so. That is, there's no expectation I have in privacy in my license plate data. To the extent that this were interpreted, and to be blunt, I didn't interpret it this way, but to the extent that some of these things were interpreted to be their personal as opposed to professional devices, for instance, when we get to cell phones, I think it's a very reasonable Fourth Amendment point. If it were a personal device, I read the bill as obviously applying to their professional devices because those are the things that law enforcement would likely have this kind of access to begin with. But from the personal device perspective, you're exactly right. You'd have to meet warrant requirements. But keep in mind, the bill puts in the loop the type of lawyers who routinely seek warrants and would understand those requirements and would trust the AG or the state's attorney to follow that path when it was necessary. So I think the answer to your question is for most uses of this bill, the Fourth Amendment isn't triggered because there's no expectation of privacy. For uses where it is triggered, if it's interpreted that way, and maybe one answer is amend it to make clear we're talking about your work cell phone, that kind of thing. But where the Fourth Amendment might be triggered, I think certainly a state's attorney, and keeping in mind this is a may direct the police to do this, would understand that the Fourth Amendment applies and requires a warrant in particular circumstances. And in my mind, leaving that to the state's attorney is a smart decision by this body because they understand that body of law.
Well, many of these things we have explicitly required subpoenas for, and more often than warrants, but in some cases warrants. But just as a reaction, I mean, there's this longstanding principle that you cannot use criminal evidentiary procedures to obtain materials for a civil case. So I just want to, I don't think that's the intention, but I just want to caveat. But I just do think it's dangerous. I take your point. If things are obtainable without a subpoena or warrant, then fine. Of course, they can obtain them. But I just think if this is not limited to criminal behavior. So a lot of these things, we have criminal processes. It's not limited to things that are, they may be crimes, but just a word of caution, because we have worked very hard to protect civil rights from law enforcement.
It's totally fair, and look, there are some who say, Moon, you've been for years trying to fight all of these technologies being widely deployed, and but I'm at a point where what's good for the goose, and even the fact that we're talking about cell phones here. I mean, look, these are the people they've decided to bring their personal cell phones and start scanning illegally well, not illegally, but under questionable circumstances, scanning U.S. citizens, yanking their global entry or TSA pre-check because they showed up at a protest. They're also not making themselves unanonymized for the purpose of showing up in court. I mean, this is the problem that frankly, this bill is partly trying to solve in Minnesota. I think the quote was the DHS has violated more court orders this month than most agencies in their entirety of existence in this country. I mean, these are the facts on the ground. So again, as to the criminal aspects of the bill, certainly I think it's clean. I am trying to find a way in to the civil world, again, because as we've heard and you see in places like Minnesota and here in Maryland, if we don't find a solution to this, our people are basically without recourse for a vast swath of what the federal agents are doing that's unconstitutional, for forcing quartering of federal agents, depriving people of their Second Amendment rights, depriving people of their freedom of assembly, freedom of speech. I mean, I could go on and on. We're all watching the same news. So I am trying to find a way to keep the civil door open for those reasons.
I appreciate that. Thank you so much. Thank you, Madam Chair.
Thank you. Delegate Conaway.
Yeah, thank you, Delegate and witness, for coming in and testify. So, Delegate, you said there would be no federal pardon that can shield the agent. Where's that in this bill?
It's just reminding people that the existence of a bill like this does serve to remind people that they're not immune from the reach of state law as to criminal.
No, you said no federal. You said no federal.
I believe the feds have been getting bad advice. I saw, I think it was Stephen Bannon and several other, Kristi Noem, some of these officials are telling their agents that they don't have to worry about consequences for their behavior, that Bovino was telling people he was going to not make them available for prosecution.
That if the state charges a federal agent,
you can't.
That the federal can't excuse that agent from being charged?
No, the president cannot pardon people for state crimes.
Okay. And
I don't know but again, I don't know that they know that.
That's great. That's fine. Is the United States of America under Homeland Security right now at this point?
What's that?
Are we under the protocol of Homeland Security?
I don't.
That you know of?
I wouldn't say we are. I'd like not to be.
Are you saying yes or are you saying no?
I guess I don't understand.
You don't know.
I'm not sure I understand the question.
You don't understand what Homeland Security is?
Yeah, but you're asking if Maryland is still under federal jurisdiction for DHS?
United States. I asked, is the United States of America under Homeland Security? I wrote it down so I know what I said to you.
It is, but again, it's not without limitations.
Okay. What is the meaning of an unlawful detention in reference to a federal agent?
Well, I guess that's a matter for court.
Well, no, it's in your bill because it's on page 2, number 5.
An unlawful detention would be, okay, I'll give you an example. Court order says turn the plane around. They're not going to Venezuela. And the administration says, yes, they are.
And so that's an unlawful
Yeah, they kidnapped the whole plane of people.
That's unlawful detention?
Yes.
Okay, all right.
Absolutely.
Okay, thank you.
The Vice Chair.
Thank you. I believe Mr. Hansel ran out of time. He was about to explain some of the guardrails that he recommended for the bill.
So there are challenges we can all expect to be brought. And similar to the earlier bill, which addressed this, in other words, what I'm about to say, the earlier bill I testified about solves this problem. There's something called the Intergovernmental Immunity Doctrine. And in short, and of course, this is one of those things, if our professor was back, he could teach a whole course on, but I'm going to simplify. In short, what it means is states cannot discriminate against the federal government, which means that if there's a rule that we're going to apply here in Maryland, it has to apply equally to a federal officer, a state officer, and a local officer. And interestingly, the case that somebody mentioned in California really made all three of those distinctions. In other words, it's got to touch on each of those people and govern each of them accordingly. This bill, as written, is focused on federal officers and would be subject to challenge under the intergovernmental immunity doctrine. As I said earlier, folks who are trying to solve these problems and protect Marylanders like myself would work hard and push back against that. But this bill could be made stronger if it applied equally to officers from local, state, and federal. Because of this intergovernmental immunity doctrine that will be, as it's worded, the very first thing that the federal government cites to try to strike it down. That should not give anybody any heartburn, again, because this bill has the safeguard that none of this information is even collected until the Attorney General or a state's attorney authorizes it, and they don't need to, it's a may. And then, once collected, the information doesn't go anywhere, isn't used until there's a court order. So this is probably the highest protection we've given any information. In other words, ordinarily, there might be a search warrant, it's signed by a judge, and material can be collected, and in its dissemination within a police department is not tightly controlled compared to this bill. This bill requires both a determination by the state's attorney or the attorney general, and then subsequently an affirmative court order where the burden would be presumably on the people trying to get it released as the movement in the court to get it released. So it shouldn't give anybody any heartburn to make sure that we satisfy the intergovernmental immunity doctrine by expanding the bill as written from just federal officers to, and I would frame it as any governmental officer, any officer, things like that. But it has to read to apply to state, local, and federal, as do all of the bills that this committee is looking at to address some of what we've seen in Minneapolis. In other words, that I would urge that point on even bills I haven't had the opportunity to testify about. They have to apply state, local, and federal if they're going to survive challenges, or at least if we're going to have the best opportunity to defeat those challenges, because I'll defend your bill no matter what if this passes.
All right, thank you.
Delegate Phillips.
Yeah, I'm just thinking this one through. If I'm in the state's attorney's office today, take federal officers out of the equation, what do I need to begin an investigation of a police officer?
A complaint. This is a complaint-generated process, so you need a complaint to bubble up that eventually makes its way.
Can I actually collect and send somebody out to collect this type of data simply with the complaint?
No.
I don't think so.
No. The complaint has to go up through one of the I think we have state prosecutor and county state's attorneys. One of the law enforcement agencies would need to refer it over before data collection can begin. So that just like with any investigation, there's at least the first screen from a prosecutor who looks at this and says, this isn't serious, or this does not appear to meet the conditions in the law. But again, if that office, and these are people that already make these discretionary determinations as to which cases should move to investigation and which should not. So that was the idea, that it goes to people already making these determinations. And if they think there's a credible complaint that in fact there was violent misconduct that occurred, then they would then refer the matter for the data gathering.
But don't they then refer the matter, and I got a former state's attorney here, don't they then refer that matter to a judge to get either a subpoena or some type of warrant?
Well, this is, again, we would need to decide what direction to go with this. If you'll note in the fiscal note, it says this leaves intact all of the other requirements that we currently layer on for all of these technologies has a different section of code, and they all have different rules that we've written for when you can use them. So again, we could either leave those in place and be silent on that, or I'd like to see if we can relax some of them, again, to just keep this moving for as many of these types of cases as possible. But look, if we have to go with the most miserly version of this, which would just layer it to only criminal complaints that meet a certain threshold, that's fine too. I think that still has some of the deterrent effect. Again, I'm just trying it to cover as many of the types of cases in here as possible, but I'm sensing that perhaps we may need to let some of them go.
I'm thinking about, Delegate Embry, I think, made a good point about what is the impact, unintended consequences for other areas should we move down this path.
Sure.
Members, any other questions? I think we have,
Do we have an opponent?
no?
Oh. Well, I thought you might be here to
No,
testify.
wait, do I have?
Oh, okay.
Yeah, no, I don't have, I'm sorry?
I signed up to testify.
What's your name?
Horvath.
I don't have you listed. Are you signed up as a, what's your first name?
Jane.
Miss Jane?
Route 1 corridor in Zisbro.
Is it on this bill, the House Bill 351?
Yeah.
And are you signed up as opposition?
No.
Favor?
Yeah.
Well, you know what? Because you have been sitting here the entire time, I'm going to go ahead and let you testify, and you will have 2 minutes.
Okay.
Okay? Members, thank you for your consideration.
Good for you for speaking up.
So I appreciate all of you. This is just a lot of impressive due diligence, and I really respect it, and I'm grateful for it. So good evening. My testimony started with good afternoon. So I'm Jane Horvath. I'm a 30-year resident of Prince George's County. I am a member of the Route 1 Corridor chapter of Indivisible, which is a national pro-democracy organization, and I lead our state and local work group in that chapter. I want to thank the committee for your interest in addressing the deep community concern about ICE and the growing impunity with which they operate across the country, and they will be here in stronger force soon. And I also am very grateful for all your work in being successful in ending 287G agreements. That's very important. But we need many tools to protect residents and businesses from unconstitutional activity, the physical harm, wrongful and inhumane detention that it comes along with ICE. We need a variety of policies in addition to 287G ban, many of which are going to be discussed in this committee, such as 351 and 332 that were discussed today, but I know your docket is filled with many other similarly oriented pieces of legislation. So I hope you will favor 351 and 332, as well as the other policies that are going to come in front of you that are going to tame immigration enforcement. It's imperative that the undue level of fear and mistreatment in our communities be reduced. Fear and mistreatment affects whole swaths of our communities. Volunteers to raise money and collect food and deliver it for devastated families of the disappeared. The attempt to make children feel safe going to and from school, and devising strategies to help businesses that are suffering economically because of the fear and the terror. I'd also point out that President Obama was called to the deporter-in-chief during his terms in office, and yet whole communities did not live under fear and terror. There was no need to respond and mitigate the damage or the basically. I also just want to mention that there is a deeply felt lack of involvement by state, county, and local law enforcement agencies in protecting residents and communities from undue immigration enforcement harm. At least in my county, law enforcement agencies really do prefer to look away, and there are clear examples of this. There is a bill, Senate Bill 660. There is no House companion to that bill at this time that would move us forward to gain the engagement of in-state law enforcement. The bill is scheduled for hearing next week in Senate JPR, and hopefully it would come to this committee, and I would also urge you to support that piece of legislation. That's a critical piece, in my view, of helping to protect communities and residents and our neighbors. It's going to be a struggle to contain ICE, but I appreciate the thoughtful leadership here in this committee, and I thank you for your time and commitment to the issue.
Thank you.
Thank you for being involved.
Yes, thank you for your civic engagement. Thank you for your civic engagement. Thank you for being here since, it looks like it was 1 o'clock. I'm not sure what time you arrived. 1 o'clock, and you stayed the entire time, and I appreciate you, and I think we have someone from Prince George's County who has something to say. Delegate Williams.
Yes, hi.
Hi, I just wanted to thank you so much for being here, for your advocacy in my district, in District 22, and really all throughout northern Prince George's County. So I don't know if there was anything else you wanted to add in addition to what you have already stated.
No, I look forward to your bill coming up. I do, and I also, it's not like me, like there's thousands of me's. I just had the day available to be here. Other people would have, and I'm glad I came. But yeah, there's thousands of people like me.
Well, thank you. Thank you very much.
Thank you.
And members, that concludes our bill hearing for House Bill 351, and that concludes our day, our evening. We are adjourned. Okay, so I just wanted to make sure everybody knew that if you wanted to, there is an event this